Good morning, everyone. Welcome to Portfolio Committee Number 1, Premier and Finance, the inquiry into budget estimates 2024-2025. Firstly, I'd like to acknowledge the Gadigal people of the Eora Nation, the traditional custodians of the lands on which we are meeting today. I pay my respects to elders past and present and celebrate the diversity of Aboriginal peoples and their ongoing cultures and connections to the lands and waters of New South Wales. I also acknowledge and pay my respects to any Aboriginal and Torres Strait Islander people joining us here today. My name is Jeremy Buckingham and I am the chair of this committee. I welcome Premier Minns and accompanying officials to this hearing. Today the committee will examine the proposed expenditures for the portfolio of the Premier. I ask everyone in the room to please turn their mobile phones to silent. Parliamentary privilege applies to witnesses in relation to the evidence they give today. However, it does not apply to what witnesses say outside of this hearing. I urge witnesses to be careful about making comments to the media or to others after completing their evidence. In addition, the Legislative Council has adopted rules to provide procedural fairness for inquiry participants. I encourage committee members and witnesses to be mindful of these procedures. Welcome again to all our witnesses and thank you for making the time to be here today. All witnesses will be sworn prior to giving evidence. Premier, I remind you that you do not need to be sworn as you have already sworn an oath to your office as a Member of Parliament. For all other witnesses, could you please state your name and position title and swear either an oath or affirmation? And we'll start with you, Mr. Draper.
Thank you, Chair. I'm Simon Draper. I'm the Secretary of the Premier's Department. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much, Mr. Draper. Ms. Boyd.
Good morning, Chair. It's Catherine Boyd, the Secretary of the Cabinet Office. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much, Ms. Boyd. Today's hearing will be conducted from 9:15am to 5:30pm. We are joined by the Premier for the morning session from 9:15am to 1pm, with a 15-minute break at 11am. In the afternoon, we will hear from departmental witnesses from 2pm to 3:30pm. We will then have a 15-minute break before holding a session with witnesses from independent integrity agencies from 3:45pm to 5:30pm. During these sessions, there will be questions from the opposition and crossbench members only, and then 15 minutes allocated for government questions at 10:45am, 12:45pm and 5:15pm. We will now commence with questions from the opposition.
Good morning.
Mr. Tudorhope.
Good morning.
Good morning. Twice in 1 week.
Yes.
Indeed. Premier, when was the last time you met with Mike Burgess?
Mike Burgess, the head of ASIO.
Correct.
I couldn't give you a date, but we have regular meetings with security agencies.
You've had, I take it, a security briefing in relation to the issuing of tourist visas to refugees from Gaza.
No.
You've had no security briefing in relation to that?
Not directly with me, no.
Do you,
As the Cabinet Office?
No.
do you have any concerns that people coming to New South Wales from Gaza have rhetorically expressed support for Hamas?
I mean, I couldn't speak to it. I don't know whether they have or they haven't.
No, I'm asking about whether, if they do, would you have concerns about that?
Well, I have to see what was said, the circumstances, what as I think you've portrayed it as inflammatory or discriminatory rhetoric. There are tests that apply to people coming into Australia, but as you know, they're administered by the Commonwealth Government, not by New South Wales.
Well,
I'm going to finish my answer. And I suspect they haven't changed for a prolonged period of time. So I know anecdotally of people who've attempted to enter the country who've had their application denied on the grounds of character or previous utterances. I assume the same rules apply, but it'd be circumstance-based.
What have you checked?
Well, it's not my direct responsibility, no.
Well, they're coming to live in New South Wales.
Who is?
Refugees from Gaza coming here on tourist visas. And you've seen the media reporting in relation to that issue, have you not?
So are you saying that people are coming to Australia on tourist visas and then attempting to be permanent residents or staying here? Look, it's a matter for the Commonwealth Government. You have to raise it with them.
And it doesn't concern you at all if, in fact, those people coming to Australia from Gaza have expressed support for a terrorist organisation?
Well, I mean, I would say as a blanket rule that if somebody should be denied entry to Australia on character grounds, then that should take place. And there's well-established laws and precedents in place that are monitored and administered by the Commonwealth Government.
So-
no, I'm going to get my answer out.
Well, no,
I've
got limited
sorry.
time, Premier.
Order.
I don't care whether
Order,
you
Mr.
I'm
Tudor.
gonna take my time with my
Please
answer.
let the Premier finish.
And I
just
think at the
can't
end of the
just give
day, no, I'm going to
speeches.
continue the answer. At the end of the day, these established rules are in place. If you've got evidence, or you want to present it to me
Well,
as
the
the Premier
police
of
have
New South
expressed concern,
Wales,
have they not,
that
Premier?
the rules have been abridged, or there's an individual that shouldn't have been granted an entry visa, or there's circumstances
Well,
relating
that's a
to
cop-out
those.
because the police
I'm
have
going to
expressed
finish my answer.
concerns.
And if at the end of the day that has been presented to me by you to this committee, I'd have something to say about it. But they're properly administered by the Commonwealth Government, not by New South Wales. And I would expect, under all circumstances, if somebody has expressed support, admiration, incited violence or hatred or discrimination in Australia, of course they shouldn't be denied. They shouldn't be granted entry to Australia, whether it's on a tourist visa or a refugee visa or a permanent residency visa or any other category.
So, if the police have expressed concerns in relation to the visa process, would that be of concern to you?
They haven't expressed it directly to me. They may have done it through the security agencies, but I wouldn't be, and I'm not going to ventilate that right now in front of the committee. That's a matter between interagency dialogue. And
So you're not aware whether the police have expressed a concern?
they haven't
in
done it
relation to-
directly with me. They may have done it through the agencies.
Are
I have
you
to take
aware
it on
whether they've
notice.
done it through
I've just
another-
answered the question.
Are you aware whether they've done it through an agency?
I've just answered. I'm not aware of it. They haven't done it directly with me. They may have done it through agencies or with the Commonwealth Government, but I'd be reluctant to ventilate intelligence or security briefings between the New South Wales and the Commonwealth Government. I think it's important that those conversations, if at the discretion of the security agency or the law enforcement agency in New South Wales, if they make a decision to disclose it, well, that's a matter for them, but I'm not in a position to do that right now.
So I think where we've got to is you're not aware of any direct issues relating to people entering Australia on tourist visas. You're not aware of police concerns in relation to people coming into Australia on tourist visas as a quick manner of giving them express opportunities to come as refugees to Australia. So you're not aware of any issues relating to that, and you don't have a view, is it the case that people who
There's enormous supposition in this question, Mr.
just let
Chair,
me finish
and
my
at the end of the
question.
day,
Let me
you
finish
put
my
a
question,
of
Premier.
hypotheticals
Let me
of
finish.
none of which I've said.
Let me finish
I'm happy
my
to use
question.
my own words.
Let me finish
It
my
doesn't
question.
need to be summarised
Let me
by
finish
you.
my question.
Okay, but it started 5 minutes ago, and I just want to make it clear, I'm not agreeing to the premise of your question. I'll use my own words, and you can draw whatever you like out of it.
Are you concerned that families coming to New South Wales from Gaza on tourist visas as an express refugee process, that they are given opportunities to attend New South Wales schools?
Well, I mean, wouldn't jump the gun here. I mean, what is important here is that the Commonwealth has rules and provisions in place that prevent people from coming to Australia that have views that would divide the community.
But I'm not
And-
asking
I'm
about that. I
gonna
want to
finish-
make
sorry,
sure
Mr.
that
Chair,
I want
I'm
to
gonna
make sure
complete
that
my
they have
answer.
opportunities
I'm
to
going
go
to
to
answer in my
Order,
own way.
Mr.
and
Tudor,
I want to be in a
please
position
don't interrupt
to
the
be able to
witness.
do
Point
that.
of order.
So,
Point of order.
and I'm going to do that the whole hearing. I'm going to
Well,
take
I'm
my
gonna-
time
well,
with
I'm
my
gonna-
answers.
in
That's
that
not my
case-
problem,
that case-
unfortunately.
Order. A point of order has been taken by Mr. Nanva. Mr. Nanva.
Chair, procedural fairness resolution, paragraph 19 requires the witness to be treated with courtesy at all times. Interjecting before the Premier has been given a reasonable opportunity to answer the question is not extending courtesy.
Yeah, I totally agree. That is the resolution. Mr. Tudor, please do not interject while the witness is answering your question. We want to remain
Well, if he
civil
won't
and
interject
courteous
when I'm
all
asking
time.
the question.
So, Premier, you have the
So
floor.
look, I mean, there was a whole range of a major preamble where the honourable member suggested that I had agreed to a whole bunch of premises, of which I'm not. I'll use my own language in relation to this, and I think it's important to be precise. I would of course have concerns if people were coming to this country from anywhere in the world with a view to dividing our multi-ethnic, multiracial, multicultural community. I think that one of the successes of Australia's ability to live together has been a really strict test, particularly in relation to character. I expect that to be applied globally, and I expect it to be applied specifically to anybody that's requesting to come to this country from Gaza. If there are concerns about character grounds that have been exposed as a result of individuals attempting to come to this country, then I expect the Commonwealth Government to do their job. I would and know of many conversations that take place between the New South Wales Police and security and intelligence agencies at the Commonwealth level.
Well,
I'm not going to ventilate
Okay.
all of them here at this committee meeting.
Premier, let me move
But
on.
if at the
Let me
end of
move
the day,
on. Let me
if
move
at the
on.
end of the day, someone applies for citizenship, or if they apply for a tourist visa, or if they apply to come to the country for any application, it's a matter that's determined by the Commonwealth Government. There'd be input
Well, that's
from New South
that's a
Wales
cop out,
agencies,
but that's fine. That's fine.
There'd
Premier.
be
That's
input
fine.
from New South Wales agencies, but at the end of the day, that's the situation as it applied to the conflict in Gaza. It's a situation as it applied to the conflict in the Ukraine.
Okay, well, that's
it's
fine.
a situation as it's applied to those
This
fleeing
is a speech,
situations in relation
Chair.
to Russian aggression. I raise those
Well,
points.
if you can
I
give-
raise
you
those
can give
points
that- you
not
give
to
the
go
speech.
around
This
the
is not
world.
relevant to the question
The reason
I
I
asked.
raise it is because I think this is
Well,
germane
point of
to
order,
the inquiry,
point of order,
and
Chair.
that is these provisions were in place during
Point
the
of order, if you
previous
take it.
government's time.
Well, you
in
just
office.
can't
Premier-
allow the Premier to just answer that. This is not responsive to the question I was asking. This is just a speech that he is elected to give, and I admire you.
Sorry, Mr. Tudor, did you say that I can't allow him?
Well, I'm requesting. The point of order is that this is in relation to relevance of this answer, this speech to the question that I was asking.
But-
Well,
To the-
I-
to the
I'll
point of
order that.
order.
It was
Chair.
directly relevant to the
Directly
question.
relevant.
You asked a very broad question about
I asked him to agree with that
immigration
proposition.
and refugees.
And Mr. Chair, the
and it
the reason I was making it wasn't to grandstand about
It is
conflicts
to
around the world.
grandstand.
It was
It
to,
is to
It was
grandstand.
to specifically
It's
say.
to give a speech.
It was to
Order, Mr.
specifically
Tudor.
say that the rules haven't changed, that there's been global
Good,
conflicts
that's
that have, hang on a second, that have resulted in people applying for refugee or visitor status as a result of conflicts during this government's time in office and the previous government's time in office. That's certainly germane to the committee's inquiry.
I know you're not
surely.
across
if
the
you're
issue,
suggesting
Premier.
that's
I know
changed-
you're not across it. I know you're not across it. So that's fine. You give speeches when you're not across it. If you had an answer, you would have.
Point of order.
So I'll just ask the
Point
next.
of order's been taken. Mr. Nanva, on point of order.
Mr. Tudor Hope has just made a series of statements and reflections on the Premier. I would suggest that is not in accordance
clear.
with paragraph 19 of the Procedural Fairness
yeah,
Resolution
we're playing
regarding
ball.
courtesy.
Play the
That's
band,
okay.
not the ball. Play
Yeah,
the ball, not the
that
band.
is
if you-
true,
if you-
Mr.
if you
Tudor
need the
Hope.
protection-
If you would desist from editorialising
I'm not
on
attacking
the
you
editorialising.
personally. You're
questions.
attacking me personally.
No, no,
And
I don't
I'd
care,
remind you,
but-
Mr. Tudor Hope, that your time is ticking. So
So I just want to move
might
on
as
to the
well ask
McPhillamy
question.
gold mine. You're going to save the mine, are you, Premier?
Look, it's not. It's very difficult for me to save the mine, and the reasons
Well,
for
you've
that.
told the Tony Telegraph you're going to save the
It's
mine.
going to be a situation where
This is
there's
gonna
no
save the
opportunity
Save the
to
mine. We're
answer
going
a question.
to save the mine.
So it's not as simple as me saving the mine, and it's not possible for me to do that. And we've never said, Mr. Chair, that we could do that. The reason it's so complex and difficult is because the tailing, which is the subject of the Section 10 determination from the Commonwealth Government, has to be found elsewhere on the site. Now, we've been in discussions with, and the Secretary of the Premier's Department and the Minister for Mining has been in discussions with the proponent of the mine about an alternative tailing so that we could get the gold mine up and running. It's not straightforward. There's not an obvious site that can be picked by the owner-operator of the site. And as a result of that, anything we do on the New South Wales Government's end in terms of modifications to the development application or ensuring that there's enough resources to assess the development application can't be applied until they do the geotechnical and engineering works. Now, this is disappointing, and I've said, Mr Chair, I'm disappointed by the decision from the Commonwealth Government. The application was made in 2019. It's gone through the Independent Planning and Assessment Commission, as well as every other government department in New South Wales. And to be knocked over at the 11th hour is disappointing in terms of mining gold and other critical minerals in New South Wales, which we desperately need, because coal mining is under pressure, particularly when it comes to export markets.
Good. Well, and so the solution that you've identified to save this mine is to identify another tailing dam for.
We can't identify that. The company needs
to
to
work with the proponent of the application with a view to identifying an alternative site.
Well, if they can, yes.
If they can, and if they can't, the mine will fall over. Is that?
It may well.
Is that your understanding?
Yeah, it may well.
And
may well.
And you would be disappointed with that result, wouldn't you not?
Absolutely.
So is there another solution?
Yeah, I mean, the New South Wales government's processes, the 2019 application, again, I barely get an answer. The application goes in 2019. It's assessed by New South Wales government agencies. We believe the assessment was rigorous, and we were hopeful that that would stand up and not be subject to a reversal by a Section 10 application at the Commonwealth.
So you
level.
disagree?
I mean, I don't think I could be clearer.
Do you disagree with the reversal?
Absolutely, I've said that many times.
And in your view, Tanya Plibersek, using that power, she was in error?
Yes.
So.
Yes. I mean, this
Yeah,
was
no.
ventilated on radio yesterday.
So,
yes.
Premier, if she is in error, there is a disallowance motion before the Senate at the moment. Would you be encouraging New South Wales senators to vote in favour? These are the senators elected to represent New South Wales to vote in favour. Just let me finish the question, Premier. Would you be encouraging the New South Wales senators and picking up the phone to them?
No, I'm not going to pick up the phone. I'm answering. I'm not going to pick up the phone to senators. It's a matter for the Commonwealth Government. We're doing everything we can in the powers that we're responsible for to see if we can get an alternative view. I think I've been more forthcoming in relation to this issue and the position of the New South Wales government than any of my predecessors, and that included the previous government. My responsibility is New South Wales. I suspect it's inconvenient for you and the Liberal Party that we've been so direct and forceful about the planning application.
We want to
but no, I'm not going to pick up the phone to
the
senators.
Let him answer.
I think that would be fruitless, and at the end of the day, I wish that the New South Wales government decision and the New South Wales agencies and commissions' decisions stood.
Well, the Prime Minister appears to agree with you, does he not?
I haven't spoken to him personally.
Why haven't you?
Well, because the decision's been made.
It's in the interest of New South Wales to get this mine approved.
Look, can
Why
I just
haven't
say,
you picked up the
we
phone
haven't
to
heard
the
a
Prime
word
Minister?
from you until this has been on the front page of the newspaper for the last 3 days, and there's been extensive
Well, you
commentary
love it,
from
don't you?
me,
You love it. You're
the
gonna
Minister
save
for
it.
Mining,
You're gonna
the
save it,
Minister for
Premier. You're
Planning,
gonna
and
save it.
everybody else. You are late to this dinner party by a country mile, and at the last minute you're suggesting that we call
it had been
senators
approved
up
under
and
us,
have it
Premier.
Can I tell you, this application went in 2019. You have the world's slowest planning department.
But
it is
we
the
had
worst
not-
in the world.
and
most of the time and effort of
Premier.
the New South Wales government has been trying to fix up your mess.
Yeah, good on
so
you.
if you're trying to come to this
Good on
committee
you.
and say, if it would have happened under us, you had 4 years to do it and
Premier.
you did nothing.
Premier, you
I
sought-
get exercised about it. Planning has been a disaster under the Liberal government.
You sought a
Building,
headline.
construction, residential construction, housing, new homes for people,
you sought a
mining,
headline that you were
planning.
gonna save the
Everywhere
mine.
you look in New South Wales, planning was a disaster, and most of the time and effort of the Premier's department, the Minister for Planning, my cabinet has been fixing the mess that you left us.
Premier.
Would you
that's
acknowledge
fine.
that, though, by
So
the way?
you wanted the headline. You got the headline. Now what's the solution,
Everything I've said
Premier?
has been consistent with what's
Where's
been
the
reported.
substance, Premier? Where is the solution to this
Again,
issue?
I answered that at the very, very beginning. We're hopeful for an alternative tailing. Well, I mean, do you want the information or not?
Premier.
We're hopeful for an additional
Well, I gave you
tailing,
another
a change
solution.
to the tailing. It may not be that the owner, the proponent of the mine's able to do that. I don't know. I couldn't have been clearer. I couldn't have been more transparent. We've been very, very direct about the New South Wales government's view in relation to this mine, not for any reason other than we think that gold, critical minerals and mining is absolutely crucial for jobs and investment in regional New South Wales.
Well, let me ask you again, Premier. Are you aware of the process in relation to the disallowance motion which is...
Well, you've already asked that question.
No.
3 times.
I'm asking you, are you aware of the process?
You identified it to me in your question, which was
Are
that
you aware
that
of
the
the-
ministerial
Well, I've got it-
decisions are subject to a disallowance motion in either the Senate or the House.
Who is the leader of
Representatives.
government business in the Senate?
Point of order,
Look it
Chair.
up. I mean, I'm not here to
Point
be
of order.
dictionary, mate. Just do your own job here.
Point of order.
Point of order's been taken. Mr. Namber on a point of order.
Chair, questions need to be relevant to
Well, it
the
is
expenditure, for the estimated expenditure from the consolidated fund and related
you
budget
need-
payments.
You've only
I'd
asked
say even
questions
allowing
about
for
the
wide
Commonwealth
latitude,
Yeah.
we are
That-
moving
I'm-
beyond
Okay,
relevance.
I'm
Chair, to the
offering you
point
a
of order.
solution, Premier.
Mr.
Chair.
Tudorhope, order,
Well, writing
order,
on lease
order.
of it.
Where I'm ruling on, I'm listening to a point of order and then attempting to rule on it.
To the point of order, I think that the committee is potentially heading into bringing the committee into disrepute. We've got the leader of the opposition in the upper house actually encouraging the Premier to take potentially unlawful steps to interfere with a Commonwealth legal procedure to approve a mine. It's serious territory.
Well, I think that might be a long bow, but I think we've strayed beyond the
Well, yeah, it's been
expenditure
20,
in the area
20
of
minutes of
Premier, so
questions. There's $100 billion
Finance-
spent every year. There's 1,000 issues in New South Wales, and you've only asked about Commonwealth government issues. Surely there's something in New South Wales that
There are no
interests
coal
you.
royalties, no
I mean, for
mining
goodness
royalties.
sake.
Mining
You got a
royalties?
question about the New
Are
South
there
Wales
mining
government and what
royalties
we're
which would come
responsible
from
for?
this mine?
You'll be asking about nuclear subs in a minute. I mean,
are
honestly,
there-
is there something in New South Wales that you have an interest
Well,
in?
come on, Premier, this is below.
Order,
Come on.
order,
I don't think
order,
it is.
order, Premier.
Just
Mr.
go.
Tudorhope, can you ask a question? You've got 1 minute and 15 seconds, and rather than hector each other, can we have a question
Premier,
that we
if
can
in
all
fact,
hear?
If in fact the disallowance motion was not brought on for debate,
Oh, mate, I don't know. I don't know what happens
Well,
in the
I'm-
Senate.
I'm putting
I've got
this-
enough on my
Point of
plate
order.
in
I
this
am
chamber.
putting
with
this-
what
Point
we're
of
not
order,
understanding
point of
about.
order's been taken.
Chair,
Ms.
you've
Val.
just ruled around this being completely out of order for the budget estimates portfolio. I'd ask you to
I don't know. I don't know
encourage
what's happening in
Mr.
the Senate. I
Tudorhope.
don't know the
Premier,
Senate
To
procedural.
Premier,
I
please
don't
don't
think I'm
interrupt.
expected to know.
Premier, please.
Just answer
I'm
my
hearing a
questions
point
if
of order from Mr. Val.
I had concluded. Chair.
You had concluded. I didn't get to rule on the point of order previously, but I do uphold it. It's beyond the latitude, the remit, of this hearing and this inquiry. So, Mr. Tudorhope, please come
So
back to
it would be
expenditure in
your
New
view,
South Wales.
would it not, Premier? It would be your view that this is a wrong decision, and it would be a great outcome if the disallowance motion was upheld. Would it be your view?
Look, I don't know about the Senate's procedures. They'll have to make a call about it. New South Wales couldn't have
Would
been
that be a
clearer.
good outcome?
We're now in the process of trying
Would
to
it
work.
be a good
We're
outcome?
now in the process of trying to work out an alternate view that the New South Wales government is directly responsible
Well,
for.
it's
Now, that
$200 million
includes-
in
that
royalties.
includes-
You won't pick up the. You won't pick
Now
up the
this-
phone.
Order.
Pick up the
But
phone.
at the end
Order,
of the
Mr.
day, at
Tudorhope.
the end of the day, Mr. Chair, the government through the Premier's department is working with the proponent of the mine. We're looking for an alternative solution. I can't promise that today. I can't. But if there's a way through, of course, we'll be pursuing it.
Thank you, Premier. We'll now turn to questions from the crossbench, beginning with Mr. Borzak. Mr. Borzak.
Thank you, Chair. Thanks, Premier. Just on a completely different note and dealing with New South Wales. In June 2023, your government quickly recommended to the Governor that Kathleen Folbig be released from prison and given unconditional pardon. On the 24th of July this year, she submitted a claim for compensation. Can you tell me where is the government up to in consideration of Ms Folbig's entitlement to payment for her 20 years of wrongful imprisonment?
Is it okay, Mr. Borsak, if I ask Ms Boyd to answer that?
Sure.
Give some information.
Hi, Mr. Borzak. We understand the claim is being considered by the Department of Communities and Justice and that the attorney will be the minister responsible for considering that ex gratia claim for compensation, and that is underway.
So the government's actively considering it at the moment?
Yes.
Have you yourself seen the claim, Mr Premier?
I haven't.
You haven't? Okay. Well, would you consider having a look at it, if requested?
Yes,
I
of
think
course
this,
I would.
I think
yes.
this is very important because I caught up with her yesterday and she literally has no means of support. She does need to get some compensation, and I think they've asked twice to the DCS as late as the 24th of July for progress, and they're getting no response whatsoever.
Well, that seems eminently reasonable, and of course I'll do that. Find out where it's up to, and understand what the circumstances are that have resulted in a delay.
Thank you, thank you. Premier, just talking about hunting and pest management and control in New South Wales, and I know you've got a pretty detailed understanding of what goes on in this space. In 2022, the total gross economic contribution of cultural conservation hunting in New South Wales was calculated by the Department of Primary Industry at $508.9 million in gross state product, generating 4,109 full-time equivalent jobs. What's the value now? Do you know that? I haven't been able to get that yet.
I don't, but perhaps we could take that on notice. Would you know the economic value? But did you say $500 million?
$500 million, yeah. That was back in 22.
Yeah, well, that's a huge amount in terms of economic growth, primarily in the regions. And I know, having had discussions with you and your party, that using people, hunters, registered hunters in New South Wales forests and lands has resulted in a reduction in the amount of feral animals that's located in those places around New South Wales. It's probably been really good for regional economies as well. So I think it's a system that's been working well for decades now.
Yeah, it started in 2002 with legislation and started actual hunting in 2006. Premier, given that state forest land is available for conservation hunting, will you also make national parks and crown lands available for hunting?
We're not going to make national parks available for hunting. We've been really clear about that in the election campaign and in Parliament prior to that, in opposition. And I understand that might disappoint some hunters, but obviously we need to draw clear lines about where and how land use is used by hunters, and notwithstanding the safety that does go into other lands owned by the New South Wales government, I wouldn't be confident that we could protect or have the processes in place to ensure that those that were using national parks for reasons other than hunting felt safe and were in fact safe.
Thank you. Let's turn now to wild horse management in Kosciuszko National Park. Where are you up to, or your government up to, in relation to controlling wild horse numbers in the park? And what's the recent count of number of wild horses in the park? There's been a fair bit of toing and froing in relation to this stuff. And I think the program of culling has paused over winter.
Just
Might be an
getting
idea to tell
some
me
help
when you
with
think
the
it'll start as
numbers
well again.
here, Mr. Borsak. So I'm advised that the total horses removed under the plan between the 24th of November 2021 and the 2nd of August 2024 was 8,944. Aerial shooting accounted for 5,963 of those destroyed horses, and the rest were done, presumed by not the traditional way, the way preceding the change in policy that would allow aerial shooting. And I, toured Kosciuszko National Park with National Parks and the Minister, and saw the baiting program and the penning program, which involved luring horses into big pens and then destroying them or sending them to knackeries or other. But it's very distressing for the horse, and obviously prolonged suffering. So, the government made a decision in relation to it. We didn't feel that there was any other way of controlling the estimated number of wild horses in the park, and that, in fact, the number of wild horses would rapidly escalate if there wasn't a change in the policy.
Thank you. When do you think that another recount will be completed?
I don't know. I'll take that on notice and come back to you.
Okay. The legislation requires the numbers to be reduced to 3,000. How can the local communities be confident that that number will be maintained, reached and maintained? in the future?
Look, I hope that there's confidence in the team that's responsible for the culling. Part of the misconception, I'm not suggesting by this committee or by people that live in the community, but from some I've seen online and other passionate activists in relation to the destruction of the horses, is that this was the first time that the horses were reduced in number via shooting. The use of guns as part of the National Parks Plan and Management has been in place for a long time. It's just that the shooting would take place at grade, and the National Parks contractors or National Parks rangers that were responsible for shooting the horses had to have an embankment or a body behind the horse in order to have a safe shot, and as a result of that, it was very difficult on flat terrain to get the critical numbers that you'd need to reduce, in terms of sensitively, but in terms of the overall number. So the decision was made to do it from the air because the shot could go down and the shooter would be confident that it would be a safe use of the rifle, it would be a safe use of the gun. But we've been using guns and we've been killing wild horses in the park for many years.
Are you confident that and maybe you can't answer this question, but the firearms they're using, the calibers 308, etc., Winchester, are adequate, and that the animals are not being killed in a cruel and unnecessarily suffering way?
I'm very glib about guns and bullets. I just don't know what the caliber is, and what is that considered not lethal enough?
Oh, look, there's been quite a lot of discussion in the Animal Welfare Committee in relation to this and all around it, that's all. And I thought you may have had an opinion on it, but that's
yeah,
okay.
but I'm happy to find out whether there's been any suggestions that the horses have been suffering as a result.
Oh, well, I think that committee's pretty full on in relation to all of that. I think we've come to the end of that part of it.
Right.
Just turning to the New South Wales budget and the economy, being an old accountant, I'm always interested in seeing deficits, and I'd like to hear your views in relation to the net debt projected to exceed 130 billion in the forward period. How's the government going to manage all of this and stop it from increasing?
Yeah, well, with difficulty. The debt that the state is facing is massive, the largest figure ever recorded in New South Wales history. You've mentioned the net debt figure, the gross debt figure's on its way to $200 billion. Now, again, that's the largest ever recorded. We inherited the biggest debt figure handed from one government to another in the history of the state of New South Wales, both as an overall figure but also as a percentage of the economy. And the ability to pay it off or manage that debt, particularly with interest rates and inflation being at decade highs, is a big challenge for the government. For example, we spend more on interest on that debt than we do on the police and TAFE combined, over $6 billion last year. So the government did make difficult decisions in its first and second budget. They were criticised by the opposition and by stakeholders in the community, but we felt that they were necessary primarily because we've got to be in a situation where we have a plan as it relates to that debt, and also in recognition of the fact that we aren't in a COVID emergency anymore.
Premier, I've only got a
Sure,
couple
sorry.
of seconds left. Sure. Just how do you think this will affect our credit rating in the future?
Yeah, well, we've already lost one of the credit rating agencies' AAA
Will we lose
metrics, and I can't speak to the credit rating agencies or their decision in relation to it, but they may make a decision either based on the change in terminology for sub-national governments' debts, the amount of debt that they have in comparison to their economy. But one left New South Wales in 2022, I think, and as a result of the size of the debt, there's no question it'd be under pressure.
Thank you, Premier. Premier, Glencore, they're one of the largest miners in this state. Have you ever met with them?
Not to my knowledge, but I may have. I'd have to check my diary, but I don't recall a meeting.
Do you have any concerns that they may or may not be a good corporate citizen? Do you think that they're a good corporate operator?
Well, I don't have any evidence to suggest that they're not. I know a lot of people don't like coal mining or coal mining companies, but it is the state's single largest export, $45 billion just last year, and companies like Glencore and others are responsible for a lot of that export growth and particularly regional jobs. So I'd meet with them. I'm not suggesting I wouldn't, but I've said repeatedly that coal mining and coal export as a percentage of the economy is under pressure, not primarily because the buyers of that coal have said and stated repeatedly that they're getting out of that business in the years ahead.
Premier, you've just said that you've received no evidence that they're not a good corporate citizen. I'll put this to you. In the UK, Glencore's former head of oil trading has been charged with corruption. He will face court alongside 4 other execs on 10 September 2024. Also, this month in Switzerland, the Swiss Attorney General held Glencore International criminally liable for failing to have taken all necessary and reasonable organisation measures to prevent bribery. Also, 2 years ago in the United States, Glencore pleaded guilty to foreign bribery and agreed to pay $1.1 billion, the biggest fine ever given in a US foreign bribery and market manipulation settlement. Bribery was built into the corporate culture, Manhattan US Attorney Damon Williams said, and 2 years ago in the UK, Glencore Energy UK pleaded guilty to 7 counts of bribery. Justice Fraser held that these counts in the aggregate represent corporate corruption on a widespread scale. Hearing that, do you think that Glencore are a good corporate operator in New South Wales?
Well, look, I mean, a global company, I assume they've got thousands of employees. It's not my job to come here and defend the historical record of a company or a corporation like Glencore. I mean, if there's evidence about any problems, improprieties, malfeasance in New South Wales, of course, we take that seriously. But, you know, we've got really rigorous processes in place in New South Wales for mine assessment. We've got very strict rules in place when it comes to the assessment of potential mines. Everything from, we've been discussing it for most of the morning, the Independent Planning and Assessment Commission, the Mine Safety Board, the union movement is responsible for ensuring safety and health on mining sites. So I can't speak for how a company like that or their personnel operate in a jurisdiction like New York or in places in Europe, but I do have confidence that we've got rigorous processes in New South Wales. And as we've seen, do you think
they should be a consideration in those processes?
Look, I've only been presented with the evidence that you've given me now. I haven't had a chance to independently look at it. What I would say, generally speaking,
is to have a look at, like, we're talking about the biggest. I'll look
at anything that you want to give me, but I would say that these are global, international firms, resource firms. Generally speaking, we would apply. We would look at it as we see it, and if company comes to New South Wales and goes through our very rigorous, independent, both assessment processes for mines, but also very strict integrity agencies in New South Wales, and I've got confidence in those regimes to police everybody, anyone who comes into the state.
You'd be aware that Glencore have a proposal before the Department of Planning at the moment for the largest coal mine expansion in New South Wales history. And that the community, lots of community groups, I'd like to just table this as a petition of community groups, New South Wales Coal Watch, Lock the Gate, and residents who are, there's a table there, who are concerned about it. Their principal concern, and it relates to what you just said, is that over the 12 years of the coalition government, the merits appeals process for these major projects, and in particular major coal mines, was removed from the community through the Independent Planning Commission and the public hearing process. Would you commit to ensure that these massive coal mine projects that have implications for the local community and for climate, that the merits appeals process in that planning process is restored?
Well, I can't commit to that specifically today, although all of the policy issues around mines, mine extensions, and how it operates in New South Wales are hotly contested, and obviously the New South Wales government's looking at the approval process and the role of coal in the New South Wales economy in the years ahead. In fact, the minister responsible is in the midst of rewriting the coal statement for New South Wales. We've made that clear to the IPC. We've made that clear to proponents of coal mines in New South Wales. The existing regime, the Barilaro statement, will be replaced by the incoming government's view.
When will that happen?
They're in the process of working on it now. I have to take it on notice when it would be released.
Okay.
But, you know, I've said this quite a few times, Chair, and I think it's important. All of coal's our single biggest export, and 1/3 of it goes to a single market, which is Japan. Now, that's putting aside the very significant, and I accept, you know, community concern about the impact on the planet. That is a very concentrated export market for the prosperity of the people in New South Wales. Our single biggest export going to one particular market, particularly when you take into consideration the volatility of technology and changes to global patterns of energy consumption. It's a risk for the New South Wales economy in the future, being so reliant on a single piece of export-led resource. One of the reasons why we're not trying to be antagonistic to the Commonwealth Government or anybody else when it comes to the gold mine. I know you're not asking about that directly, but these are pieces of a jigsaw puzzle that do go together. We've got critical minerals and gold in the ground in New South Wales, and if over time, as everybody expects, even the most passionate proponent of coal, that the percentage that we export will drop, we want it replaced with other sources of minerals, exploration, export, and opportunities, and job opportunities. So that's why we're passionate about the gold mine, other resource-led opportunities, other critical minerals in the ground, and we want to get the planning system right and have a set of rules in place to attract capital to that part of the economy, which is massively underdone at the moment.
The Mayor of Muswellbrook, Steve Reynolds, is a proponent of bringing into his region as a transition out of coal mining the medicinal cannabis industry. In the US, the cannabis industry is worth $35 billion and growing at double digits. It employs 500,000 people. There's support for it in the Upper Hunter community as a transition industry. It's got a huge profile. It will be worth hundreds of billions in the coming decades. Do you think that that's an opportunity that the New South Wales government should be considering if it's looking to create new industries and new opportunities for export?
Well, I don't know about export, but I know that there are. Well, I didn't know this off the top of my head, but I took the liberty of looking at the size of the medical cannabis industry in New South Wales. There's 44 companies that are currently in the process, sprinkled up the New South Wales North Coast and in other parts of the state. The government, over successive governments, this might be of interest or news to Mr Tudor, but the previous government, I've got to give credit where it's due, invested money in the cannabis industry. Did you know that?
I did.
Well, there you go. And as a result of that, we've seen some companies being able to fill the marketplace for medicinal cannabis in the community. I was surprised to see that the number of New South Wales residents that have access to a prescription and therefore access to medicinal cannabis is over 300,000 now in the state, probably a lot higher than that. And the companies that are currently regulated under a national regulation and are in operation in New South Wales under licences, strictly regulated as everyone would expect, don't fill that full marketplace. And I think there's a lot of Canadian medicinal cannabis coming into the country. I'd be interested to know, I'm not saying you would know personally, Mr Chair, but what's the quality of that is and whether Australian medicinal cannabis would be of a better quality.
Australian medicinal cannabis is of very high quality and it is an export opportunity. Some of the companies are exporting to Germany, a big flourishing market. Some other companies like Canada don't allow it. Is that something the government would be interested in assisting those companies do, is access foreign markets?
Well, I'd probably say in the first place, given there's a deficit in terms of Australian firms meeting the domestic market for medicinal cannabis, that's where we would begin. If it's a better quality, it would give a lot of people more medicinal benefit as a result of having Australian grown, made access to it. That's probably where we would start, but I'd take the other part of it on notice.
Thank you very much. We now return to questions from the opposition.
Premier, I'll just preface the questions I'm about to ask you by saying that the opposition is not opposed to additional housing, and we support your initiatives in relation to the delivery of housing. It's the processes we have some concern about. And Premier, I want to take you to the process surrounding Rosehill. You told us at the last budget estimates that Steve McMahon is a friend of yours and has been for many years. That's correct, isn't it?
Yes, he is.
How many years would you say?
I couldn't tell you, but probably more than 20 years.
And if I could ask you about the timeline in relation to the development of discussions around Rosehill, and you may or may not know this, but accept it from me that this is a timeline created from documents which have been produced to the Legislative Council pursuant to an order under Standing Order 52. So on the 14th of August 2023, Mr McMahon and the ATC had a meeting with the Independent Metro Audit Review Committee, and there was no discussion at that meeting about housing on the Rosehill racecourse, but there were other discussions in relation to the delivery of the Metro. On the 25th of October 23, Mr McMahon had a meeting with the Planning Secretary, and at that meeting there were no plans for the development of Rosehill. On the 26th of October, however, Mr McMahon briefed Mr McGorran and the CEO of a concept to sell Rosehill. Then on the 27th of October, Mr McMahon requested a meeting with you. That meeting then occurred on the 30th. So he requested a meeting on the 27th, a Friday, and was granted that meeting on the Monday. And it was recorded in your diary as a meet and greet with the ATC. Is that how you would recall it happening?
I don't know. I'd have to check my diary.
Well, I can give you a copy of your diary if you like, but that's how it's recorded. It is recorded as a meet and greet.
Right.
So Mr McMahon has access to you with a request on a Friday, and he's granted a meeting with you on the Monday. Is that a process which is available to most people in the community?
Well, normally I'm getting hammered for not having meetings or being too slow.
No.
I remember we would do these estimate meetings and it would be, you haven't met anyone in weeks and you haven't replied to a phone call.
So I take it that that's a no. It's not not easy to get a meeting with you. So
I
it would
don't
be
know.
unusual.
I mean, he's I couldn't recall the circumstances that related to us having the meeting. It might have been there was a gap in the diary. It might have been he's a senior person in a big stakeholder group in the state and we didn't have anything on. It might have been, I don't know.
You may not.
It was last year, but it wouldn't be unusual.
You've just told us it's pretty hard to get a meeting with you.
No, I didn't. I think I'm here for 4 hours. It's not hard to question me. But no, I don't think it's unusual. No, I mean I would meet. Hang on, I'm going to finish it. I would meet senior executives from big stakeholders in the state, particularly big landholders, routinely. Whether it was I can't even name it. There'd be 1,000 different groups.
But it was Mr. McMahon who requested the meeting. His name wasn't recorded in the diary as the person having the meeting. It was a meet and greet with the ATC. So a meet and greet meeting had no urgency attached to it. However, the meeting occurred with a mate of yours, requested on a Friday, and the meeting occurs on the Monday. Isn't that right?
Well, I mean, a couple of things, because I don't want anyone to be left with the impression that, you know, yes, he was a friend of mine, and is a friend of mine, but also he had that position maybe a decade before the New South Wales government was elected in March of 2023. It's a senior position within the ATC, and it wouldn't be unusual for me to meet either him or the person in his equivalent position in any one of many other government agencies that I would meet, run into, talk to, under any circumstances.
Yep. But he certainly didn't go to the back of the queue, did he? He was
Oh,
your
look,
mate. He was your
I
mate.
think it's a semantic position. He wanted a meeting. I would meet with many different groups.
So he
all
told
the
you.
time.
So he told you about the proposal at that meeting.
I think so, but
Yep.
I mean, it would have been around that time.
Yeah. So he told you about the proposal, and you backed it in, didn't you?
Well, I think that he suggested that this was an option for the ATC. The view was, we're not going to go on with it because obviously it could upset members of the ATC, whether they were particularly attendees at Rosehill or others, if at the end of the day the New South Wales government, like meaning me, didn't want to go ahead with it. So it didn't seem to me to be unreasonable of, well, look, at first blush, is this something that you'd oppose rather than support? We recognise, I mean, without knowing the specifics of all of the thousands of gates that would have to be jumped through for a proposal like this to get up, my view would have been absolutely, I'm not against it. Whether we're for it or not depends on what it looks like.
Well, and a month later, of course, you were making a big public announcement at Rosehill Racecourse, were you not? This was an exciting, once-in-a-generation opportunity that the New South Wales government was embracing.
Well, the reason for that, and you know, this is the preface on any question in relation to Rosehill or the ATC, is that it's going to be up to the members to decide. And I think we all felt that we would be damned if we did and damned if we didn't. And if it stayed inside government and it was a secret discussion between the ATC and the New South Wales government, and then eventually it leaked because it's a big organisation, both organisations are big, the government's big and the ATC's big, notwithstanding confidentiality that would be signed, then there'd be a sense from the racing community and perhaps others that they weren't in the loop, that they didn't know about it.
Well, let me
Hang on. So the reason we made an announcement about it was to be transparent. And I do remember that press conference, and I remember saying very specifically that there'd be a lot of work to do between now and then. Environmental approvals, regulatory approvals, processes through the New South Wales government, eventual planning and rezoning changes if it got ahead, but most fundamentally and most importantly, a vote of ATC members. It would have been within the remit of our government and the previous government to compulsorily acquire Rosehill and put housing on it. But we weren't going to do that. And this was always in the remit and the decision of the members of the ATC.
You could have done.
And still is.
Yeah. Well, you could have had that at the discussion on the 30th of October. You could have said to Mr. McMahon and Mr. McGoran, you go away and get the approval of your members to do that and come back and see us when you've got that approval.
Yeah, I mean, I suspect
that would have been a
going
better way to do it.
Going back to your preamble, that supposedly you're in favour of this. My suspicion is that your procedural opposition to aspects of this is politically motivated. As an opportunity for the
Premier.
opposition
It's
to hit
about
us.
probity, Premier.
Oh, well, I know
It's
you'll
about probity.
always
Order.
claim that.
Order.
But
Order.
let's hypothetically look at the position that you've suggested to the government.
Correct.
Either they go away and have a vote, or alternatively, I know you haven't suggested this, that it remains confidential and that there's no public announcement in relation to it. Whichever way it was decided, whether it was a compulsory acquisition, whether it was an ATC members vote, whether it remained confidential and wasn't revealed to the public and ATC members, there would have been a line of criticism for you or for political opponents for it to take. And I mean,
that's an
Mr.
outrageous
Latham's
proposal.
here. I acknowledge that at least Mr. Latham's against the proposal, doesn't want it to go ahead. We can't work out what your view is.
No, I've told you. If there
Well,
is
what is
the proper process, Premier,
Oh,
I
right.
will support this.
But you haven't been able to establish that there isn't a proper
Well,
process.
did you offer a railway station to as a condition of the proposal? Because that was what they wanted, wasn't it?
Nothing was offered. Nothing was offered.
Well, but it
I
was
mean,
only a
what was
viable
on the table
proposition.
was this is ultimately how you try to get an outcome for Sydney. There's got to be a process in place. It has to be handled by the Cabinet Office. It was the best process to take wasn't for us to just go and grab the land, steal it from the members of the ATC. It was for them, in a very complicated process, to have a vote in relation to it and almost at the same time go through an unsolicited proposal to government. That's very complex, not an easy thing to do. And you might say it wasn't perfect or it was bad or raise a whole bunch of innuendo, but any of the ways we would have pursued it, I suspect, would have been met with opposition. And, you know, if the opposition to the proposal is, we love Rosehill, we don't want to sell it, we think it should remain a horse track, I'll accept that. I think that's fair enough. I think that there's an option to do something else with it. But if the opposition is to, well, you shouldn't have had this meeting or you didn't have this meeting or raise a whole bunch of innuendo on the basis of no facts or no evidence, I think you're copping out and you should just say whether you support it or not.
Premier, you're copping out in my view, but in one sense you were seeking to avoid the proper process.
No, absolutely not.
You became the cheerleader for an unsolicited proposal, which is exactly
Well, what
the
would you have
antithesis
preferred? We just came in and
of-
grabbed the
gotta
land.
follow
If
the
we'd done
process.
that, I mean,
I
this
put
is
to
a
you-
relevant
I
point,
put to you
Mr.
a
Chair. If
proposal.
we'd gone in there and said the proper proposal, as identified perhaps by the opposition, is just to grab the land,
No,
to execute a compulsory acquisition, to take it over by the New South Wales government, to put housing on it, to put a metro station on it, and to sideline the members of the ATC. What everybody did in relation to this proposal is to say, let's present a proposal to the members of the ATC, let's let them make up their mind, and there might be a win-win across the board. Now, you can allege that that's improper or not correct procedure, but you're not providing any evidence as to why
No,
that would have
but-
been the
Premier,
case.
but if you're waiting for the members of the ATC, as you say, how come at the farmers' conference out at Rosehill this year you told them they'd have to find a new venue next year?
Yeah, I mean, I think that Mr. Saunders cracked exactly the same joke.
I'm
Prior to
asking you the
mine.
question.
But isn't that relevant?
Well, the question is,
I
if
don't
you're
think
waiting
that-
for a
I don't
process,
think that
why
the
did you tell
ATC
people that the conference wouldn't be there next year?
The conference, if they choose to have the conference at the ATC in Rosehill, will definitely go ahead.
So are you making a joke when you said that, or
Well, I don't think many people laughed,
no?
but yes, I was
It
trying.
wasn't very funny.
No, I wasn't very funny, but that was the. I mean, I guess this goes to my point. I crack an unfunny joke at the Farmers Federation, and you guys want to have a royal commission into it and allege that there's a conspiracy. I mean, honestly, what's
So
what's your
who's
position
follow a
in
proper
relation to
process
it?
for an unsolicited
Who was
proposal,
suggesting
Premier?
that there would be 25,000 units on the site? Who made that suggestion?
I
Or
haven't.
residents?
No, I haven't made that suggestion. I mean,
Well, no, you did with respect, Premier.
I suspect that the point, the policy point here is important, and that is that there was, my understanding is, under the previous government, a proposal to have between 3,000 and 5,000 apartments around the periphery of the track. And maybe more housing at Camellia, which is adjacent to
Yes.
the metro line, but you'd keep the track in place. The point about density is that it would the benefit for the government and the benefit for the state in a housing crisis is that it wouldn't just be 3,000, it would be substantially more than that, and maybe approaching 25,000. But I suspect the land economists and those who are proposing the potential sale and presenting that to the members will have to make a decision about what
Well, it
what
was
and how many.
contained in your press release, wasn't it? That it was up to 25,000.
I'd have to look at it, but substantially more than 3,000. And the reason for that was really straightforward, and that was because I didn't want the people in New South Wales to believe that we wanted to be upfront about it. This would mean more density on the site. This wouldn't just be a gigantic park, which some people have proposed, just closing down the racetrack and turning it into a public park, that there would be housing on the site. We wanted to be transparent about that, and there would be significant density on the site.
Well, see, Premier, it was open to you to at least say to Mr. McMahon, go away and get the approval. We're not interested in this proposal unless you can guarantee to me that your members will back this.
Yeah, well, we had to do it in a
but you
concurrent-
didn't, did you? You
We had to
didn't
do
that
it.
process.
We believed,
But
and I
the-
think this was the fairest way in terms of transparency for members of the ATC and the public. We had to do it in a concurrent.
But it would have been a
process.
better way to do it.
Why
would
is
have been
that?
a better way to do it and say, we're not interested unless
But
you...
why? Why?
Because you're going through a process now, Premier, where you don't even know whether the members are backing it in.
But that's fine.
But isn't that... Well, you're
That's
spending
fine, isn't
a
it?
truckload
is
of
it-
money...
We're not spending a truckload of money.
Well,
Look,
how are you-
ultimately,
how are you
land use,
assessing-
land
how are
use
you
changes.
assessing-
Order,
How are you
order,
assessing it,
order,
honestly?
order, Mr. Tudorhope. You've asked a series
you
of
assessing it?
questions.
This is why nothing got done in Sydney
and,
for a decade, by the way.
The Premier is attempting to answer, so please.
It's true.
wait
I mean, is it not
for
true?
The Premier.
Mr.
Premier.
Chair, this is
Calm
right.
down.
Nothing
Did
got
you
done.
go
open the metro?
No
Calm down.
housing got done for 12 years in New South Wales.
Order.
Point of order.
Did
Order.
you just open the metro?
No, I don't need to hear a report order. I need Mr. Tudorhope to be quiet while I bring the meeting to order. You've asked about 5 questions in a row, some of them hypothetical, Mr. Tudorhope. Wait for the Premier to answer, please, and
Well, I make this
return
point. I
some
make this point, Mr.
decorum
Chair.
to the committee.
I make the point, Mr. Chair, that this is why no housing got done in New South Wales for 12 years. You know, if you go through the planning system at the moment and you try and get in a schematic, the amount of hoops that private capital has to go through to build a home in Australia's largest and most expensive city, it would blow your mind. There's about 1,000 different routes that a proponent of a policy has to go through, and now I know why, Mr.
Your
Chair.
mate gets a meeting in 3 days.
It's not a
Now I know why. Because these guys are
Really not
obsessed about slowing down the process and
No,
making
Premier,
it
we
impossible
want
to
a
build
pro- we
any
want a
houses.
proper
Now,
process,
at the end of the
but
day,
that
Mr.
doesn't
Chair,
matter to
no,
you.
I'm going to
Love
finish
you,
this.
mate.
Order.
This is very
It's fine if
important.
it doesn't matter
we
to you.
aren't going to usurp the rights of members of the ATC. We're not. We are not going in there to grab the land from them. We're not
No,
taking their right to
but
wait.
if your mate wants
Honestly,
it, your mate
point of
wants it,
order.
doesn't he?
You get a
Your
meeting in
mate.
3 days.
Well,
if
what are
you're
you
a friend.
implying?
Your mate wants it, doesn't he?
What's the
your mate had a
implication?
meeting with you, and
Sorry,
this was
point
his
of order,
idea.
3
Chair.
days.
Your
Order.
mate.
A point of order has been taken. Mr. Namber on a point of order.
Mr. Tudorhope is just making a series of adverse reflections on a third party who's not even here. I would just ask that he treats the witness with a little more courtesy and allows a more fulsome answer than what he's allowing the Premier to provide.
Yeah, I uphold the point of order.
Well,
Mr.
I mean, that's a point, isn't it? He's not here to defend himself, so it's a good opportunity
It's
for
good-
you to
you can-
slur him. And I just make the point that we are not taking the rights away from ATC members. The reason
thing might
we've embarked on this process, this unsolicited proposal from the ATC and a member vote of ATC members, is to give them their democratic right over the land as members that they own. Now, I know it'd be far more convenient for the Liberal Party to suggest that we were going to take it from them, that we were going to grab that land, that we're going to build housing on it, but we're not. This will be up to members of the ATC. And if in the end they decide that they don't want to go ahead with it, we won't go ahead with it.
So it's dead in the water, really, isn't it?
Well, I mean, it's up to members
Well,
of the ATC.
you've seen the reaction of the members of the ATC, haven't you?
Well, would you be happy about that if
Well,
it went down?
are you going to delay the metro pending the unsolicited proposal outcome and then the consideration by the members?
No.
So the metro is proceed. So you'll have to retrofit the station if, in fact, that's the decision which arises out of the unsolicited proposal, which was really a solicited proposal, wasn't it?
There's
about
you
four
asked
questions
them.
in there.
You
There
asked
was,
them.
Mr. Tudorhope,
He's gonna
like
answer it.
there were a series of quite distinct and diverse questions
Well, I
there.
think he's
So
answered.
please, to assist
The Premier's answered.
the committee inquiry, just do one at a time.
Yeah, no, it won't be delayed. We hope it's open at 2032. It's a massive logistical undertaking. It's the largest public transport project in Australia. It's very expensive too. When the government was elected in 2023, the publicly stated cost was 16 billion. The real cost, which the previous government and you as the finance minister knew, was in fact 24 billion, but none of that was presented to the
Well, the
public.
ETU didn't help, did
And
it?
at the end of it, so they added $10 billion to that.
Well, the delays in
Oh,
these
10
projects
billion,
caused
okay.
by your mates in the union movement.
Far out. No wonder. This is a
Is that
shocker.
right?
Anyway, Mr. Chair, I just say this. The project jumped from 16 billion to 24 billion at least. We saw the process on the Northwest Metro line and the Sydney Metro line, which undeniably is a wonderful piece of infrastructure. And I
Oh.
think I think I've appropriately given credit, particularly to the former Premier Gladys Berejiklian in relation to that.
And the North Connects and the West Connects.
I think my argument in opposition during the election campaign and after the election campaign was these are hugely expensive public transport projects. They're going to put the state into significant debt, and that debt will have to be paid off by future generations of taxpayers. What we need to do, particularly to give Western suburbs families a break from rapid greenfield development, is to have more infield development alongside or on top of that brand new public transport infrastructure. Now, this proposal, this Rosehill proposal, as put to the government by the ATC, is completely consistent with what we said in the election campaign and what we've been pursuing nearly every day since. But if ATC members don't want to go ahead with it, Mr. Chair, we won't go ahead with it. I mean, as I said, I think it's an exciting opportunity for the city. There's many other people that don't want to go ahead with it. I know that Mr. Latham's against it and other trainers on the track. At least everybody's got a position in relation to this project, except for you.
Thank you, Premier.
You're embarrassing.
Order,
The
Mr.
process
Tudor.
is embarrassing.
We'll now turn to questions from Mr. Latham.
Yeah, thanks, Premier, for your attendance today, and good morning. Do you recall 2 years ago writing in the Sydney Morning Herald that integrity is not only a noun, it's a verb, it's not an outcome you reach, it's a continuous and relentless determination to place integrity at the heart of all your decisions and actions?
I'm sure I did write something like that, yes.
Yeah, can I raise with you a serious integrity problem at Racing New South Wales reflected in a transcript that I'd asked to be circulated in full, if the Premier could have a copy and other members of the committee, and I'll later seek to table it.
Why don't you table it now?
Well, I'll table it now, Chair. If I can take you to that transcript, Premier, this is a case in 2021 where the CEO of Racing New South Wales, Mr Volandy, sought to ban Colleen Walker from the Mudgee Race Club because she'd had a disagreement with his friend John Camilleri's daughter, who Mr Volandy's had hired at Racing New South Wales. You'll see from this transcript, particularly on page 3, that Mr Volandy set up the inquiry, appointed the stewards, headed by his chief steward Mark Van Gestel, and even though Mr Volandy's didn't attend the inquiry and hear any of the evidence, the stewards had to go to Mr Volandy's to determine the final outcome of the inquiry. This is clear interference by the CEO, isn't it, in what should have been an impartial, independent inquiry?
Oh, look,
Point of order, Chair.
I couldn't possibly.
A point of order has been taken. Mr. Nandra on a point of order.
Chair, the procedural fairness resolution it's pretty clear that where there's a question that might anticipate evidence that might adversely affect a third or reflect on a third party, that they are not in order in accordance with paragraph 13 of the procedural fairness resolution. I'd suggest that this question is seeking to elicit evidence that might adversely reflect on an individual who's not here.
To the point of order.
To the point of order.
To the point of order, with respect, that's not part of the procedural fairness resolution. Members should proceed with caution when they are referring to third parties, and there needs to be an opportunity for a third party to then respond at some point, but my understanding is they're free to ask.
Evidence that might be anticipated that might adversely reflect on a third party would normally be heard in camera, and you can't do that at budget estimate sessions, which is why the procedural fairness resolution I would have thought is fairly clear.
I'm going to a matter supported by a document, and the matter is clear and the evidence is clear, and the Premier, who set a high standard for integrity, should answer the question.
Absolutely.
Yeah, I won't uphold the point of order. The document is before us, and but I would remind Mr Latham to proceed as with the procedural fairness resolution with caution, as the third parties you are mentioning aren't here and don't have an opportunity to defend themselves.
Well, I mean, Mr Chair, there's a whole bunch of suppositions in the question asked by Mr Latham that are presented as fact that I've got no basis of validating. He said that the person who was the subject of the inquiry was a dear friend or a close friend of
No,
Mr.
I didn't say
Volandy.
that. I said Mr Volandy's was acting on behalf of his friend John Camilleri's
Yeah, well, I don't
daughter.
know that to be true. I don't know the circumstances in relation
that's not material
to it.
to the
Well,
interference.
why did you say it then?
Well, I gave you the background, so you
Okay,
can
right. Well,
understand
I
it.
don't know whether what you're saying is true, can be validated. I've got
Well,
no
I can
idea.
assure you it is.
But at the end, no, that's probably not good enough, Mr. Latham, that your assurance in this committee. Secondly, the second supposition that was presented as fact is that the Chief Steward didn't make a decision. I don't know that to be the case.
Okay, well,
What
can
evidence
I take
have
you
you
to
got?
the document? Can I take you to the
Sure.
transcript that's in front of you on page 3, where the Chief Steward says...
Oh, and the other
that's how it
supposition
would
is that you
work,
said that
yes.
it was payback. Is that right?
No, I didn't say that at all. That's how it would work, yes. We will consider the evidence, make any recommendations
Sorry,
that we
Mr.
think
Latham, where are you referring to?
On
for
page
us
3,
playing?
towards the bottom of page 3 of the document, the Chief Steward says very clearly, that's how it would work, yes. We will consider the evidence, make any recommendations that we think are appropriate, and then Mr. Volandis will consider as to whether or not he agrees with those recommendations. Now, in a situation where Mr. Volandis hasn't been present at the
Yeah, I think
inquiry,
you had an
hasn't heard
opportunity
Can
to
I
present.
finish my question? You always ask to finish your answer. Where he hasn't been present at the inquiry or heard any of the evidence, and several current and former stewards of Racing New South Wales
Who were
have come
they?
forward to say that these things happen all the time under Mr. Volandis. Will you now inquire?
So there's a
into
few,
the
again,
serious breach of
suppositions presented
integrity?
as facts, Mr. Chair. This happens all the time,
Yeah,
apparently, and
I-
a whole
I-
bunch of witnesses that haven't been presented to me and haven't been presented to the committee as presenting factual evidence as to a third party who's not here to defend himself. I just make the point, obviously this should go to the Minister for Racing. You had an opportunity to question Mr. Volandis a couple of weeks ago. I'm curious as to why none of this information was presented then, and I'm worried that might be an opportunity to slander him without the ability
well,
for
I
him
do
to
my
defend
work
himself.
according to my
Because
timetable.
you are subject to parliamentary privilege at the moment in here, aren't you?
Order.
Well, are you a hero
order,
to go out
Mr.
there when you've got $1 million defamation delegation from Racing New South
order,
Oh, mate, you're in the midst of a big
Yeah,
defamation.
Order,
you're
Mr.
under it
Latham.
too. You're under it too.
Order, Mr. Latham.
Well, it's not a valid point to make, is it?
Order.
That's why we're in
Or,
Parliament.
Mr. Latham, I call you to order for the first time.
Well, Mr. Chair, he's loading up a whole bunch of questions with supposed facts
He is, and
that,
I've
that
called
no
him
one
to
can
order,
validate.
And
And
I've
you don't get
warned
a
him-
chance to look
Thank
at
you,
until
Mr.
the
President.
committee meeting's completed and you
Order.
look at the hearing or the transcript.
Premier,
I mean,
I call
if
you
you've
to
got a
order for
question,
the, Premier, I call you to order for the first time.
Yes, but we can't throw him out. We need him.
Yeah, throw me out. Throw me out.
That's
I'll
the
get
You're
out.
an early mark.
What do I do to
Badly
get kicked
get
out of here?
free.
Mate,
Get hunted.
he's the first Premier at budget estimate to be called to order. There you are.
Good.
So,
There you
Mr.
Do better.
Mr. Borzak, your questions, please.
Can I get called to order too?
You will, probably.
Premier, just in relation to Powerhouse Museum, will your Powerhouse Ultimo project meet its actual projected cost?
The money set aside for the rebuild of the existing powerhouse at Ultimo, I haven't heard to the contrary. I think it's a couple of $100 million. It's quite a substantial remediation project at Ultimo, but I could take advice on it and come back.
Well, that was going to be my next question. Do you know what a final figure is? Because in these projects, they just, as you can appreciate, keep escalating. No one really knows where we're at in terms of what the current figure might be.
Well, I think that's true. The revitalisation project is $300 million at Ultimo. Huge sum of money, but necessary. It's an important piece of cultural infrastructure for the state. That's $250 million from New South Wales taxpayers and $50 million in philanthropic capital from donations. So, we would expect it to be on time and on budget. This is a perennial problem across the government. We've been left with a whole bunch of infrastructure projects that have wildly blown out, and there's opportunity costs that come with it. But we recognise that we've got to manage these things very closely.
Can you tell me? Can you put a date on when you're expecting completion?
I think I can, but it's not front of mind, Mr. Borsak.
Can you take that on notice, please?
Sure.
You mentioned 50 million in philanthropic donations. Can we find out who actually made those donations?
I don't know.
Take it on notice.
Yeah.
Take it on notice.
I've just read. I didn't know. I've read it in my note here that we expect it to be completed the middle of next year.
Middle of 2025.
Yep.
Thank you. Premier, will the Powerhouse Ultimo be restored to restored as the primary technology, applied arts and sciences museum in the country once its upgrading is finished, of course, in the middle of next year?
Well, I expect it to be, yes, and that's a position that it has held as a cultural institution for a long time, and I'd expect it to, once the revitalisation is completed, and you've got almost sister museums, one located on the Parramatta River and one located in the heart of the city at Ultimo. They'll be fantastic additions to the city, and I can't wait for them to be completed.
Can you assure the community that the Ultimo development will result in having its major exhibition items restored and returned from Castle Hill and elsewhere?
Most of them, my understanding is, will be, but do you know that, Simon? Right.
Sorry, I didn't hear that.
Some of them will go to the new Parramatta site. Some of them will be located at Ultimo, but you'd be aware that the Castle Hill site, which is the, I guess, for want of a better expression, the overflow part of the museum, where when we haven't had an opportunity to put a piece of history or art on display, they've been able to go to Castle Hill. Because we've got more floor space, we'll be able to put more on display more regularly. The intervening period, I think a particular favourite is the Catalina, and that's going to be temporarily put down in Albion Park at the Aviation Museum down there. So, but we'll all come back when the project's complete.
The Catalina, for example, will come back?
That's my understanding.
And the first steam train, New South Wales?
Steam train is due to be located at Para, I think.
Yeah, I'm not sure exactly where that one's going, but Mr. Borsak, the vast majority of the items that the powerhouse holds are actually not generally on display. It has thousands and thousands held in storage.
I think we accept that, and I think...
Yeah. So they cycle them through. They cycle them out of storage into different exhibitions that are held in... They'll be held across both those sites, Parramatta and Ultimo, once, that, as the Premier said, the floor space is available from both those new facilities.
Are we going to see the live steam exhibition restored?
You'd have to direct that question to the curators, to the powerhouse themselves, the Museum of...
Can you take that on notice and get an answer for me? Because
I'll take that on notice. Yeah, I'll try and answer it this afternoon if I can, but otherwise I think...
no, that's okay, when you can. Yeah. I'm just interested because there's a lot of talk around the community that the primary purpose and of the Ultimo site will no longer be technology and applied arts and sciences. And Premier, what you're saying is that preeminent application of that site will continue once it's restored.
I am.
I'm not verbally you, am I?
Yes.
I am.
Oh, sorry, what did you say? I am saying that. Is that...
He is verbally you.
I'm verbally you, thank you.
Now, questions from the Greens. Ms Boyd.
Thank you very much, Chair, and good morning to you, Premier. I'm going to start with a multiple choice question. On the 11th of August 2016, during the second reading of the Greyhound Racing Prohibition Bill 2016 in the Legislative Assembly, you said that if there is still non-compliance across the industry after a period of 2 years, and you then ended that sentence with either A, it should be closed down, or B, we should order an inquiry with the sole purpose, under its terms of reference, of ensuring the greyhound racing industry does not need to be closed down.
I don't know. I don't know what I said.
What do you think you said, the first one
No,
or the
I'm
second
not sure.
one?
Just tell me.
A or B?
Take me out of the suspense.
Okay, it's obviously it was A. You said it should be closed down.
Right.
That was apparently if there was non-compliance after 2 years. It's been 8 years, and it's very clear that this is an industry that continues.
Can I have a look at the transcript?
Really?
Yeah, absolutely.
You don't remember what you said in relation to the greyhound?
No, I don't. Do you remember what you said in 2016?
I think it's reasonable that if the Premier is asking, questions put to the question about something he's put to the Premier about a speech he gave 8 years ago, I think it's reasonable, Ms Boyd, for you to table the transcript.
Yeah, I don't have the transcript with me, but you can Google it. Which is what I did. So
that's fine.
Anyway,
I'm happy to answer questions. I don't have automatic recall of a speech
I
gave in 2016.
Okay, in 2016, you said that it should be closed down if it was still non-compliant within 2 years. It's been 8 years. It's very clear from the recent scandals that the greyhound racing industry is not compliant. Why won't you shut it down?
I'm not going to shut down the greyhound racing industry. We've got new regime and new systems in place, including regulatory agencies and the appointment of a new regulator through GWIC who's responsible for...
Why did you
hang on, I'm going to get the
prevent-
answer out.
Order.
Who's responsible for ensuring that the industry does comply
Yeah,
with...
but it's not.
hang on, sorry, I'm going to keep going. And I think that it's appropriate that under the circumstances to let Lee Drake, who's just been appointed, to have the opportunity to
Yeah.
do just that.
So on
so
that,
I think
why were the terms of reference bounded then by the statement, the purpose of the inquiry is to ensure a viable and sustainable greyhound racing industry in New South Wales, thereby precluding her from concluding that actually this is an industry incapable of reform?
sorry, was that the only term of reference?
That was the main purpose. The
Sorry,
purpose
what else
of
was in
the
the terms of
inquiry.
reference?
We're not going to waste time.
Well,
with
look,
you
I'm
showing
worried
you
that you're
terms
cherry
of
picking
reference.
because your suggestion to me in the committee is that was the only thing Lee
That
Drake
is
was looking
the only
at.
purpose. That is the only purpose.
Was there any other terms of
Of course,
reference?
there's terms of reference bounded by that purpose. That's how terms of reference
Can
work.
I have a look at it?
No, because I've got my own
Oh,
writing
okay.
all over
Well, there
it.
you go. I'd love
It's
to
your
see it.
press release, Premier.
yeah.
You know full
Oh, hang
well,
on,
and we're
hang
just
on, it's just
wasting
been
time.
look, this is very interesting.
Yeah.
It also says the inquiry will examine complaints
I
about
know.
greyhound
I've got
racing
it in
New
front of
South
me.
Wales governance
Order.
operations,
Yeah.
track safety, animal welfare issues,
What does it say?
including claims by whistleblowers.
What does it say
Now, I
in
think
the
if you're going to
purpose
present a
of the
question to me,
inquiry?
well,
Read the bit.
Mr.
The
Chair,
purpose.
Order,
if
order,
the question's
order.
going to be presented,
Order,
you can't
order,
cherry pick
order.
different
And
parts
you-
of the meeting.
Order. Please allow the Premier to answer.
If I
the
didn't have
question.
this,
All right.
if I didn't have the, I presume this is an attempt to.
No,
to
can we
trick me
can we
in
be very
relation to
clear
the
here?
release
What
of
does
the-
it say the purpose is in the last
Hang on.
sentence of that paragraph?
You've
Do not make
deliberately
out that I am
omitted a central
somehow
part
saying
of the
something
inquiry
that's not
with the
true.
attempt of
That's
either
really no, Premier. That's very dishonest of you. It's very
Is it? I
clear.
don't think it is dishonest.
Order, order, please. It's very difficult for me to
Right.
keep up with
Okay,
the
so-
banter.
The question,
and it's also
not banter.
Premier.
No,
what?
no, Mr. Chair.
Order, no.
The question
no,
was presented to me.
Order,
Back.
order.
Yeah, this doesn't.
He's
Order.
gonna kick
Please
me
come
out
to
in a
order.
minute.
You've been called to order once. It's very difficult for me to keep up. It's very difficult for Hansard to keep up. Please
Yeah.
return to some form of decorum.
Okay.
Let's have questions and answers
I
rather
will-
than hectoring each other.
Thank
Can
you.
I raise
will
a
move
point of order?
back.
Yes, you certainly can.
That a number of
Raise.
allegations and
Order.
suggestions are being made by direct
Yeah.
questions. I think
With
it's
a
appropriate.
whole bunch of omissions.
I believe it's appropriate that
my God,
any
witness.
witness,
Okay.
that they're not left hanging, that a witness
Okay.
who's asked to be able to answer those is now given the opportunity
To
to
the-
answer them, then we go on.
No, I
I've got
don't-
more.
I'll
I've
rule
got
on
the
that.
whole-
that,
I've
that,
got the
that-
whole
that is-
reference
I'll
here.
uphold
Yeah,
that point of
exactly.
order.
Stealing
That is
that.
how I've previously ruled.
Okay.
Ms. Boyd,
So,
you
so
have...
Mr.
Thank
Chair, in
you.
relation to the
No.
question, the scope
Premier,
of the inquiry
Premier,
is
it
to-
is my
interesting.
question
Okay.
time. I've made it very clear what the purpose of the inquiry was, and you know full well what the purpose of the
You've
inquiry
omitted
was.
the central premise. In
No.
fact,
And
the very
of
first,
course, terms
A
of
point of order
reference have
again.
more than
Fine.
that.
Order! A point of
That's
order has been taken. Mr.
incredibly
Primrose on a point of
dishonest of
order.
you,
Ms.
Premier.
Boyd,
Point
can
of
I please come
order.
to order?
This is Premier's estimates. Questions
He doesn't
by
get to
the
grandstand
opposition.
and make out
opposition
someone
Order.
else does not
Get an
have
very
to.
Order.
appropriate. But you can't then seek to leave those questions hanging.
yeah,
The
thank
Premier
you.
must be given the opportunity as a witness to respond.
even know
That
what
is a matter of
that's
purely
now.
of courtesy, if nothing else.
Thank you,
a stitch
Mr.
up.
Primrose.
I
I
wanna
uphold the
respond
point
to
of
the-
order.
I wanna
The
respond to the
Premier
question.
was attempting to respond. I've upheld that point of order. Unfortunately, Ms. Boyd,
Yes, it is.
do you have anything further to
Yes,
add?
I do.
Premier?
Absolutely.
Okay, well,
I don't want to let,
it's my time.
let a misapprehension hang in the air on the basis of an incomplete question
tell
that
the truth,
deliberately
Premier.
omitted
So please-
the first
please
scope
proceed.
of the
Chair.
inquiry, and I want to
Tell
read it
the
into the
truth.
record.
What does the purpose say?
order.
The scope of the inquiry is to
Order.
inquire.
Ms.
Is
I
to
heard
inquire
that.
into, report on, and make findings and
It's
recommendations
not my fault that
in relation to the
that
following.
happened and that
Number
this is eating
one,
into your time.
sorry, the scope of the inquiry is to inquire, report on, and make findings and recommendations in relation to the following.
I didn't ask you the
Number
scope, I
one,
asked you the purpose.
number one,
Yeah, this is
greyhound
pretty bad.
welfare
This is
and the
terrible.
care of greyhounds by Greyhound Racing New South
Shameful.
Wales.
The purpose, not the scope, the
Well,
purpose.
you can
Order.
abuse me if you like, but I think that you deliberately omitted a central
No,
part of the
you
inquiry.
cannot make that kind
and
of
I would
allegation
argue that a
against my
sustainable
integrity.
greyhound
Order.
racing
You don't
Order.
industry.
understand words.
Order.
I would
Ms.
argue
Boyd,
a sustainable greyhound
talking
racing
over the top
industry.
of the Premier while he's answering
my
and
time.
calling him names is discourteous. It's certainly disorderly, and I will call you to order if you're reflecting on the witnesses and talking over them continuously. You're not assisting yourselves. You're not assisting the hearing. Questions from Ms. Higginson.
Thank you, Chair. Premier, I would like to start with a joke, if that's okay.
Is yours funny?
Let's see. A former CEO of Forestry, a physicist and engineer, and a former Shadow Minister for Forestry walked in a bar to talk about threatened species who are threatened with extinction. Is that funny?
3 blondes is better.
Is that
Order!
funny, Premier? So, Premier, the premise is it's not very funny, but this is precisely what your independent forestry panel involves. Could you explain, Premier, why does that panel have no forest expertise on it in terms of forest science?
So it has no expertise on it.
In terms of forest ecology and forest science?
Isn't the former chief scientist on it?
With the greatest respect to Professor O'Kane, she is a physicist and an engineer. We are talking about forests, Premier, and the future of our public forest estate. Could you please just explain
Which will all
why
burn because of
there
you.
is no expertise?
Hang on a
You'll
second.
burn
I
it
think,
all.
Could you
again,
please explain
again, I
why
don't
there is
wanna-
no
hang on.
expertise?
I don't want the misapprehension to be perpetuated by you or the committee that this doesn't have eminent people with scientific background who can go and get expertise or evidence.
Premier, can I please redirect
Again, I'm
you?
going to finish
Premier?
my answer.
Premier,
Mr. Chair,
can I
I'm going to
please
finish my
redirect
answer.
you?
And I think it's unfair to
Chair?
the three
Chair?
people who are on the committee.
Premier, can I
been
please
appointed by the
redirect you
committee.
to answer my
order,
question?
not a point of order. Order. There is no capacity for you to redirect the.
There is. It's
no,
in the
there,
order.
no,
It's-
there isn't.
There isn't.
No, there isn't. That's a practice that's crept into these hearings in recent years, and there is no capacity for you to do that. You've asked a question, Ms. Higginson. The Premier is answering it. Please listen to the answer, and he can answer as he sees fit, and you can ask your questions when he's finished.
Forest science,
So
Premier.
look, the truth of the matter is, Mr. Chair, that the government has appointed Professor Mary O'Kane, Mick Veach, former member of the Legislative
Former
Council.
Shadow Forest Minister.
That's true.
Yep.
Yeah, that's true.
And
we've been
Peter
very
Duncan,
upfront.
the
And
former
Peter-
CEO.
Order.
Yeah.
Higginson, please
Mr.
allow
Chair,
the Premier
honestly,
to answer.
I mean, you've got to give me an opportunity to answer this because
this
it's
is
been
true.
leaving the community with the misapprehension that there's not people who are scientifically qualified who will not go out and get the information necessary to make good judgments in the best interests of the people of New South Wales. Now, it's...
Premier, this is not my claim, it's the community's
This may
claim.
well be an implied...
It's the community's claim,
It may well
Premier.
be an implied or accidental
Premier, you've got the
knock on the three
opportunity-
people that have been appointed.
You've got
but
the
I think they should
opportunity
be,
to answer the
Point of
question.
order. Should be given an opportunity to
Order.
report
Point
to
of
the New
order's been
South Wales
taken,
government.
Mr. Namber, on a point of order, and I can guess what it is.
Yeah, courtesy to the witness, but I just think courtesy to Hansard to just allow this to be a question and answer session, not a continuous stream of interjections.
Premier, you
during
have the
Hold
answers.
the point of
opportunity
order.
to answer the
It's
question.
impossible. I don't know what the question and the answer was now because there's been too much interjecting. I don't know how Hansard is possibly doing their job, and so unfortunately,
Well, give them an opportunity to do their job. They're eminent people. They'll do a good job on behalf of the people in New South Wales.
It's
And
very
you.
disappointing.
Don't jump the gun. And,
You could have
and
answered the question.
Don't jump the gun and
You could have
imply.
answered the question,
Thank
Don't
Premier.
you,
jump the
Ms.
gun
Higgins.
and imply that they won't do a good job.
You could have
These are
answered the
eminent
question,
people.
Premier. It was very straightforward.
Thank
Forest
you,
ecology.
Ms. Higginson. Order. We now have
Thank
time
you,
for a
Chair.
question. Thank you from the opposition.
Thank you. I'd also like to ask a question about appointments too, because you were a former Shadow Water Minister, were you not?
I was.
In 2018, did you not tell the Barrier Daily Truth that, quotes, Minister Blair has been found to have misled Parliament and refused to correct the record when he was told he was wrong? His position is untenable. Minister Blair knew that information concerning supposed prosecutions was false, and yet he did nothing about it. This is exactly why no one has confidence in the National Party. They have misled the Parliament, closed down investigations and misled the Ombudsman. It's time for the Minister to lose his water portfolio. And then on Facebook you posted, Labor says Blair must go.
Yeah.
Who have you just appointed as the Chair of Sydney Water?
You remember, we used to have those debates with Justin.
Sorry,
no.
Premier, who have you just appointed as the chair of
Well, I
Sydney
think you know
Water?
the answer to that.
This is the
Do you not know?
I'm asking you to confirm that you
No,
have just
Noel
appointed
Blair.
the same person that you made that description of in 2018 as chair of Sydney Water, have you not?
Well,
So what's
the
changed?
cabinet
What's changed? What's changed?
The cabinet appointed Mr. Blair, but I support it. I think he would do a good job in that role.
I agree, but you didn't
I
support
agree.
him in 2018.
It doesn't sound like you do.
Thank
You just say what you need to
Because
when it's
you
appropriate.
Order!
to cover
Order!
for the appointment of another one of your mates,
Order!
didn't you?
Please, come to
disguised
order,
as a
please.
question.
There's time for one question, and that will be from me. Premier, first I'd like to congratulate you on the strong action following the death of Molly Ticehurst and the $23 million package announced in May. I note that at the time you flagged the intention to undertake further long-term reforms to prevent domestic, sexual and family violence. My question my question is that more could be done to prevent perpetrators of domestic and family violence from re-offending. You may be aware that there was a review by Corrective Services called Equip Domestic and Family Violence Program, and it found that that treatment for offenders in corrections is not working. There are several reasons that they found for that. The Boscar audit found for that, and that was that prisoners are not allowed tablets in their cells with any connectivity, and they're not receiving therapy for their behaviours. Would you commit to an evaluation of a plan to allow perpetrators to access outside counselling on their tablets so they could commit to change and continue the therapy on release from prison?
Well, I don't know whether a repeat domestic violence offender in New South Wales, the reason for that repeat offending is the failure to access a tablet and
therapy.
And therapy. So I'm not committing to that. What I would say is the rate and prevalence of domestic violence is increasing in New South Wales, not decreasing. It's decreasing in Victoria, and Queensland showed promising results as well. The government announced an additional $250 million for domestic violence programs. We changed the law to make it more difficult for those facing serious domestic violence offences to get bail. And there's a whole range, a whole suite of legislative and administrative changes that we've pursued. But I'd like to see those major reforms take effect, and I suspect they'll bear more. I suspect they'll be more effective in reducing the scourge of domestic violence in the community.
Thank you, Premier. Thank you, everyone. The time for questions in this session has concluded. We will now have a break for 13 minutes. Oh no, we go to the government. Oh no, we're not having the break now, are we? We've got 15 minutes of government questions. I'm sorry.
We're fine. Very satisfied.
We're very satisfied. So you're waving so that we go to a half-hour break. Yeah, sorry.
11:15.
So we return. We'll return 11:15. Thank you.
Sorry,
I
Chair,
open the meeting again.
Well, I have questions for the Premier and he's not here.
What happens if the Premier...
It's 11:15. Where is he?
Here. There you go.
Here we go.
There he is.
Yeah.
You're late,
Perfectly
Premier.
on time.
Had to get
No,
his
it's
coffee.
11:15. He's on time.
Well, we're already on and he's not here.
Thank you for returning, Premier, for this second session. We now start with questions from the opposition.
Thank you.
Mrs Mitchell.
Premier, are you aware that since you came to office, more than 10 regional publications have shut down in New South Wales?
I didn't know the number was 10, but I knew that there'd been several that had shut down.
Are you aware of any that could be on the brink of closure?
I had a discussion with the Regional Journalists Association in Gunnedah on Wednesday or maybe Thursday of last week, where they indicated that they were concerned about regional newspapers shutting down, but I can't remember whether they told me about specific titles or not.
Sure. Well, there's been a number. Are you aware that in September last year there was a media release from your government stating that you're going to deliver on your election commitment to ensure the longevity of regional media, in your first budget delivering a $3 million commitment devoted to advertising spend in regional and community print outlets? Do you remember that announcement?
Yes.
Okay. Are you aware of a letter that you received in March this year, a joint letter from the Managing Director of the Australian Community Media and the President of the Country Press?
No, I'm not aware specifically
I've
of
got
that
a
letter.
copy here, so I'll be very happy to table it and provide it to you to have a look at. As I said, Premier, it was sent some months ago, back in March, and I'll just wait for you to get the document, but you'll see in the highlighted part, in the letter that is addressed to you dated 7th of March this year, whilst the $1 million of incremental New South Wales government advertising spend that was part of your government's election commitment was welcomed, sadly this promised expenditure has not occurred. In fact, New South Wales government advertising spend in regional newspapers has fallen by over 40% in the last 12 months. Premier, why haven't you honoured your election commitment?
My understanding was that we had honoured the election commitment in relation to the increase in expenditure for regional publications, but the net amount that's spent in regional newspapers across government agencies has dropped. Well, that's at least what was presented to me by the ACM and the regional editors.
Well, they're saying...
Hang on, I'm going to complete my answer. So I did have a discussion with them about the government's commitment, and not just the government's commitment in relation to that fund specifically for regional outlets, and there was a similar fund that was in place for ethnic media and other newspapers and media in the state, but also in relation to other government agencies. The big spender for regional communities from the government, particularly for newspapers, is roads and road safety campaigns and programs. In any event, I agreed to meet them. They said, can they speak to me and come and have a meeting? I can't remember the name of the people who I was with, but they were associated with
That's fine, Premier, but I guess my
Canberra Times Group.
My question to you is...
Casalino.
They
Casalino
wrote to you
Group.
in March. You said you bumped into them at AdQuip last week. We've had at least 10 and possibly more regional newspapers go under. They're saying under your government, the advertising spend is down 40% in the last 12 months. That means people are losing their jobs. That means regional people who rely on those newspapers for access to information are missing out because you haven't spent the money that you said you would in terms of advertising spend. So what are you going to do about it?
Yeah, no, I think that's a glib recitation of the circumstances relating to the economics of
glib
newspapers.
about it.
Well, I'm going to answer the question that you put to me. And the reason is, and the major reason is because you've neglected to point out the sharing agreement, the fund sharing agreement from major social media firms in the country. There was a pool of funds that was distributed. My understanding is it continues to be distributed by Google, but Meta withdrew from the application. And that's affecting print media, broadcast media, regional media right across the country. It's particularly the case in disaggregated populations like in New South Wales, and is the leading pressure, the massive pressure that we're seeing when it comes to regional newspapers. So
can I, Premier,
I want to take issue with the last bit of your question, which was that the drop in New South Wales government spending which you articulated is the reason for these newspapers going out. I just think it's important for the committee to understand that there are a lot of economic forces in relation to media businesses. Perhaps you're not aware of them.
I
I'm
don't
not
need
sure.
to be lectured by you in relation to what happens to regional newspapers with respect, Premier. I know many of the people who own and operate and work in these papers, and they've made it very clear that that lack of government advertising spend and the lack of the rollout of your election commitment is placing huge financial
But perhaps
pressures
you didn't
on them.
read the
So you are
second
going to
paragraph
meet
of
with
the
them.
letter that you
You
gave
are
me.
going to meet with them next week. What will you do?
Well, Mr. Chair, I think that's interesting that you
I'd
just
like
said
to
that.
ask, what are you going to do?
The letter is tabled, Premier.
No, no, and I'm going to read from it.
No,
I don't
just
need
answer the
you.
question.
Point of
Mr.
order.
Chair, surely I'm entitled to refer to the document that's been given to me.
Point of order has been taken by Mr. Nanva. Mr. Nanva, on point of order.
Chair,
Inconvenient if I did
the
read
opposition may not like the answer that's being given, but
I
the
know
answer
what's
is
in the letter.
relevant to the question that was asked, and I just ask that the courtesy be extended to the
Yeah,
Premier.
I mean,
Yes, I was
Mr. Speaker,
listening
I'm happy
very
to take the
clearly.
question.
I'm ruling,
I'm
Mr.
here for 4 hours.
Premier, the question was, what are you going to do?
No.
I was listening. No. The question from Mrs. Mitchell to you was, what were you going to do? Are you going to meet with these people, or you are going to meet with these people? Sorry, and I think you were responding to that. So please respond.
No, Mr.
Will you
Chair,
guarantee the 3 million will
question
be rolled
was,
out?
as a result of the government's closure, supposed reduction in spending for regional press, people are losing their jobs. And I'm just pointing, and I think this is reasonable, if it's not, I think it's grossly unfair, that I refer to the tabled document supplied by the honourable member in the second paragraph, and I'll read it to the committee. This has just been given to me now.
I don't need you to do that. It
Well,
hasn't
it'd be
been given to you
Mr.
now. It was
Chair.
sent to you in March.
Mr. Chair, please.
Order. The Premier can respond to the question the way he
You just
sees
cherry
fit.
pick.
He is being relevant to the questions you have asked. Please proceed, Mr.
The
Premier.
widely reported decision this week by Facebook parent company Meta to discontinue funding to regional media as compensation for using our locally generated news content will have an immediate and devastating effect. It removes a critical
Premier-
income stream that had been widely expected to continue for at least another 3 years.
And they also very clearly in the letter, Premier, country people will listen to this. They very clearly in the letter articulate the lack of investment from your government. You can't hide from this, Premier.
Particularly if you're going to ask questions
please.
about regional economies or the businesses,
What about election
it shouldn't be
commitments?
the case that you cherry pick information. And in fact, the second,
goodness
look,
sake.
this just goes to the point here
That
There's
you know
been an
nothing about
income
regional
stream-
New South Wales
Well,
and you don't care? Because that's pretty evident.
That's the point.
Well, you've got your abuse out of the way, and I'll
Order.
answer the
There's
question
nothing
now.
abusive
Order.
about
I'll just say
Premier.
this. I'll just say this, Mr. Chair.
Please come to order.
Clearly, the economics of media, particularly in regional New South Wales, particularly when it comes to regional newspapers, has been significantly affected by social media companies, particularly Meta's decision to withdraw that local content fee to regional newspapers. The same occurs to major publications in metropolitan cities like Sydney and other places.
Premier,
As
they
a
very
result of
clearly
that,
say
I'm
in
going to
this
finish
letter,
this because
though,
this isn't just hyperbole. This
I'm
is
asking
absolutely
you about
crucial.
New South Wales
As a result
government
of that,
spending.
of course,
That's what
the,
we're here to do.
Of course, the government will meet with regional businesses and talk about changes to the circumstances.
6 months after they
But I
write
think
you.
I honestly think that you should present all of the
It's lucky it
information that's
wasn't
been
Steve
presented to
McMahon.
you.
would've got
He
an
got in
answer.
3 days, but these
would've
guys
got an
wait
answer,
6
wouldn't he?
months.
Order.
Well, you've neglected the second paragraph in your
Steve
question.
Well, you've
Mr.
neglected the
Mrs.
bulk
which
of the letter and the
sends
refusal
Got a
of 6 months
question?
to meet.
Please
It adds to
proceed
the-
rather than...
Thank you,
Bad
It
Chair.
adds to the
witness.
suggestion that you're not on the
Thank you,
level
Chair.
about trying to find a solution to this
Premier,
is my only point.
You're the one not on the level. They wrote to you 6 months ago and you've ignored it.
I
Can
haven't
you tell
ignored
me,
them. I saw
Premier,
them last week. I just told you that.
you bumped into them at Agri.
No, I-
It's hardly like
I
it was an
talked to them-
organised meeting. If they were a mate, they'd be in within 3 days.
Well, I was happy to meet with them and
Premier,
I talked to them, and that's
thank you,
inconvenient for you
I
in
would
terms
like
of your
to
timeline, but it's
ask
the
you-
facts.
Well, the facts speak for themselves and they know. Can you tell me what the initial intended network capacity target was for the Central West Arana Res?
I can't tell you that.
Do you know what the current intended network capacity for
Simon,
it
have
is?
you got any information about that?
No, I don't have.
No.
Can you take it on notice?
We can get that for you today. Yeah.
Sure. Do you know, Premier, where the Central West Arana Res is currently sitting in terms of network capacity when you add up all the projects that have been approved?
I'm happy to take it on notice and come back to the
Okay.
committee.
So the concern coming from a lot of the regional communities around this, Premier, is that the original intended network capacity was 3 gigawatts. We're now looking, when you combine, according to data provided by the relevant councils in that area, that the total renewable generation comes in at 12.52 gigawatts. The problem that you've got is that Energy Co is saying that the Central West Arana Res will be at least 4.5. Local councils are saying it will be more than 12 gigawatts. Can you clarify which figure's correct?
I'll have to come back to the committee and report, which I'm happy to do. But in relation to the Central West Arana Res, the government was faced with a situation where we were originally told that the estimated cost of the project for consumers, this isn't going to be borne by the New South Wales government balance sheet, but it will be borne by consumers in the state, was $650 million. We were then told, I presume this was presented to you, Mr Tudor, Hope in government, that the actual cost was $3.2 billion, an astronomical increase, more than 300%. None of that information was presented to the public. None of it was presented by the National Party or the Liberal Party to the people of New South Wales during the election campaign. None of it was communicated as part of the challenges facing energy production and distribution in New South Wales.
I actually didn't ask
and
the
as a
Premier.
result of
Can I
that,
just- I can
the
take a
government's
point of order,
decision to keep
Premier?
Arara
Premier, I'm
power
able to
station
take a
open
point of order.
was an important one in terms of
Can
keeping
I
it
take a
open.
point of order, please?
Well, Mr Speaker, every time I raise a point
I'm
that
a
the
no,
member doesn't
no.
like, a point of order comes in.
Well,
If I'm here for 4 hours, you should give me an opportunity to finish my
is
answer.
entitled
Thank you.
to take a point of order,
Thank
and
you,
you
Chair.
are entitled. No, you're not.
I
to
didn't
respond,
ask, with respect to the Premier, I didn't ask questions about the cost of the project. I was asking about the capacity.
Well, nonetheless,
And
I
I
think
would
this is
like,
important
it
information.
is important. So I would just like to come back to what I'd asked you about, Premier. If local
So what's
councils...
the point of order?
My point of order is relevance. It was not relevant to the question that I asked. I was asking about network capacity. I was not asking about cost.
To the point of order,
To the point of order.
it was relevant to the question asked. Wide latitude is given, and just because it wasn't relevant to the part that Ms Mitchell wanted it to be relevant to,
It was a pretty direct question.
It doesn't mean that.
Well, it goes to the
answer is
information.
not relevant.
Sorry, Premier, that's my job to rule on that. It was generally relevant, and so I don't uphold the point of order.
Well, in any event, the capacity of the site is directly relevant to the cost that will be borne by the consumers. To suggest otherwise, which is what the National Party seem to be implying today, is ridiculous. The information that I've got now is that it will be 4.5 gigawatts by 2028.
Right.
But if there's updated information, I'll report it to the committee.
Thank you.
Premier.
But can you accept then, Premier, if you're saying it's 4.5, local government in that area are saying...
Which government?
Dubbo Council, Midwestern, and also Warrnambool.
In what capacity are they saying that?
Well,
But
as
just-
the
we'll ask the
areas
questions,
that are having these projects in their backyard, they're within the reses. They're the 3 councils within the Central West.
And that by
res.
2028.
They are saying that the data that they've provided, it comes in at 12.52 gigawatts in terms of the approved project. So the concern that is coming from the region's Premier is that more land is going to need to be used when you're talking about more projects. Do you accept why that regional people are having to cop more and more renewable projects in their backyard? Do you understand the concern
Well, I
around
mean,
that?
it's interesting. You talk about regional people copying renewable energy projects in their backyard. You started this. This is your project.
But it is being overblown by more than 3 times
well,
the amount that it was
you presented that as a
originally
fact.
intended.
I'd have to check whether that's the case.
Well, you
or
had
not.
to
But
take
this
that
is
on
your
notice.
project.
You didn't
hate
know.
it.
You had to take
now
it on
you hate
notice,
it.
Premier.
Well, you
But
don't
at the
want it.
time,
You didn't know.
I think it's important.
Well, good.
You
Again,
didn't know.
my position's clear.
my-
With respect, Mr. Latham's
my-
position's
my
clear. The
question-
Greens have got their view.
Premier, I'm
But
not
before the
asking
election,
about
you're
others.
against. You're for the
Premier,
project. Straight after the
I'm
election, when
asking you very
communities start saying, I don't like
important
We knew how to
transmission
on
manage it,
behalf
Premier,
of the
not
residents
you.
of regional areas who actually
This
are
is your
deeply passionate
project.
about
It started at
this.
$650 million. It's now $3.2
What-
billion, and you've got the gall to come in here and say, I'm not happy with the
Premier.
progress.
Because you can't handle it.
What will you do to ensure that the Central West Arana Res doesn't
okay.
continue
Well,
getting...
what's happened?
Order!
What do you think that we've
Two
done?
years, mate. You've
I'm
had
answering
Order!
his question.
Order! Can we have a question, please?
Thank
Mrs.
you.
Mitchell?
I'd love to ask one. What are you going to do to ensure that the concerns of regional residents who are being impacted by this res are being heard? People are concerned about the proliferation of more and more projects being added. What will you do? You are in government. You
well,
are
I'd
the
say
Premier.
this,
What will you do?
Mr. Chair. I mean, these are land use challenges. They're big. They're very difficult to navigate, and we've got real challenges. We've got a very tight and narrow pathway to transmit the renewable energy from places like the Central West Arana Res to the East Coast energy grid. The transmission line, I mean, I didn't mention this, that's the res blowout. The res blowout 650 to 3.2 billion. The transmission lines have had cost increases as well as time delays as well, and that puts pressure on the existing coal-fired power generation. Now, that's a roundabout way of answering the question, but what I mean is this. We have to get these projects up and running as soon as possible. The reason for that is that we've got increasing numbers of coal-fired generation that are coming offline in the years ahead. And if we don't meet our timetable for renewable energy in the central West Arana and other places in New England, then we're going to have a shortfall, and that means that prices will increase, or there'll be load shedding, or there'll be supply constraints. I mean, when you ask me what am I going to say to the people of the Central West, I'm out there tomorrow and I'll say that this is your project. You started it.
Thank you, Premier.
It's hugely inconvenient today in relation to your questions, but it's the truth nonetheless.
I wanted to ask you today, there's an announcement about 125 paramedics in regional New South Wales. Could you just confirm for the committee how many of those 125 paramedics are intensive care or extended care paramedics?
I couldn't do that off the top of my head, but I'm happy to take it on notice.
Right, so you're aware that your election commitment of those 500 additional ones was that they would all be intensive care and extended care paramedics, so are they all, that 125 you announced today?
I can't answer it. I said I'd take it on notice.
So is it possible that's a broken election commitment if they're not all 125?
Give me an opportunity to examine the information.
But you spruiked it on social media, but you don't know the detail?
Would you like the information if I could
I thought you'd know it. It's all over your social media.
I couldn't tell you whether it was...
Do your staff know?
Someone might be able to pass you a note. The designation in relation to paramedics. But I'm happy to collect the information.
That'd be
great. When you got my job, you are in a position to ask the Health Minister or...
Well, yeah, but it was on your social media. I noticed it today, Premier. I just thought you might know. But if you can get me the answer, that'd be great.
Taken on notice.
Thank you. Premier, before the election, you said, and I quote, "I don't pretend to have any expertise about regional New South Wales." Why then have you brought regional coordination under the control of your department?
Well, I mean, self-evidently, I'm not the sole person that works in the Premier's department, and we have senior people who can run, administer, implement serious changes. The second part of this is that we do want it to be central to the mission of the New South Wales government. 1/3 of people don't live in Sydney, in New South Wales, and it's important that it gets the highest priority. And in relation to my comment, I'm not going to pretend I'm something that I'm not. I grew up in suburban Sydney. I've lived my whole life there. I do make an attempt to understand the circumstances, the economic opportunity, the challenges of living in regional New South Wales, and every week that Parliament's not sitting, I will go to a regional town.
Every week?
Yep.
Yeah, right. There you go.
You should try it.
Well, I live there. I don't need to visit. There's no need to fly in and fly out when it's your own community.
Well, but that's the case. I fully admit that. I don't live in regional New South Wales. I live in the city.
And I accept
we do
that.
try and make an effort to try and get out to the communities to understand what they're going through.
Can you tell me what are the 4 focus areas for funding in regional New South Wales under your government?
What document are you referring to?
I'm referring to, you made an announcement when you were out in Orange. I think that was as far west as you went when you had that cabinet out there. And there were 4 key areas of funding that you'll be rolling out under that regional fund. Can you tell me what they are?
What's the name of the regional fund?
The regional. You've got the Regional Development Trust before the House at the moment. You made an announcement. You were there. You were at the press conference. There were 4 focus areas for funding. I want to know if you know what they are.
So these are the specifics of the trust, the priorities of the individual trust. Well, I'm happy to get that for you, but in terms of the priorities for regional New South Wales, world-class service delivery, economic opportunity, and a chance for everybody, no matter where they live in the state, to meet their full potential.
Okay, well, there were 4 areas identified, and I appreciate you've taken that on notice. Can you tell me how those 4 focus areas were identified?
But you'd have to direct that to the Minister.
But it's under your department, with respect, Premier, and you're the Premier of the state. You stood up and did the press conference. Can you tell me how those 4 areas were identified?
I'm happy to take it on notice, but I think it's best that you direct it to the Minister.
Right, well, if you can provide it on notice, that'd be great. Do you think there should be more than 4 focus areas?
Well, as I said, this is in relation to specifically the trust, and I don't want regional people to believe that that's the sole focus, priority or attention of the New South Wales government. I mean, we were in the South Coast not long ago. The absolute priority for the New South Wales South Coast, a regional community, a growing community but with an ageing population, was the completion of the Eurobadalla Hospital. I'm going to Orange tomorrow. I suspect what they'll speak to me about is resource opportunities and job opportunities in that part of the state, in particular the gold mines. If I go to the New South Wales North Coast, specifically spoken to them many times, it's flood recovery and disaster recovery and ensuring that both the state and the federal government provide the information and funds that had previously been promised. If I go to Moree, which I did the week after last, they'll say it's crime, and that we need to make a major impact on an intervention when it comes to repeat instances of criminal behaviour.
So, by your admission then, Premier, there are much bigger issues than just
yeah, but you're
four
just speaking
areas.
about the trust, the priorities of the
Well,
trust.
it's
That's
your
just one
2-year
aspect of our regional.
It's the 2-year investment strategy that you
But in any
talked about when
event,
you
the
were in
trust
Orange.
is just one aspect of the thousands of things the New South Wales government does. So to imply that that's the whole priority or focus of the government's efforts in
Well,
the
that's
region
where
of New
your
South
money's
Wales is
rolling out
ridiculous.
initially, those first 4. It's a
No,
2-year
more
investment
money would be going to
strategy.
service delivery. More money would be going to education. More money would be going to health.
Well, there's
That's
not,
the way it should be.
Well, I'll tell
I mean,
you,
$1
regional
billion
health's not
for
going
roads,
particularly
regional
well, I have
roads.
to say, Premier.
Thank you, Mrs Mitchell. We'll now turn to questions from the crossbench, beginning with Mr Borzak.
Thank you. Premier, just talking about and thinking about social media for a couple of minutes. Can you tell us about your social media summit? Why are you doing this, and when do you think you'll do it?
Well, the summit's in October. The reason for pursuing the summit is because I've been inundated with parents who've spoken to me about their concerns of the proliferation of social media used amongst young people. In my view, it's a global, unregulated experiment on the next generation of young Australians and people around the world. I think at best, Mr Borzak, it's a giant waste of time, a time suck for young people, and at worst it can have devastating impacts on young people's mental health and development and social circles and cohesion. We made a decision to ban mobile phones in New South Wales schools, and I think,
Well,
I honestly think
how's that working out, for example?
overwhelmingly positive. I honestly think it's the best decision that we've made. Seriously, it's been hugely beneficial for regional for communities across the state. I've spoken to principals that say this time 2 years ago the kids would sit at recess and lunch and be on their phones, maybe even texting each other 2 feet away. Now they're actually playing ball games, talking with each other, interacting. It's been a massively positive impact. Now look, there's big challenges. There's constitutional and legal challenges in terms of the remedy that we're pursuing, and I know that the South Australian government with Justice French is exploring the ability for state governments to impose their own restrictions, so we'll look forward to that advice once it's furnished to the South Australian government. But at the very minimum, we'll be able to present information to parents about what social media is doing to their families.
Yeah, there are calls to lift, and I suppose, obviously you know this, the age of social media access from 13 to 16. Do you support that?
I haven't given a decision on that personally, and the cabinet hasn't decided on it either. And we're not trying to be coy about it. I think that there would be major positive impacts for young people about a change like that. But I want to get the information on the table. I want to get the experts in the room and not, I guess, overshadow the social media summit so that the information can be provided. I think those that would be against such a change would imply that there was some form of apprehended bias if I came out and said, oh, well, you know, this is the decision before we even have the evidence presented on the table and we pursue the summit. But I did want to make it clear that everything's on the table, including legislative change, and I think something has to change here. And I remember Mr Borzak, we had a group in my electorate called the Heads Up Alliance, just mums and dads in Kingsgrove who got together as parents and said, well, we've spoken to our kids about accessing social media and our concerns about it, and the kids come back to their parents and say, but if you take me off social media, I'll be a social pariah because everybody else does it in the school. I get that. We see that every single day. So their view, the Heads Up Alliance, was to try and get a group of parents together to say, well, we're all going to bring down the same rules so at least our kids can have each other. The other point here is that, you know, this isn't about being a perfect parent either, Mr Borzak. Like, I'm guilty as much as anyone else is of giving an iPad to the kids when they're all bluing with each other and fighting, but that's kind of the point. It's just so simple to do it.
Maybe you need one here. Sorry.
Order. Premier, there are studies out there that are saying that I've read that say that that starting on social media too young actually stunts the brain development, because our brains weren't designed to develop through adolescence using something like social media. It's more about letting kids be kids, whether they're male or female, it doesn't matter, or something in between. And the reality is that I think it's a good idea to think this through very carefully, and you're not actually. I don't think you're actually trying to restrict freedom of communication or freedom of speech, because children don't have a right to freedom of speech. They are meant to be administered by their parents, and it's important that parents have a say in relation to this. What are you going to be doing in terms of getting parent groups into your summit?
Yeah, that is part of the process. Where there is, as I mentioned earlier, a number of groups that have been started by parents, civic-minded parents that are concerned about the impact of social media. We're doing our best to identify them and invite them as participants in the summit, as well as getting experts around the table. The social media firms will say publicly that while the rules are in place for many of the social media firms that people under 12 can't join, I think 12 for most of them, they've got no way of determining whether the person is of that age or not. And that's just garbage. I mean, they can tell whether somebody likes, green smoothies and lives in Cogra and is a millennial, or they can virtually pick the date that someone's born, and yet they're with a straight face trying to express to everybody that they'd have no idea whether someone was over or under 12 years of age. Second point here is that you're right, parents, it's the parents' responsibility to raise their kids. Having access to social media networks opens people up to a whole range of nefarious actors. Very difficult to police, almost impossible to keep an eye on. And even if we did bring in a rule banning people from a certain age from accessing social media, I've got no doubt some people will abuse it and join up anyway. But the point would be that you'd have a rule in place and the social media firms would be required to abide by it.
A lot of this is obviously federal jurisdictional, and obviously there's some cross jurisdictional opportunities as well. If findings from the summit push you in a direction of doing some regulation at the state level, would you take every opportunity to do that?
Yes, we would. I mean, we'd have to make sure that we were on solid grounds in terms of legislation or prospective reform. But as I said earlier, Peter Malinauskas in South Australia, I think, has led the national debate about concern for this, and the South Australian government's exploring legally enforceable, binding, state-based legislation that could make a difference. And, this is the first time two jurisdictions, as far as I know, South Australia and New South Wales, have bound together to host a joint summit on something other than border issues or state-federal relations. So, hopefully, at the very least, it'll present information to parents about what's going on.
Sorry, did you say the federal government's going to join in your summit?
Well, they're invited to come, but no, the New South Wales government and the South Australian government are
South
hosting
Australia
it.
at this stage.
Yep.
And you wouldn't be interested, or I suppose you would be interested, if any other states, for example, Victoria and Queensland, were interested?
Yes, we would, but I haven't heard of whether they are or not.
No, all right, okay, I'm done at the moment.
Mr. Latham, you've got 2 minutes.
Premier, earlier on you said, why didn't I put this problem of Mr. Volandi's interfering in the stewards' inquiries to him directly at the hearing on the 9th of August? Well, in fact, I did, and Mr. Volandi's replied, "Let me say again under oath, Mr. Latham, I've never, ever, ever interfered in a stewards' inquiry, ever." Now, you've had a good chance to look at the transcript that shows that, as a matter of course, Mr. Volandi's makes the final decision. That statement's not true, is it?
Well, I've got no possible way of answering whether that's the case or not. I just have to take your word for it, and I'm not prepared to do that.
You said earlier on that this matter needs to go to the Racing Minister. Will you now undertake, given the high standard you set before the election for integrity matters, for the Racing Minister to investigate this problem at Racing New South Wales, where the stewards' inquiries aren't impartial and independent, and there are scores of transcripts that indicate the same thing?
Well, again, you've put a series of propositions and dressed them up as facts, and then demanded that I submit to an inquiry by the government. I've got no way of validating whether that's the case or not. You've suggested that they're not impartial, that there's been some kind of, well, the implication is some kind of nefarious input from senior figures in Racing New South Wales. That's not good enough for me to demand an inquiry.
The very high standard you said, that in your marrow and your bones it'll all be integrity. Haven't you read this transcript?
But this transcript doesn't imply corruption or nefarious conduct by itself. Well, we're relying on your word.
No, you're relying on the words of the Chief Steward at the time, Mr Van Gestel, who says, yes, that's how it works. We'll consider the evidence, make any recommendations that we think are appropriate, and then Mr Volandis will then consider whether or not he agrees with those recommendations.
Well, the question to me was...
Are you saying to the committee you don't regard that as a serious matter of integrity in the administration of Racing New South Wales? Someone who doesn't hear the evidence, someone who's not at the inquiry, makes the final decision? Imagine it happening in the courts or ICAC. Everyone would be up in arms.
Again, a whole bunch of suppositions that are presented as absolute facts. Someone that doesn't hear the evidence, someone that doesn't afford due process. I've got no way of validating whether that's true or not. You're asking me to tell the Racing Minister to conduct a formal inquiry based on your word
based
and
on
a partial transcript.
Based on the transcript.
Yeah, but you've implied that the transcript. You've implied that the transcript is in some way deleterious or nefarious.
Well, that's what it says. Do you understand what it says?
No, it doesn't say that. Where's the evidence? I'm trying to find it.
The
other thing, Mr Chair, is that...
well, that's a denial of reality.
The other thing, Mr Chair, is that in previous questions on the same issue from the member, there was a whole bunch of... the question was premised with the suggestion that there was, I think the quote is, a whole range of people that have made allegations. Well, they haven't been presented to me. I don't know if they've been presented to the committee.
Well, they haven't.
Well, the Racing Minister can talk to them. If you're
going to ask me a question like that, surely you should
Premier,
raise
I
it
have
with
some
all the
questions,
information.
and I'll start with those now. Premier.
But I'll ask the Racing Minister.
Thank you, Premier. Premier, what's the leading cause of death in New South Wales? Is it accidental? Is it the road toll or overdose from opioids?
So it's the road toll.
No. Would you be surprised to learn that it's a death from opioid overdoses?
Oh, right. I would be surprised, yes.
Shouldn't you know that?
Perhaps I should, yeah.
Are you aware of a new type of synthetic opioid that's emerged globally called nitazene?
I am.
And are you concerned that this is a unique and urgent issue in the community, in that nitazenes, which is an incredibly toxic and powerful synthetic opioid, is appearing in areas where, let's say, in drugs, in such as cocaine, THC vapes, methamphetamine, ketamine, and MDMA in New South Wales?
Increasingly, yes, it is appearing.
And that people have started overdosing from that, from those synthetic opioids in this state?
Yes, I am aware of that.
What are you going to do about it? There's been calls from the RCGP, the Royal College of General Practitioners, National Alcohol and Drugs Network, UNHARM, to bring in drug checking, expanded drug checking, to roll out naloxone to first responders, and to run a public awareness campaign. Would you commit to doing some of those things before people who have got no idea that this drug is out there, that it may be in something they're using, die?
Well, I don't profess to be an expert in relation to the proliferation of this new substance, particularly in other illicit substances. It might be part of the illicit black market mix of substances that people buy, whether it's ice or cocaine. Obviously, those unregulated illegal narcotics in the community are not subject to anything. So we don't know what's in them. And
shouldn't people...
Well, I'll finish the answer.
Sure.
And so, given that, and given the experience in the United States, which has seen, I think, 500,000 people die as a result of exposure to fentanyl, and other synthetic opioids, we don't want to see, of course we don't want to see the number of people die in Australia for a similar and potentially more lethal product. So I can't specifically commit to all of the things that you've just articulated, but I know that the Minister for Health is concerned about it, and the government, going back several administrations and under different premiers, has a long history of public awareness campaigns and ensuring that there's a harm minimisation
I understand
in place.
that, Premier, but will the government do something in specifically around this emerging crisis, as some has put it, around nitazene?
Mr. Chair, I'm sure that we will. I don't have the details of it. This is obviously an emerging threat to the community, but the only point I'm making is that the government has a long history of public awareness campaigns that have been run by the Ministry for Health that have been successful, or more successful than if they weren't in place, and I'm sure the Health Minister's looking at it, but I will commit to you to return to the committee and you personally about the government's program to minimise the number of deaths from this toxic substance.
That'd be very much appreciated. Another issue, Premier, that I've been raising for a long time now is coal seam gas on the Liverpool Plains. Recently, the government decided not to vote for a coal seam gas prohibition bill on the Liverpool Plains. The Liverpool Plains contain the largest area of biophysical strategic agricultural land in the state, contribute hundreds of millions of dollars of agricultural productivity to the state every year. The farmers there are asking that their plains be protected from future expansions of the Narrabri gas project as foreshadowed in the state's future of gas strategy that's still alive. Why won't the government commit to protecting our food bowl and the Liverpool Plains from CSG?
Well, I mean, you know, that question rests on the premise that you can't do both, that you can't protect the food bowl and have gas extraction and energy extraction from the Liverpool Plains. Supporting the bill, I think it was your private member's bill in the Legislative Council, would have seen the extinguishment of the prospect of coal seam gas from Narrabri for domestic use primarily for domestic use in manufacturing in the state, which is really important. And I said in the election campaign, we've been consistent in relation to this. The state needs gas. At the moment, we import all of it. Now, that doesn't mean Narrabri is going to go ahead. Santos has to make an investment decision at some point, and I understand that there's still environmental court challenges that are taking place, but you know, there's probably a few hurdles to go through. But us supporting that bill and providing the numbers for it would have extinguished the prospect of the program going ahead, and I'm not prepared to do that, particularly when a lot of today's discussion has been about the volatility of energy supply and the challenges facing the state.
Thank you, Premier. Premier, do I seem impaired to you?
No, you seem very sharp.
Would you be prepared to hop in a car with me and drive around the block?
No.
I was going to say, please say yes.
Why not?
Just because I'm busy and I don't know what.
If you weren't busy, if we had all the time in the world, considering I'm not impaired and I hold a licence, would you be prepared to, you know, drive down to Bondi Beach and have a cup of coffee?
I probably would, yeah.
It
depends what you put on the radio. What would you be listening to?
If you did, and I was picked up by an RDT, I would lose my licence because I'm a medicinal cannabis patient and I took medicinal cannabis last night, I would lose my licence for 12 months. Even though in your opinion I'm not impaired, because I just have I would test positive for the presence of medicinal cannabis. Do you think that that's a fair situation that I and hundreds of thousands of other people in New South Wales are faced with every day, and that thousands of people in this state have lost their licences, their jobs, their relationships, because we are continuing to test for the presence of medicinal for cannabis, which impacts on medicinal cannabis patients who have a legal prescription?
Well, I think the first question was, would I be surprised that you consumed medicinal cannabis last night? And I wouldn't be surprised.
That's true.
But in relation to the question of roadside drug testing, picking up the presence of THC and therefore cannabis use over a prolonged period, and I accept that the literature suggests that impairment and detection are separate, they're not the same, and that detection will exist longer than impairment. The challenge for the government is there's no test for impairment. But as I said earlier to your questions, there's over 300,000 people in the state that are currently have a prescription for medicinal cannabis with THC and therefore would be detected by roadside drug testing infrastructure, and therefore if they want to use a car while accessing the health benefits of having access to medicinal cannabis, then they can't do it. So I think you've asked me about this before. One of the reasons we are pursuing a drug summit is to look at issues in the law like this, and I expect that drug summit will look specifically at that issue. I mean, the reason things have changed is that when I first was elected to Parliament in 2016, 2015, in the first year after access to medicinal cannabis became legal in New South Wales, there was 1,000 people. Then it got to 1,500. Now it's over 300,000 in New South Wales alone, and the numbers are increasing. So I think it's an area of the law that needs to be looked at. I can't commit to it today, but the Drug Summit will investigate it.
Thank you, Premier. You and your department have carriage of Aboriginal affairs and responsible for closing the gap. The parliamentary inquiry into the regulatory framework has received a lot of evidence that one of the leading causes for young Aboriginal people to have an engagement with the police and the criminal justice system that ultimately leads to incarceration are cannabis laws. Young Aboriginal people are being stopped on suspicion of minor cannabis possession, searched. It then leads to a hinder police, an assault police, and abusive language. Do you think that cannabis laws and the way they are policed in this state is adding to the rates of young Aboriginal people who are ending up in our criminal justice system unnecessarily?
Look, I wouldn't be able to give a sweeping answer like that. There'd be a whole range of reasons that anyone in the community, whether Indigenous youth or not, would have interactions with police. And police are in a difficult position, and they've got to enforce the law of the land. The law of the land is that these drugs are illicit and illegal, and so I think that what often happens is politicians, we say, well, it's the police's fault. The police say, well, hang on, this is the law, and we're charged with the responsibility of upholding the law. So this is a very complex area of the law. I acknowledge that under the closing the gap targets where we're not meeting our way stations along the way, and we're looking very closely at that. But our hope is that leads to, the goal has to be that we're making every effort possible to reduce the amount of interactions between police and Indigenous people because crimes aren't committed. That's going to be the best for everybody. And we're starting that process, but I'm not going to pretend it's easy. Mr. Chair, do you mind if we have a quick break? Sorry.
No, well, that's fine.
I've got to go to the loo. I won't be a second.
Go have a break. You've got to have a break, but we'll suspend the time.
Ultimo Museum when that's completed, so that they're going back there. And in terms of the donations, $10 million of the $50 million has been pledged by UTS so far, but the campaign for the other philanthropic fundraising will commence when the main works contract is awarded. That hasn't been awarded yet, and that's in line with what we did at the Archaeology of New South Wales and Parramatta powerhouse as well.
So you're saying that people that win the contracts will kick back?
No, I'm not saying that at all.
Okay.
Certainly not.
I'm
saying that there's no point in that people aren't likely to donate to the costs of a new building until they know it's going to be built, and that happens when we award the contracts to the main works contractor. Yeah.
So someone like Walker Corporation, for example, might make a donation.
I believe Walker Corporation donated to the.
I think they did something in Parramatta.
That's correct. Yeah, but I don't know whether they're going to make any other donations. I couldn't comment on that.
So what you're saying is that you hope to get $50 million once the thing is completed.
Probably before it's completed, and that's the track record for the Archaeology of New South Wales and the powerhouse Parramatta is we're almost there in terms of its fundraising as well. Yeah.
So the actual appeal hasn't been launched yet? Is that what you're saying?
Not sure what you're referring to.
Sorry?
I'm not sure what you're the appeal for funds.
Donations, yeah.
Correct, the campaign, yeah.
Yeah, okay, thank you.
Thank you, Mr. Draper. We'll assume that we've lost 5 minutes and we'll correct that. We'll just continue on for an extra 5 minutes. So we'll now turn to questions from the opposition. Mr. Tudor, hope I assume.
2 minutes.
Premier,
well, that's
the ETU are currently engaged in industrial action in New South Wales, are they not?
Yes.
And that's impacting and putting at risk a lot of infrastructure projects that are currently taking place in New South Wales?
Well, you'd have to be specific. I mean, there's contingencies in place for infrastructure projects and the running of the metro and other pieces of critical infrastructure. So I wouldn't say it's imperiling it. It really is dependent.
Well, it's impacting on it, isn't it?
Yeah, it may be, yeah.
Well, it's self-evident if they're taking industrial action that it would be impacting on those projects.
Well, there's a difference between impacting and putting at risk, is my point. I don't think that's a semantic point.
Some of those projects include Royal Prince Alfred Hospital. You're aware that that's being impacted by this action?
I'm not aware of that.
Balcombe Hills Public School?
No, I'm not
the
aware
Aerotropolis?
of that. No, the Aerotropolis is going ahead. We expect it to
but
open
it
on
is
time.
being impacted in terms of it's the work being done.
Well,
there
that's what
by
I'm
this
saying. I mean, a lot of these contracting firms have got contingencies in place, so it may not put at risk critical infrastructure.
So you're
on time.
prepared just to tolerate this, are you? Is that what I read into what you've just told me, is that this is okay?
I don't think anything I've said would lead you to that conclusion
Well,
by
is
a
it okay?
fair-minded observer.
Is it okay?
In different cases, if they're taking protected industrial action under the Fair Work Commission at the federal level, I mean, it's got to be worked through. Oftentimes these are private... hang on, I'm going to finish my answer. Oftentimes these are private firms, construction firms. They might be contractors to the New South Wales government. They might be contractors to a head company who does work for the government. It might have nothing to do with us. It might be a private project that's not dependent on government taxpayer work. It really depends.
Well, you would have seen some reporting on Channel 9 last night where private contractors involved with the delivery of important housing infrastructure can't get construction certificates or occupation certificates because of actions being taken by the ETU. You would have seen that, would you not?
I didn't see it, but I'm aware of the issue, but I didn't watch the report.
Yep. Well, because there are certain actions you can take in relation to the activity of the ETU. Have you considered taking action under Section 424 of the Fair Work Act?
No.
Why haven't you?
Well, I mean, industrial action, protected industrial action under the federal award took place and has taken place since Federation. We hope to reduce industrial impacts. We hope that there's not impacts on critical infrastructure or people's ease of doing work around the state or the country, but I can't promise, and I don't think any leader can promise 100% industrial harmony. There's industrial issues that are going to pursue. So when you've asked the question, I'm not going to pursue it.
Well, let me just say that there is a mechanism under the Fair Work Act for an intervention in relation to protected industrial action. What's the point do you say, Premier, where you would take that action?
Well, I'm not going to entertain hypotheticals. And I remember. I think it's important to, when talking about industrial relations, we're going to have a different approach to the previous government. We're going to have a different approach to you.
We saw that yesterday.
Well, that's right. I mean, they were yelling my name and abusing me, not you. So, I mean, I don't. In fact, most of their behaviour was under your time as the industrial relations
No, I'm
minister.
not sure that's right.
So I don't know if you're in a position to sort of claim that you've got some high moral ground about clamping
Well, at least
down
I
on-
took action under Section
No, you didn't. You didn't do anything.
We did, in fact, take action under 424.
Against the CFMEU?
No, in relation to the RTB.
Well, I mean, I think the CFMEU would have been
so
the
we
one that-
actually took...
You probably should have taken some action on.
Well, we did. We were seeking to beef up the CCU, weren't we, Premier?
No,
Yes,
you weren't.
Premier, and in fact you dismantled that under your watch. So don't give me a lecture in relation to dealing with the CFMEU.
Well, there's
Order,
five.
order,
governments
order, I don't need your point of order.
Building
Mr.
Construction
Tudor Hope,
Commission and the
Mr.
CCU.
Tudor Hope.
Don't give me a lecture.
Order,
No, I'll
Mr.
give you a
Tudor Hope.
lecture.
I
I'm
want
happy to
ask
give you a lecture.
question or like
Well,
complete
Well,
decision.
there's 5,000.
Order,
There's five.
order, Premier.
no,
No, he
no,
hasn't
no,
asked a
yes,
question,
he
so
has.
there's nothing to
I'll ask.
respond to.
Let him
Mr.
get his
Tudor Hope.
question out.
Yeah, there was 5,000 construction workers out the front abusing me, not you.
Good.
So where are you on any of these
Let me
things?
just say, Premier, what is the point where you say the impact on the state by the actions of the ETU will lead you to intervene under Section 424?
Oh, look, I'm not going to answer the
Have
hypothetical.
you
I don't
taken
know.
advice in relation to that?
I just say that the system that we're developing in New South Wales, we believe, is better for the state. Now, whether that's got to do with union involvement for public sector unions, whether that's got to do with private sector unions, or some unions have got dual coverage. And as evidence of that, particularly in comparison to your time, hours lost to industrial action was 154 times higher under the former government. That's pretty devastating.
Well,
wouldn't you
over
say?
what period of time, Premier?
The last 18 months.
Well, leading up to the election. Is that
Yeah.
what you're saying? Yeah. Well, at a time when Mr. Murray,
but
when
isn't your
Mr. Murray said it was going to be the year of the strike,
But isn't
to
your
win an
supposition
election
that it's
for
worse
you,
now?
Premier, to win your election for you.
But isn't
it
your
was the
supposition
year
worse
of
now?
the
Order,
strike.
order. That's
sorry.
not a question,
And
Mr.
Mr.
Tudor Hope.
Namber
That is
over there
just
assisted him.
Oi,
I'm really sorry, but I thought the supposition of your question was that things are worse now.
order.
No, Premier. Well, I'm saying to you, you should be taking
Oh,
action
right.
under Section
Oh,
424.
sorry.
If you are
Oh,
serious
I thought you were
about-
presenting
are you
yourself
se-
as an industrial
Are you serious
whiz,
about
but in
delivering
actual fact it
housing
was a
projects,
mess.
Premier? You serious about that? Or you just, or are you allowing?
Oh, fair dinkum.
Or are you
You spent the
allowing-
first hour bagging out Rose Hill. Now you're all in favour of housing, are
I
you?
told you I was in favour of it.
All right,
But
you
I'd
could have fooled
I'd
me.
like the union to get out of the road, Premier.
I'm
Would you like the union to get out of the road so you can deliver these projects?
No, I don't
Well,
want
okay,
to launch
that's
a
fine.
war on
We-
the
we
union
get- we
movement.
get- we
but
get-
I
we
do.
get-
I think the government's actions over the last fortnight or last month speak for themselves. We took action in relation to the CFMEU. We introduced legislation to bring in an independent administrator. We kicked them out of the Labor Party. We made all of these decisions that you didn't
Haven't
take
paid the money
when
back.
you
So you're
specifically
gonna
and
pay- you're gonna
personally
pay
had
the money back,
responsibility
Premier?
for it.
You're going to pay the money back?
The money is not sitting
It's
in an
tainted
account.
money, isn't it, Premier?
Luke Foley paid back tainted money. Why won't you?
Tainted money from this union.
I'll tell you what.
Yeah, no, you don't.
When you guys pay back the money that you took from Darryl Maguire and John Sidoti and Gareth Ward, is that not relevant?
Premier?
Or the Millennium
Premier,
Fund? Or Operation Spicer?
These were the tainted money that you have received from this
Has the
union
Liberal Party
to
given
get
back
you
a
elected,
cent
to
in
get
its
you
entire
elected.
history?
You about your decision.
Well, isn't that? I mean,
So, Premier-
honestly, I will
Premier-
answer the question because I think it's important,
No,
Mr. Chair.
Would
The
you-
money's not available. It's been spent. I'm just trying to be incredibly straightforward and, transparent in relation
so was
to this.
Mr. Medic's money.
And the reason for that, Mr. Chair, was that the administration of the Labor Party, whether it's running conferences, whether it's running our extensive branch network, it cost money. They were affiliated to the party. When the charges were laid against the former secretary of the CFMEU, I made a decision to kick him out of the party, but it was in relation to his tenure or time as far as the charges were concerned. In the last fortnight, we went further. We made a decision to put in an independent administrator concurrent with the federal government's rules and regulations. And in the last 24 hours, you've seen mass demonstrations out of the front of the New South Wales Parliament condemning me and the government for taking that action. Now, I don't know what point you're trying to make. Is it that we haven't gone far enough or something?
Well, the ETU were supporting that action out the front of the building yesterday, weren't they?
They may well have been. I don't know.
Well,
I can promise you that it hasn't been universally popular amongst the trade union movement or the labour movement. I accept that, but I think the right decision was made.
So the ETU was out there fully supporting that action yesterday by the CFMEU, demonstrating against the decision which has been made by this Parliament.
Yeah, again, I'll make the point. It wasn't by this Parliament, by this government.
By the Parliament.
All right, you've come to the party pretty late then, haven't you, mate?
No, mate.
Yeah, this all happened under your time.
I was calling for the appointment of administrator well before you were in
Not when you were in government, not when it counted.
When these allegations were made, you took a long time to react. If I recall, it was over a week before a response came from you. Isn't that correct? And the decision...
They wouldn't even know your name, Damien. They wouldn't even... No one knows
the
what you
Fireys
did.
do.
He's Mr. January.
Can I just...
Maybe we get back to questions?
Order. As entertaining as that was, the flexing there by both of you, can we have some questions
honestly,
and some
thanks,
answers
Mr.
that
Chair.
are going to assist with our inquiry?
So the ETU, how many members of the ETU are sitting in your caucus?
I don't know.
You know?
No.
Does it concern you?
How many are in your party?
No members of the ETU.
No, any members of any trade union in the Liberal Party?
I'll ask the questions, Premier.
And you're trying to answer them as well.
What's wrong with being in a union?
Well, when unions don't engage in illegal activity, absolutely
that's
nothing.
Pretty unfair. Ordinary members get to cop it for the
absolutely
objects of the leaders.
But you tolerate it, though, Premier. You're prepared to stand there, take their donations, and tolerate the illegality. Isn't that the case?
It's huge.
Order.
No integrity.
Take the money.
Order. We're just having a series of comments, the not assisting the inquiry, not assisting the hearing. I think we should return back to questions.
I want to answer the question
and answers.
Mr. Chair.
And if we could desist from shouting over the top of each other, it's not assisting me or Hansard.
But in any event,
and
Mr. Chair,
no one is learning anything. So
we got a direct
an
question
answer.
about returning the money. I've been very clear and very transparent about the fact that it's not sitting in an account, and I don't want to write a cheque to the CFMEU. But this is particularly germane. The New South Wales Liberal Party's taken $45,000 from John Sidoti, $30,000 from Gareth Ward, and $31,000 from Darryl Maguire, and haven't returned any of that money.
Well, what are you?
Well, it's good for the goose, but not good for the gander.
What are you suggesting? What are you suggesting here, Premier?
I'm not suggesting anything, but you've come in and said that it's tainted money, it's corrupt money, it should be returned.
Because he's got nothing else to say.
Well, this is.
I'm all ears,
exactly,
mate. What's the answer? Are you going to return it?
Will you be prepared to adopt a policy in those circumstances where you would return the money from organisations like the CFMEU? Are you prepared to
As
adopt
I've
that?
said,
When
the
you
money's
first
not
came to
available.
Parliament, you wanted to do it.
The Liberal Party shouldn't dress themselves up as Lily White in relation to
We
this.
do.
They haven't returned a single cent or a dollar or anything from Operation Spicer to the ICAC inquiry into the MPs on the Central Coast, all the way down to Darryl Maguire. Proven corrupt conduct as it relates to findings from the ICAC, and you haven't returned a cent.
So Gareth Ward.
No, I'm not in relation to Gareth.
Well, so would you withdraw that?
I didn't say Gareth Ward.
You did. You wanted Gareth's donation to return.
Gareth Ward's donation should be returned if it's under the same guidance.
No, Premier.
Shouldn't it be?
Premier.
Well, hang on. This is important,
Premier,
Mr. Chair.
Premier.
The suggestion
Premier,
is that the donations from the CFMEU should be returned because the Secretary of the CFMEU is facing charges. Is Mr. Ward facing charges?
But bribery charges in relation to activity.
Okay, there's a distinction. Right.
Criminal charges.
Well, we know we're finding out.
So, so are you prepared to tolerate the activity which we saw on the 60 Minutes program, Premier? Is that activity?
I mean,
is that
action of the government for the last month would demonstrate that is absolutely not the case.
Pay the money back then.
Pay it back.
Pay it back.
Have some integrity.
Pay back the MPs.
Pay the money back.
And what about the Hills Shire?
Pay
How much
the
money
money
have you
back.
collected from that? I actually don't know. We should find out.
This goes to
Tens of thousands,
show,
I suspect.
Just goes to show how
absolutely
Point of order.
desperate
It
you
shows that
are.
you're a hypocrite.
Desperate you are
Order.
to
A point
protect
of order
your
has been taken
union
by
mates,
Mr.
Premier.
Namber.
They're your union mates,
Mr.
and
Tudor,
you're
Mr.
intent
Tudor,
on protecting them.
Order, Mr. Tudor. I call you to order for the first time. I think, or was it the second time? First time. The first time, Mr. Namber on a point of order.
Just the level of interjection is not allowing for this, for these estimates to be run in a fair and orderly manner, Chair, and I just asked that the...
Yes,
that
I uphold the point of order. The level of interjection, the yelling at each other, it's unedifying.
Premier.
It's not treating the witness with courtesy, and it's very difficult
Premier.
for us to understand what is being said
thank you.
and what is being responded
Premier,
to,
yeah, well-
and for Hansard.
well, in
So,
that
Mr.
case,
Tudor,
stop interrupting
please
me.
proceed.
Premier, in the budget there is provision, in fact, for public sector wages, is there not, for increases of 10.5% over 3 years? Is that correct, which has been allowed for in the budget?
Well, the government's wages policy is for that amount across the
Thank you.
public service.
How many public sector unions have accepted that offer?
None.
None. So, to the extent that none have yet accepted that offer, do you accept that that figure is at risk in terms of the budget bottom line if in fact the actual awards made to those unions are substantially or above that amount?
Oh, not necessarily. I mean, again, it's hypothetical. We don't know whether if it does get into arbitration in the Industrial Relations Court, what a finding would be.
Well,
We
let me
don't
just
know
ask you
whether-
this.
Oh, Mr. Chair.
Chair, point of
let me
order.
ask you
Apologies. Point of order.
It's actually a very good question, but I think the Premier ought to be afforded more than, a
2 words.
cursory
more than 2
response.
words.
You can't answer a question like that in a simple sentence, Chair, and I just ask that the courtesy be extended to the
Yes,
Premier to
I
actually
hold the
provide a
point of order.
substantive answer to a good question.
Yes, it was a good question. Please let the witness answer in full.
No, I'm not going to concede that. We don't know what the
Are you
final
cavilling
amount
with me? I
will
said it
be.
was a good question.
But I think that the government's entering into good faith negotiations with a whole range of public sector unions that represent the vast majority of essential workers in the state. And in the event that an agreement can't be struck between the union and the government, then it'll be set for arbitration in the Industrial Relations Commission. So, I can't speculate on it. We want to get good outcomes. We've agreed that the paltry amount that the previous government, and you were solely personally responsible for, was too little and it resulted in a massive decline in service
We
delivery
had
in the
real
state.
wage increases under our government.
Okay, so it was all fine.
So the Fire Brigade Employees Union reports that the government has not agreed to a single one. You're now proffering that you're a government that enters into good faith negotiations. They say that none of the issues which they have raised with the government in relation to those negotiations have been accepted by the government and will not move in relation to any claim above 10.5%.
Well, that may well be the case. I don't know. We're hopeful for an outcome, but we don't know. We don't have one yet.
Yeah, and arbitration is not due until March next year, is it?
Yeah, well, there's rules in place for the Industrial Relations Commission. The commissioners can exercise call-in powers, but I mean, we're hopeful to get an agreement. We don't have one yet, but as I said earlier,
Well,
I think it was important. Industrial disruption in the state has dramatically declined under Labor, which I think bodes better for our system of engaging and talking with the trade union movement than. I mean, I don't. A lot of them can't forget that during COVID, you didn't have 2.5% as a wages cap. You put it down to 0.
Yes. There was a
Good decision.
very good decision.
Okay, great.
So,
We'll be using that.
so it was a good decision at the time in circumstances.
Okay.
Well, you
Would you do
weren't
it again?
managing the budget
Do
clearly.
you reckon you do it
You
again?
weren't managing a budget
Do you
under
reckon you do it
COVID.
again?
You weren't managing budget under COVID, Premier.
Understood.
Clearly. And if you don't have any comprehension in relation to that, don't go giving me a commentary on it.
No problem. No problem.
So,
We'll bank that. That's fine.
what, bank incompetence by you?
Oh, there you go.
Order.
So- So, Premier,
Mr. Tudor, would you desist from making
Premier,
reflections on the
do you
witness's
concede that in
witness?
relation to the Fire Employees Union, mutual gains bargaining has been a failure?
No, of course
Well, tell
not.
me what concessions have been made by the government.
Well, we haven't got an agreement yet.
Well, it's the dispute has been going on now for nearly 6 months. What concessions have you made, Premier?
We haven't got an agreement yet.
Mutual
so I can't
gains bargaining, according to the union, has been an abject failure.
Well, the government's proposing to pay 40% more than the previous government was offering in terms of a wage outcome. We've got an independent industrial court in the state. We've removed the wages cap, and we'll abide by the arbitrated decision if that's what ends up being the case. Now, the only alternative. So I think that system works. I think it's working
give
well.
me one case. Give me one case where it's worked, Premier.
Well,
so far,
every public sector union accepted 4.5% in the first year. That was a good outcome, particularly with inflation being high. Second point I'd give you is that industrial disruption in the state, Mr. Chair. I would say industrial.
Order, Mr. Tudor, hope you asked
industrial
to
disruption
give you an
in the state
example.
is dramatically lower than under your period of time in office.
Have you reduced industrial action by the Fire Employees Union? Are they still engaging?
What was that?
Have you reduced industrial activity by that union?
Yeah, I'm not aware of bans that are in place at the moment.
Do they have an impact on the opening of the metro?
I'd have to refresh my memory on the reasons for the delay, but my understanding was that it wasn't directly related to the industrial action that was put on, but I'd stand to be corrected.
There is some impact that they had on the opening of the metro, wasn't there?
Well,
no, I'm not prepared to concede that. I'd have to check. There was a whole range of reasons why the metro was delayed.
Thank you, Premier, and thank you, Mr. Tudor. We'll turn to questions now from the crossbench. Mr. Borzak.
Thank you, Chair. Premier, your government's made a lot out of the electricity infrastructure roadmap and the delivery of the renewable energy zones. You've also made an agreement with Origin Energy to operate the Eraring power station until 2027. What was the detail of that deal, where it sits now especially? I'd
have to take the specifics on notice just because it's quite detailed, but, in general, the deal was that if there were to be profits as a result of the running of it, that they'd be shared to an extent, and that if the government or the state was required to step in as a result of the operation of it, that we would bear that cost. But all things being equal, and it may not be the case, but all things being equal, the cost to the taxpayer may well be zero, whilst at the same time having some kind of redundancy or safety in the system while we attempt to get the renewable energy roadmap back on track after it was, by common consent, a disaster under the previous government.
Well, should that power station have been sold off for next to nothing in the first place?
No, it shouldn't have. I mean, it put us at a massive disadvantage. And as a result of that sale, we had to enter into a negotiation with the private owners of Eraring. If it was in Queensland, it would have been far simpler and straightforward.
Yeah, it's interesting you talk about the potential for profit sharing, because that's not something I've heard before in discussion in relation to the deal the government's done.
Maybe Mr. Borzak, maybe Mr. Draper can
Sorry,
speak to it.
Mr. Draper?
I mean, in simplest possible terms, my understanding of the arrangement is that there's certainly a risk-sharing arrangement where, on the downside, the government would bear some costs where there were losses by Eraring, but the same would apply if there were gains made by Eraring.
Because Eraring is certainly, in my view, enjoying super profits at the moment in relation to what they're reporting. Would you agree with that?
I wouldn't know.
You don't know. Premier?
Yeah, I've just been given more information, Mr. Borzak. So Origin must choose to opt into the underwriting arrangement each year. If it opts in and makes a loss, the state will pay Origin 80% of the losses at a cap of $225 million. And the agreement's been tabled.
And is there any I guess what I'm trying to say, is there any level of operation? In other words, does it have to be 50% available, 75% available, 100% available all the time? Is there anything in that scale in your agreement, obviously?
I'd have to take that on notice. The agreement is in the public domain, but my assumption is that it'd just be based on demand in the marketplace. They'd be happy to sell as much as they can into the network.
Would the roadmap for the use of that particular power station continue past 2027 if it had to?
We're not committing to that. The reasons for that are that we hope to get the renewable energy roadmap back on track, and there's redundancies as far as Eraring is concerned. I mean, it's at the end. I think I'm right in saying it's at the end of its life in any event.
Yeah. Okay. Thanks. So what are delivery dates and costs for the renewable energy zones? Can you quote those to me? You should have it on the top of your head.
I don't. I'm sorry. Sorry, Mr. Borsak. Under the RES, the New England RES, the timetable has changed from an expected completion date of 2027 to 2029. But in fairness to the government, that was established following the conclusion of the election campaign. We didn't realise that we were so far off track when it comes to...
So then that goes against a bit of your previous answer in terms of the availability of Eraring past 2027, does it?
No, not necessarily, because Central West Arana should be online by 2027.
Okay. Sorry, I interrupted you.
Yeah, no, so Central West Eraring 2027, New England RES timetable change from 27 to 29. But the truth is we've got to get a lot better and a lot quicker with the whole range of issues in relation to electricity generation for renewable sites. The RES process, planning, approvals, transmission lines, connection to the grid, it's all slow, and it's all too slow, and unless we can get those margins down, then I'm just being honest about it, we are concerned about power shortages.
Yeah, I have a few more, but I might, if I get a chance, come back to them. Thank you.
Mr. Latham.
Premier, given that Mr. Volandes lied to or misled the Upper House inquiry on Rosehill about his interference in stewards' inquiries, do you still have confidence
Point of
in
order.
as the CEO of Racing New South Wales?
Point of order's been taken by...
yes, you do. Okay.
Point of
No,
order's
the
been
question's
taken
been
by...
answered.
Point of order's been taken by Mr. Namber.
I was merely going to say questions shouldn't reference or raise a debate from an unreported committee hearing.
Oh, that's rubbish. That's nonsense.
No, I'm unfortunately, Mr. Latham, it's not rubbish, so I do uphold the point of order.
Well, an answer was given. Premier, before the election you said you were going to deal with the problem of fat cats in the New South Wales public sector. How did Mr. Volandes escape your dragnet? In the middle of a cost of living crisis, how do you, as the head of government, justify his salary and bonuses of $1.5 million per annum for someone doing a part-time job, given his commitments at rugby league and also looking after his private business interests?
Well, again, this question and the last question was full of suppositions dressed up as absolute facts. And the previous question said that Mr. Volandes lied or misled the committee. There's no evidence being supplied that would prove that charge. It's just we've just got to rely on your word for that, Mr. Latham. The suggestion that it's a part-time job, that he's not putting in his full time and effort, again, no evidence supplied. So there'll be many people in the community that would have a chief executive's job as well as serve on a board of another organisation or corporation or unincorporated entity. I mean, that's not novel, and it's not novel in relation to corporate life in New South Wales or Australia. So again, most of the questions that you've asked have been dressed up with some kind of, I would say, slur at the beginning, but again, no proof has been provided.
Yes, and I would just remind you, Mr. Latham, that adverse mention of third parties who are not here to respond is against the standing orders.
Well, Premier, as part of your attack on the problem of fat cats in the New South Wales public sector, will you now investigate the earnings of Mr. Volandes at Racing New South Wales? Because the $1.5 million per annum is 50% higher than anyone else in the New South Wales public sector and clearly inconsistent with your government's policy.
Well, look, I'm not going to commit to investigating on the basis of uncorroborated information that you provided at the beginning of your questions, other than to say that there's systems in place, regulators in place, and independent bodies that are responsible for administering a whole range of agencies, including Racing New South Wales.
Well, not for his salary. The so-called independent body has him on it. Shouldn't this now be handled by the Remuneration Tribunal, which is independent?
No. I mean, there'd be a whole range of positions in the New South Wales government that don't have sort determinations. I mean, I can't list them now, but they'd be littered across the 400,000 public servants in the state.
Premier, somewhat to the surprise of the committee, the Upper House members of the Rose Hill inquiry received numerous whistleblower submissions and information about Racing New South Wales. There are current and former senior staff who, for the first time, have been able to speak the truth without losing their jobs. They've detailed a range of atrocious working conditions and problems.
Sorry, point of order, Chair.
Racing New South Wales has admitted to surveilling its staff.
Point of order has been taken. Mr Nanver on the point of order.
There is a clerk's advice that states clearly that questions should not raise or debate unreported proceedings or deliberations of a current committee inquiry. So I ask that you rule the question out of order.
We'll just take some advice on that.
It's amazing the Labor Party's happy for all this to be happening.
Just standing
why
orders
would you
and
defend these atrocious
not
conditions?
defending them.
Why would you do it?
Not defending them.
Can you repeat the question, Mr Latham?
Yeah, to the surprise of Upper House members, and I've received this material directly myself, there's been a range of material put forward pointing out atrocious workplace conditions at Racing New South Wales. Racing New South Wales itself has admitted to surveilling its staff using CCTV footage and web traffic and email checks. These other individuals have provided evidence of a
Mr
toxic
Latham, I was asking you to repeat the question so I could rule on the point of order, and that is that those matters do not appear to be unreported. So once the matters have been the subject of, they're made public, they're reported, therefore they can be referred to in this inquiry. So I don't uphold the point of order.
Okay, well, thank you. The further problems are financial and department reports have been doctored, nepotism and favouritism are rife, trade union membership is banned, staff turnover is high, particularly among stewards. There's coercion for staff to show their private WhatsApp messages to management. There's no HR department, and employees live in fear
a lot of supposition
retribution for these
again
things.
Dressed up as fact.
Well, as a Labor Premier, are you going to order an independent inquiry into these work practices at Racing New South Wales, or you don't care less?
Well, you can make that claim, but ultimately, for me to say yes, it would rely on your word.
Well,
and you're in the midst of several defamation proceedings.
On a point of order,
at the moment,
and this goes to the entire evidence the Premier has presented. He's come here with a deliberate tactic to require authenticity to every single thing that's said, even though committee members and your own members of the committee would not object to any
What else am I supposed to base it on?
You can't
I mean, heaven forbid, Mr Chair, I'd have to rely on facts.
These are serious
Mr. Nanver,
matters.
to the point of order.
Heaven forbid that I'd rely on some facts or presented some evidence.
We are presenting you with
Order,
facts, and you
Mr.
won't answer to
Latham.
them.
Order,
Sorry,
Mr Nanver on the point of order.
To the point of order, there is a current parliamentary inquiry into those matters. Those matters are in the form of confidential submissions to that inquiry, and they are all unreported.
Yeah, I uphold the point of order. It's very difficult for me to know whether or not those matters are reported or unreported, so I'm going to err on the side of caution and uphold the point of order.
I think this is an opportunity to slur Mr Volandes under the cover of parliamentary privilege. I mean, look at some of the stuff that you've said already. Fraud,
Premier, the question's been ruled out of order, so we don't need to hear anymore. And now we'll turn to questions from order. Mr Latham, come to order, please. Premier, please come to order. The question was, I've ruled the question out of order. We'll now turn to questions from the Greens. Ms Cohen.
Doctor. Good morning, Premier.
Doctor.
Thank you.
Sorry, apologies.
Earlier this year, you made an apology to people who'd been impacted by the criminalisation of homosexuality before 1984, which was an extremely moving day that many people were really grateful for. And you were also the first Premier of New South Wales to ever march in the Sydney Mardi Gras parade. These gestures are really important and they have huge value. And they've also given people across New South Wales hope that those gestures would be followed up with legislative change. In New South Wales, the Anti-Discrimination Act doesn't protect a whole range of people who are non-binary, people who are asexual, people who are bisexual, like me. Do you support changes to the Anti-Discrimination Act to provide those protections?
Well, we have made changes. We have made legislative changes since being elected to office. We've made legislative changes in relation to conversion therapy in the state, which was a promise prior to the election campaign, one that we fulfilled, and we've pursued other changes to the law as well. Anti-Discrimination Act changes. I can't give a blanket answer that we will change it in line with what some activists insist is necessary. The reason for that is that, there's many reasons for it. But my understanding is that the Anti-Discrimination Act is being reviewed. I expect the result of that review to be presented to the government and therefore to Parliament in the time ahead. I have to come back to you and take on notice when that would be, but they're not straightforward changes to the legislation.
Yeah. So the members of the Labor Party who marched with you in the Mardi Gras, and it was good to see so many there. They were wearing T-shirts that said "Labor, a future free from discrimination." What did that mean? What are you promising to LGBTQI communities?
Well, as I said, we pursued and implemented changes to the law in relation to conversion practices in New South Wales, and there's several bills on the books to be debated in the LA and the LC, and we'll get to it when we get to it.
As I'm sure you're also aware, New South Wales is the only state in Australia that forces people to have medically unnecessary and violating surgery just to be able to change gender on their forms. Do you support changes to the Birth, Death and Marriages Act to bring us into line with every other Australian jurisdiction?
We're looking closely at that potential change as well, and I realise that it's a priority for those that are impacted by it. I accept that, Doctor. I don't have an announcement about it today, and when I say we'll get to it when I get to it, I don't mean to be callous about that or flippant. I shouldn't be. It's obviously of major concern for those who are calling for a change in the law, but we don't have a decision in relation to it, and we're examining all of those policy matters closely.
The board of the Sydney Gay and Lesbian Mardi Gras has written to every member of Parliament. I got that letter, and I'm sure you did too. The couple of legislative changes that I've just asked about were among a list of legislative changes that they're actually demanding from MPs to be able to march in the Mardi Gras parade next year. They've been very clear that for people to support the queer community on a good day, they need to be ready to support us on a bad day as well. We're now preparing for the Mardi Gras parade in 2025. Are you intending to march in the parade in 2025, and are you intending to make this progress before then?
I haven't even thought about it, and I mean it's up to the organisers who they invite, not up to me.
Will we see progress on any of these changes before Mardi Gras 2025?
I can't give a timetable right now. I mean, we're examining potential legislative change, but I don't have an announcement today at the committee meeting.
Sure. I understand it's something your government might be considering, but you're the Premier. The people of New South Wales are interested in your view. Do you personally support those changes?
Yeah, I want to examine it. I mean, there's going to be some issues that we do come to this committee and can't give answers to because they're under deliberation by Cabinet, and this is one of them.
I'll go to my colleague.
Thank you.
Thank you, Doctor.
Thank you, Chair. Good afternoon, Premier. You said this morning, as well as on 2GB, that the Federal Environment Minister made an error in ruling against a tailings dam for McPhillamys gold mine being constructed on the headwaters of the Belubula River. Why did she make an error?
Well, the entire project was already assessed by the Independent Planning and Assessment Commission in New South Wales, as well as government departments in the state. They assessed all of the issues, all of the legislative and regulatory issues around it, and made a decision that it should go ahead. In large part, the decision in relation to the tailings dam was taken on, my understanding is, on the advice of the Orange Aboriginal Land Council, which is the elected body in that part of the state, who made a submission that they didn't regard it as intangible Indigenous cultural heritage. And I think they went further than that. Maybe if we could get a copy of the letter.
And
So the decision was made by the not without evidence, but it was assessed against the elected body in Orange.
Just based on one Aboriginal groups, this is how you're making a judgment that the federal environment minister with responsibility for Aboriginal heritage has essentially said build the tailings dam elsewhere. You say that's an error. So
it's not. Again, Mr. Chair, it's not my judgment. This was the judgment of the Independent Planning and Assessment Commission. And I think that was the correct decision.
You said today, and on 2GB, that Federal Environment Minister Tanya Plibersek made an error. Why?
Well, I've explained it many times over. The decision was assessed by the Independent Planning and Assessment Commission in New South Wales. They took into consideration the evidence and advice in written form from the Orange Aboriginal Land Council, which is the elected body representing... Hang on, I'm going to finish this,
Premier,
Mr. Chair.
There's other
and under those circumstances...
Aboriginal groups as well that feel
I appreciate that, but a judgment
differently.
needed to be made. I think the correct judgment was made in the initial instance. I mean, this is the thing. If you come and ask a direct question, I will give a direct answer, but the circumstances are straightforward as far as the government.
So, Premier, are you aware? Did you look into what significance this has for the Aboriginal community? So, for example, the rivers where they meet. There's 2 rivers historically. There's 22 springs on that headwater. At that headwaters, that is going to be permanently blocked. 22 springs at the headwater. One Aboriginal stakeholder has said that area is called Billa Bula, which means rivers too. It was a very significant gathering place for the elders. They are incredibly concerned about the fact that the tailings dam was going to be built there, lots of artefacts scattered. Why did you tell 2GB and this inquiry that you think that's an error based on one?
Mr. Chair.
So you.
But is it outrageous that we would accept, or I would regard the written advice from the Aboriginal Land Council in the local area that suggested that it wasn't intangible Aboriginal cultural heritage on the site?
But there's other Aboriginal.
I appreciate that. So a judgment needed to be made.
So you are.
And
also,
I didn't make that
what
judgment.
You also
the
said,
local Aboriginal Land Council
Premier,
did, and the Independent Planning and Assessment Commission did.
What you also said, my time is very limited, this morning when you were referring to the need for the mine, you said gold and other critical minerals. You are aware that gold isn't a critical mineral,
gold and
don't
other
you?
critical minerals. I said that several times.
No, you said gold and other critical minerals. Gold is not a critical mineral.
But it's still an important component part for renewable energy, export-oriented resource opportunities for the state. It's not on the critical minerals list. It's crucially important for the future economy.
It's not on the state or federal critical minerals list. It's not on the state or federal. Well, speaking of importance, were you aware, in terms of the Belubula headwaters, that 22 springs that feed into Belubula River, feeds into the Lachlan River, the Murray-Darling Basin system?
I mean, I wouldn't rely on my advice in relation to it. What I would suggest that you do, what I would suggest that you do, is go and speak to the Aboriginal Land Council, who made a submission to the IPC. Or not, or don't do it.
Thanks, Premier. I have spoken to Aboriginal stakeholders in the area who I've just read out. In any event,
I don't want the impression to be left that this is an exclusive judgment of the New South Wales, or me, or the cabinet. This was made by the Independent Planning and Assessment Commission
Premier, you seem
on
very
advice
vested,
from the elected body.
You seem very vested in this, hence why I'm asking you questions
I am vested
about
in it.
You also said that the mine would bring thousands of jobs to the area. Where did you get that from? Because in fact, the jobs, there's 710 construction jobs, 260 operational jobs going forward. Where were the thousands of jobs coming from?
So, I may have misspoke, it's in the hundreds, but critical minerals, and in terms of the investment pipeline for capital in the state, is dependent on certainty that once you get through the state planning panel, the project will go ahead, and this does imperil that. But there's an important follow-up to the question that was asked of me, and this is a letter from the Orange Labor Local Aboriginal Land Council. It's dated 9 January 2023, and it says, "It's a matter of concern to the OLALC that a range of claims have been made on this issue by people and organisations lacking the experience, expertise and authority to hold themselves out as authorities on Aboriginal cultural heritage. We question the motives of people and organisations who participate in promoting unsubstantiated claims and seek to hijack Aboriginal cultural heritage in order to push other agendas."
Thank you,
What
Premier.
agenda are
Now
you
we'll
pushing,
turn to
Premier?
questions from the opposition. You've got 2.5 minutes.
Thank you, Chair. Premier, is it unusual for an ED in a department to have a security pass that gives them direct access to a minister's office in 52
Sorry, can you
24/7?
repeat that again?
Is it unusual for an executive director within a department
Executive director.
to have a pass, a security pass that gives them access in 52 Martin Place
I
24/7?
would have no idea. I don't know what the
Do any of
security
yours
arrangement
have any of your EDs in your department have access to your office 24/7?
is. I don't know.
Oh, I can only say that when I was an executive director in the Department of Premier and Cabinet, I had a pass that let me into ministers' offices. That was about probably 10 years ago. But
Okay.
yeah.
So we've heard in evidence yesterday that Adam Tyndall, who's an ED within the Department of Primary Industries, that he's had unfettered access to the minister's office. Do you think that's unusual?
Oh, clearly not, because he had it under the previous government.
Did he get it because he's a member of the Labor Party, Adam Tyndall?
Oh, God.
How grubby, honestly.
Sorry, what was your answer, Premier?
I don't think Mr Draper said he was a member of the Labor
No,
Party.
Mr Tyndall is, though.
Oh,
I'm just
Mr.
wondering
No, the
whether
question
Mr
is-
Tyndall got it.
This is pretty funny, but the question was, is it unusual for executive directors to have access? Mr Draper's just
Yeah, and
suggested
I've
to
just
the
asked
committee
you,
that he
I've
had it
asked
under
you a
the previous
follow-up
government.
whether Mr Tyndall got one because he's a member of the Labor Party.
I think this is a backhanded way of exposing, if that was the case, that he was a member of the Labor Party. I don't even know if he is, but mission accomplished. Good for you.
So, Premier, the last time you were before us, you told us that you were able to negotiate a GST agreement in recent weeks. But shortly after that, your Treasurer was telling us and everyone else who would listen that his budget is ruined because of a bad agreement and bad GST deal. Was that the GST deal that you were talking about, that you negotiated?
They're separate arrangements. The agreement that was reached at the National Cabinet related to the extension of the No Worse Off agreement of the GST. The issue of the New South Wales government missing out on GST revenues has to do with the relativities as determined by the Commonwealth Grants Commission, which we're getting absolutely screwed on, but one's not related to the other.
The only deal that you, in fact, were able to negotiate was an extension of the agreement which had been negotiated by the previous government.
Well, no, because the previous government's agreement expired after 3 years, and then it fell off a cliff for New South Wales. So, I mean, look, whatever. It's not the crowning achievement of the government. I don't think we were scrutiny, and I barely remember announcing it.
Thank you, Premier. Mr Tudhope, unfortunately your time has expired. We've just got 2.5 minutes for me. Premier, you'd be aware that since the 2000s, petroleum exploration licences were rolled out across New South Wales and then rolled back under principally under the previous government. That they used to cover about 70% of the state. Now they only cover a tiny fraction of the state. Why did that happen?
I couldn't give you an answer.
Is it possibly because of community opposition and worries in the community that coexistence with unconventional gas and fracking and CSG couldn't exist?
That sounds right.
So why is it that you said in your previous answer that you thought that coal seam gas and the Narrabri project could coexist with farming on the Liverpool Plains? Why is it that for the rest of the state, even though there was petroleum exploration licences over Sydney, over Newcastle, Wollongong, the South Coast, the North Coast, that it was deemed unsafe there and rolled back and couldn't coexist? The government's position is that it can coexist in our most critical biophysical strategic agricultural land.
Well, look, I'm not responsible for the rollback of those decisions that were taken by other governments in previous administrations. The point I was taking issue with was that, like a lot of the questions that I've had today, is the question is premised by a statement of fact, and that is, in your circumstance, that the two couldn't coexist. Well, okay, well that's your evidence. Mary
What's your
O'Kane.
view? What's your view? Your view is that they can.
Yeah, Mary O'Kane wrote a report to the previous government. Is she not an eminent person?
She's a very eminent person.
Wrote a report to the previous government suggesting that they could.
Is that what she?
And again,
you don't think there were conditions, that recommendations?
Of course
that
there were, but I'm not suggesting.
Have those recommendations of the chief scientist been implemented?
Well, the recommendations of the chief scientist's recommendations haven't been implemented as far as the project hasn't started or hasn't progressed for many years now.
Thank you, Premier. Well,
I think
I'll
they do
take
generate,
that as
they do generate
the end.
electricity, but
So, well, I'll
on a
just
small
ask one
scale.
question.
Oh, sure, Mr. Tudo. Why not?
Just
one more.
the GST agreement that you negotiated, has that been legislated?
I don't think it requires a
It
legislation,
does.
but I can take it.
It does.
5 seconds.
It does.
All right, thank you very much, Premier and officials, for your attendance today. We very much appreciate it. I assume that the government's not
Again, very satisfied.
very satisfied. Thank you very much, everyone.
Easily pleased.
We will return at 2 o'clock. That's correct? Thank you. Everyone, let us recommence with the Portfolio Committee number 1 hearings into the expenditure for the areas of Premier. Thank you for coming back. Before we resume the questions, I need to ask the additional witnesses to be sworn. So we'll start on my left with Miss Ma. Could you please each state your name and position title and swear either an oath or affirmation. Thank you.
Thank you, Chair. Good afternoon. Kate Ma, Deputy Secretary, Community Engagement Group for the Premier's Department. I solemnly, sincerely and duly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Ms White.
Hello, my name is Gillian White. I'm the Deputy Secretary in the Cabinet Office for Social Policy and Intergovernmental Relations. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you very much. Mr Ray.
Thanks, Chair. Marcus Ray, I'm the Deputy Secretary, Environment and Economic Policy in the Cabinet Office. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you, Mr Ray, and thank you all. We'll now recommence with 20 minutes of questions from the opposition. Mr Tudor, hope I assume.
Thank you. Ms Boyd, great article in the Law Society Journal.
Thanks for bringing it up, Mr Tudor.
I'm surprised you had time for such a long article. It's very complimentary, but I have to say that it doesn't do you justice.
Great photographs as well.
Great photographs. Ms Boyd, did the Secretary for the Department of Education seek your advice in relation to the SO 52 and the production of documents relating to school funding?
Not my personal advice, although the Cabinet Office's advice may have been sought. I'd have to take that on notice.
So, you're potentially unaware of the specific standing order relating to school funding, but the answer came back that the information would have to be provided by way of GIPA. That would not have been advice that you would have given, would it?
I wouldn't have thought so, because SKIPA doesn't in any way curtail the power of the Legislative Council to call for papers.
Yeah, so, in fact, the Secretary yesterday, Mr Disdar, in fact, admitted that the response to the SO 52, in which the advice was directed to the member, should be obtained by GIPA. He acknowledged that that was in error.
Yeah, I think sometimes we've recommended that the informal release pathway under GIPA is sometimes a helpful one, particularly when members are seeking electronic access to documents, which is not something that is able to be provided to
And
the
that
House.
might be the misunderstanding, because I think the nature of the document, by virtue of the size of the document, may have been better provided by way of an electronic document as opposed to the production of a physical document would have been very difficult. Yes. And because of the nature of how the document was stored, it didn't lend itself necessarily to production of a physical document. It should be.
And I think electronic production or access is able to be provided under GIPA in a much more controlled and authorised way, I would say. By agencies. So we often do find agencies going back to members and saying, look, happy to provide you with proactive release of this document. You're able to come to our offices and view an electronic version of the document.
So this is obviously an area we've traversed before, and I know you have a view. In terms of the amount of documents that are being sought, you've always had a view in relation to that. Are you of the view that we should be moving now towards the electronic production of documents rather than the physical production of documents?
Look, I think there are definite advantages to electronic production in terms of efficiency and transparency, but I would note that there are countervailing privacy, security and other concerns like that that would need to be really carefully thought through, given the volume and nature of the sensitivity of the information that is currently provided to the House under Standing Order 52.
Yep.
So if there were appropriate controls and security over those documents, and we could ensure that they were no less secure than they are when they are held by government, I think we would have no qualms about proceeding with electronic production. But at this stage, that is not the environment.
But it could be done, couldn't it?
Yes.
Yeah, I know when I was on the other side of this equation, and you were providing the previous government with advice, and those opposite, of which Namba wasn't in the Parliament at the time, but those opposite were seeking to exactly ask the same questions I'm now asking. The same sort of concerns were being raised in terms of making sure that privacy issues and confidentiality was adequately secured. It can be done though, can't it?
Yeah, and we've been working really closely with the clerk's office to ensure that they understand what level of security protocol we would insist on before we provided electronic access to state papers. So there's been a really good dialogue, as there always is, between the Cabinet Office and the clerk's office on this issue. I think the challenges are that, that would require a significant uplift in the infrastructure of the Parliament in order to ensure that there's a secure portal for members to view these state papers. And given the, cyber risks, foreign interference risks, privacy, there's a lot of reasons why that would need to be carefully done before we opened up electronic access to Standing Order 52.
Except that there probably a lot of these documents are currently held electronically in the relevant departments from whom they are being accessed, because what is now occurring, of course, is that the order of the papers is made, the departments go away and then produce thousands sometimes, not often, because we're very scrupulous about and targeted in terms of the papers that we seek. We don't go on fishing expeditions and those sort of things, but the process at the moment is moving from electronic versions as they're currently held, producing the paper, and then all the work that entails. And often the argument about Standing Order 52 is the amount of departmental time that is taken up in complying with the order.
No, I acknowledge that the manual printing of documents is a hugely inefficient process, but I think we would have to ensure that the information was as secure as it is when it is held in departmental systems.
So
when it goes
if
to
I
the
was
House.
to ask you for some sort of timeline about where you could reach, or a situation where documents could be produced electronically, what am I looking at?
I think you'd have to direct that question to the clerk's office and understand where they're at in terms of their systems. It's really their systems that need to facilitate.
And that may require some additional funding, would it, to upgrade that infrastructure? I think
It may.
I think that's what you're suggesting is that potentially the software attached to would need. Have you been able to identify the software which would give the requisite level of privacy and security?
I can take that on notice. I don't think it's a software issue, like one single bit of software. I think it's the whole infrastructure around cyber security that we'd really be looking at. And there are some objective standards for that we've shared with the clerk's office over the years as to what we would look for before those, the government would entertain electronic production.
There is a memorandum M2015-05 relating to the publication of ministerial diaries and release of overseas travel information. It's still in force, is it not?
It is.
And there's a couple of things about that. That's a mandatory compliance document, is it not?
That's correct.
I just noticed that it was issued on the 30th September 2015. Were you involved in
Yes.
at that time, the reduction of this memorandum? And it was due for a review on the 30th of July 2024.
Yes.
Is that currently taking place?
I don't know that it was due for review, but I think
It says here review date.
I think I'd have to double check
30th of
that.
July 2000.
I don't know that that's accurate in terms of a government review. I think on the ARP system there's always a notional review date for the internal business unit that's responsible for the memo to sort of check that it's still relevant and valid. It's not like a government review of the issue.
I accept that. So has the internal review...
I can take that on notice and check, but it generally is the practice after an election that we would present all of the current memoranda to the Premier and just seek the current government's endorsement of the existing administrative requirements.
There are various things that are required in relation to the publication of diaries, and they include, just let me get to the relevant, but it includes the nature of the meeting, does it not?
No, you have to list the organisation and the purpose.
And the purpose, and the person with whom is attending the meeting.
I think if you're attending a meeting with someone in a private capacity, you list the individual, but if it's with an organisation, you list the organisation.
Well, it provides this. The published diary should include details of all scheduled meetings of a minister involving the discussion of a matter that may be considered by a minister, whether formally or informally. So, a meeting which was recorded as a meeting with ATC, meet and greet, does that comply with this
I think if
disclosure document?
If you look a little bit further up in the memo, it just says the organisation and purpose, and then the section that you read out is really going to the kinds of meetings that need to be disclosed.
Well, okay, well then you're obviously very familiar with this document.
Yes.
Ministers must publish summaries in the attached form 1 month after the end of each quarter, and that's a document which we do have. But then the summary should disclose the organisation with whom the meeting occurred, or if the individual is attending in a personal capacity, the name of the individual and the purpose of the meeting. Do you say that the diary entry, which for the 30th of October 2023, relating to the meeting with the ATC, complies with this?
It lists the organisation and it says that the purpose was meet and greet, so it would appear to satisfy those two requirements, yes.
So you would say that meet and greet was sufficient to cover a discussion relating to an unsolicited proposal relating to the redevelopment of Rosehill Racecourse?
I won't express an opinion about the quality of the disclosure, but I will say that the memo requires the organisation and the purpose, and the level of detail that the Minister wishes to go into is really a matter for the Minister.
So, well, does someone in your office actually review the diary publications before they are actually produced?
No, that would not be our role. No, I think the Minister's office maintains the Minister's
diary. So
diary.
it would be a ministerial responsibility to cover that material?
Yes, I would think so. I mean, we're always available to provide advice on the interpretation of memos and circulars, but we would not generate the return or review it, no.
Mr. Draper, you were involved in the issue of the circular relating to the return to work of people in various departments who had been working from home, or I call it colloquially the working from home memorandum.
Yeah, I was. I just don't use the term return to work because that's got another meaning
No,
to
sorry,
the people who are
you're quite right.
Yeah.
It's the back to office, requirements. Did you have consultations with various departments before issuing that circular?
We had a number of discussions with secretaries. So we have a secretaries board, and we discussed that for quite a long time, probably over the course of probably 8 months on and off, before we settled on an approach.
Yep, before you settled on the actual release of.
Correct.
Did the various department secretaries disclose to you the numbers of people that they had who in fact were working 3 days or more, less than 3 days or more in the office?
No, I never asked for that. It wasn't really the nature of the discussion we were having.
Well, there must have been some disclosure of the issue which gave rise to the issuing of the memorandum, because clearly there was dissatisfaction with a number of people who had elected to use this very flexible arrangement in relation to their working arrangements. So you must have a concept in your mind that there were too many people not working in the office.
There were two considerations. One was consistency across government. Clearly we have a body of, or actually the majority of people who work in the public sector who can't work from home at all. So that's one thing. Then a number of departments over
That's
the years...
85%, I think.
Yeah, that's right. A number of departments over the years had their own approaches to people who could work from home and how much they would work from home. So there was the question of consistency across the government sector. And the second thing that brought this up to my mind was really a discussion about what our approach would be to office accommodation, how much office accommodation we'd need. And we couldn't really settle that matter until we had a view about what sort of work patterns we would expect of people. They were the two considerations, but I never asked the secretaries for information about the number of days people working in the office on average or as a distribution.
Well, then how do you gauge success?
I don't need to gauge success. So
you must have the number of people who are actually rearranging their work lives to comply with the memorandum.
It's just like any other condition of employment we have, or any other policy that we have. We set an approach, and then it's up to each organisation, each team in those organisations to then manage that, have the discussions with the people who work in those teams, and then apply that within their own workplaces.
Well, the manner in which the media were reported this after the issue of the circular was that would happen the next day. But that was never your intention. Is that what your understanding is?
Yeah, I've said that in the media myself.
I've heard you on the media.
Yeah, no, it was never going to happen that we issued the circular one day and at midnight the next day people would have to change their work practices.
Yeah, but do you agree with me that some of the media reporting and the announcement relating to this was that it was an immediate requirement that those people who are not working 3 days would in fact come back to the office?
Yeah, I haven't carefully reviewed all the media, but I think there were some that gave that impression. But it wasn't. That didn't come. If anyone who read the circular itself probably wouldn't have got that impression.
So, what is your expectation then of the rollout by each of the individual departments of compliance with this circular? Would you expect compliance by the end of this year, by sometime next year? What is, and was that part of the discussions which you had with the various secretaries relating to how it would be implemented?
I think the expectation is all departments and agencies are working to implementing this circular. So what it requires, to go back to the first part of your question, is that agencies develop their own policies that meet the requirements of the circular. Our own departments, the Cabinet Office and the Premier's Department, have collectively done that. We've prepared a draft policy. We've issued that to our staff about a week ago, and we're consulting on it. We've got about another 3 weeks to run on that consultation.
Well, in relation to your own department, how many people, staff, do you say this impacts?
I think it impacts all staff.
No, well, so you
Applies
say
to all staff.
All staff
Yeah.
are working. There is a component of them working from home more than 3 days.
No, we would have staff who can't. It's not a question of 3 days. That's not. We have. There's nothing in any of the documents that we've issued, but either the circular, the policy, or any statement I've made that refers to 3 days. That's not what it refers to. We would have people in our department, in the Premier's Department at least, I'm not sure about the Cabinet Office, people who cannot work from home, they have their duties require them to be at a workplace in order to, as a fundamental requirement.
Yep.
There would be others, most other people have had some degree of access to working from home. In fact, as you know, we were all commanded to work from home during COVID, and then when those public health orders were lifted, different agencies had different approaches, and different individuals also had different approaches. Everyone's made that work. I'm not at all critical of the public service, just the opposite actually. I was in the public service at that time, and I think, and you were in government at the time, I think we can all be proud of what the New South Wales government achieved during that period. That's not the reason we're doing this, but we haven't got any reservations about particularly individuals or anything of that nature. We just have an expectation that this applies to all staff, and that be discussed in teams as to how they will apply it.
But is there any process though that you're adopting for the purposes of assessing how this is actually going and the number of people who are impacted by this decision, who will have to alter their current working arrangements?
The two things that I think we will keep an eye on, firstly, implementing our own policy in our own departments, which, as I said, we're working on. And the second would be that the other departments also implement their own policies. We don't need to micromanage that process themselves. They've got their own secretaries or agency heads who will do that. So that's the measures that we will apply.
So how will you know about additional office space, for example, that you may need? So that was a part of the discussion which you identified as having been had with secretaries prior to the issue of this circular. How do you know, without knowing how many potential staff that it impacted, how much additional office space you may or may not need?
So I think once the policies have been implemented and agencies have had an opportunity to go through their own implementation plans, we'll have a much better idea of whether it impacts our needs for office space or not. There actually is, we're a long way from having fully utilised the office space we have, and it's quite possible that we will be able to more effectively utilise that office space as well. We've had, just as part of our consultation process with our staff, we've already had some really great suggestions about approaches that allow people to better book their workplaces for the day. That also helps people who have caring responsibilities, so they don't have to rush into the office in the morning to secure a desk. They can drop their kids at school or other things that they might need to do. So once those things are rolled out, policies have been implemented, we'll have a much better idea, but that won't be for many, many months.
Thank you, Mr. Draper. Thank you, Mr. Tudor. Mr. Latham, you've got 10 minutes.
Thank you, Chair, and thank you, Ms. Boyd. If I can ask some questions stemming from the major involvement of the Cabinet Office with the development of the Rosehill unsolicited proposal. The Premier earlier today was critical of the traditional bottom-upwards development application process, where he said there's 1,000 different hoops for applicants to jump through, and it seems like this Rosehill USP has been developed as a new way of getting housing moving in Sydney. Can I ask, is any barrier to a company like Lendlease or Mirvac lodging an unsolicited proposal for major housing development in Sydney?
No.
And they would just need to meet the guidelines set out in the USP document that's available on the website, the three major criteria being it's unsolicited, there's a commercial benefit to government, and it's unique.
Yeah, the uniqueness criteria would be the most significant there.
What's unique about Rosehill?
I think the fact that the ATC has quite a substantial land holding is probably one of the criteria, but again, the government has not seen any proposal from the ATC, so we don't know what they will be saying in terms of...
Haven't they lodged the first stage of the...
Oh, sorry, I haven't personally seen that.
You haven't. Mr. Draper, what's unique about Rosehill as specified in the ATC first stage?
Yeah, Ms. Boyd is onto it. So the scale of the housing supply that can be generated from that site coinciding with the fact that we have a metro line running directly underneath that site. You don't find that very often. That does bring an enormous benefit that has been evaluated in stage one as potentially bringing a great benefit to New South Wales. That's being now re-examined as the details are worked through in stage two.
Right, but it's not the first time a racecourse in Sydney has been converted into housing, is it? It's far from unique when you look at Rosebery, Kensington, Harold Park, many others. It's happened over many occasions over many decades, hasn't it?
None of them had a new metro line running in, as far as I'm aware.
Well, there's no guarantee of a metro station, is there?
There's no guarantee, and there's no guarantee of no guarantee about any of it. It's a process. A proposal's been submitted by the ATC. It's been evaluated in stage 1 as having merit. It's been approved to go to stage 2. There are a number of elements to that proposal. They all have to be worked through, and the metro line and the metro station itself is clearly a part of that.
And what's the commercial advantage to government?
That's not actually one of the criteria in the guidelines. There's value for money, uniqueness, alignment with government objectives. That commercial benefit is not, or commercial advantage is not one that I recall.
Isn't that covered by value for money?
Not the same thing exactly, but yeah.
What's the value for money for government, given there's going to be billions of dollars of extra expenditure in providing facilities for 25,000 new dwellings, plus a metro station?
Well, I think the Premier kind of alluded to this morning. You know, if we build a piece of infrastructure like the Sydney Metro West project and we put in a new station, the number of homes that can be located around that station, either it's a couple of thousand homes or it could be up to 25,000 homes, that's where we evaluate the benefit, the public benefit associated with that.
Well, that's not value for money for
Well,
government.
no, it is. That's exactly the sort of things that gets evaluated in those criteria.
Ms Boyd, what was the circumstance by which William Murphy, the acting head of the Cabinet Office, developed this position paper on the 6th of November, Project Waddle Transaction Options Analysis?
I think you'd have to ask him that. I can't speak to that.
You're not familiar with that? Did you take it on notice as head of the Cabinet Office to find out how the Cabinet Office produced this document, where it came from? I think I'm told that it came from Mr Minns wanting this assessment made. And in his risk document for option 3, unsolicited proposal, he writes probity risk, perception that New South Wales Government is engineering an unsolicited proposal for a government-driven transaction. That's more than a risk, isn't it? That was the reality of how this came about.
I wouldn't comment on that. I'm not familiar with that document.
Yeah, Mr Draper,
can you read that out? Can you read that out again, please, Ms. Latham? Sorry.
Mr Murphy wrote probity risk, perception that the New South Wales Government is engineering an unsolicited proposal for a government-driven transaction.
Yeah, it's about the perception.
But that's the reality, isn't it?
Well, the reality is that unsolicited proposals are almost always come about through discussions between government and proponents, because we won't consider proposals that don't align with government priorities. So it's absolutely pointless for a proponent to just lodge something out of the blue without having spoken with government about it. So that's the reality. But what I don't know was in Mr Murphy's mind when he wrote that, but certainly there's clearly a risk of a perception of that, because it's a risk that you've raised many times with me.
Well, Mr McMahon from the ATC has told the Select Committee that the idea came up in meetings with government officials in August and October of last year, where they said if you want a metro there, you're going to have 40,000 people living on the site, and that, of course, logically requires the sale of Rose Hill for housing development. So the solicitation of this came from government.
Well, no, I think you're conflating a couple of things. I think the feedback to Rose, the ATC may have liked to have had a train station, a metro station at Rose Hill to service the racing activities at Rose Hill. The feedback they would have received was that was simply not sufficient demand under that scenario for us to warrant us building a station there. But what we're really after in many locations is more housing. In fact, the government had already, I think at that point, been very clear that it was pursuing housing development around transport hubs, the new transport-oriented development. So that makes perfect sense that they would have formed that impression.
How can it be an unsolicited proposal if Mr McMahon and the ATC had never heard of the concept of unsolicited proposals until Mr Murphy recommended it in this document on the 6th of November?
Again, that is absolutely normal. People come to government all the time with ideas. They don't know. We don't expect every person in the private sector or non-government sector to know all of our policies. They come to us. They have a proposition they want to pursue. and it's standard for us to provide advice about the best way to pursue that. If there's no current process where we're going out and actively procuring something and someone's got a proposal they want to explore further, that comes down to direct dealing, and we have an unsolicited proposals policy which allows them to put a proposal to us and be considered in an arm's length way.
Yeah, Mr Draper or Ms Boyd, are you aware of any legal advice that's been produced for the Premier regarding the probity risk that Mr Murphy identified?
I'll have to take that on notice, but there is a probity advisor under the guidelines.
There's a proposed probity advisor who's appointed.
Not O'Connor Marsden.
It is O'Connor Marsden.
Who else? Of course, they get every job because they produce what government wants.
I won't comment on your assertion there, but we obviously provide advice to the Premier directly ourselves, and we've advised him how the unsolicited proposal guidelines works, and he was perfectly happy with that.
Right, but from your earlier comments, Mr Draper, this is not really unsolicited, is it? The government came up with the idea through its officials in discussion with Mr McMahon, and then recommended the USP process. So what
It's
you're
unsolicited.
saying, it's a misnomer, is it, to call it unsolicited?
No,
these are just proposals.
I said just the opposite. I said it seems to me a perfectly normal process for these things. What unsolicited refers to is the government hasn't prepared documentation, issued to the market a request for proposals, and then sought responses. That would be a solicited proposal. This is something that has been put forward by proponents after discussions with government to test whether there would be an appetite within government. That's absolutely normal for unsolicited proposals. I've seen many over the years, and that's how they all work.
Right, so it's possible to have an unsolicited proposal lodged by an organisation that hadn't heard of unsolicited proposals until the government told them.
No, well,
to
I've
do it
already
that way.
explained that the way that generally works is that those agencies those proponents are referred to public service officials who are very familiar with those processes, and they receive advice on how to go about it. In fact, the guidelines have a preliminary stage which specifically suggests that the proponents do that so that they can understand the process and whether their proposal has any chance of proceeding.
And Mr Draper, are you on the assessment panel for the USP?
I'm not on the assessment panel, I'm on the steering committee that governs.
On the steering committee.
Yeah.
And how does the steering committee consider this with an independent assessment of the merits or demerits of the proposal, given that the Premier has repeatedly said he wants it to happen?
Well, there is an assessment panel as well. So the value of the unsolicited proposal guidelines is it creates a separation of roles. So there's an assessment panel who assesses it for all the merits against the guidelines and procures advice if necessary to do so. That assessment panel makes a report to the steering committee, who also tests that. A report is made to government to consider that, and there's a number of steps required, each undertaken by different parties.
Each of those steps is aimed at meeting the Premier's public statements that it should happen?
No.
No, well, what's the difference?
Beg your pardon?
Well, if the Premier has said it should happen,
well, the Premier, I think the Premier gave his own evidence this morning on that, which was if government's objectives can be met, and the members of the ATC vote in favour of it, then it may happen. But it's also possible it may not happen.
Thank you, Mr Draper. Some questions from Ms Boyd.
Thank you very much, Chair, and good afternoon to all of you. Can I just ask, I'll start with you, Ms Boyd, just clarifying something you were saying in response to Mr Tudhope's questions about the provision of documents electronically. Were you only referring to privileged documents, or were you referring to all of the documents?
No, the discussions we've been having with the clerk have been on the basis that we would move to full electronic disclosure subject to appropriate security.
Because you would presume then that there would be a different circumstance when it comes to the non-privileged documents, which are notionally public and are supposed to be viewable by anybody. We wouldn't need the same level of security around the provision of those in electronic form, would we?
Our view would be that you still do need some. I think physical access by members of the public is very different in terms of security risk, particularly on matters like foreign interference and misuse of official information, than having all of those materials together in an online platform. So, the ability to piece the huge volume of non-privileged government material together in that way, there would still need to be some management of that, we would think. But yes, the privileged information is clearly the most significant in terms of the protections that would need to apply to that.
That's interesting because I think we've always imagined that once a document is released in a public way in an SO52, it was only a lack of technology that had stopped the public being able to then access it freely. I actually quite like the idea of the media, for instance, being able to quickly assess that information in electronic form. So, yeah, that's interesting. So are we only talking about foreign interference that's the issue here? Or?
No, I just think the issue for the House is just to consider the public interest for and against mass publication of government material over a really long period of time, particularly in circumstances where privilege claims are not generally upheld by the House. So I think those are really the issues that we'd be asking the House to consider before moving forward.
But for the non-privileged information, that there's been no reasons found to put privilege over them, let alone the ones that then privilege gets taken off. But for those ones where the department has originally decided to put them out, it's a bit of an interesting position to then say they're not actually public. It's only if you then take that extra step to come in here that will let you look at them.
I think some of them are actually published on the Parliament's website. I'm not sure how that decision gets made, but some returns of non-privileged material are published online. I think the distinction I'm drawing is between, assessing the public interest harm in producing or publishing a single document in isolation is very different from the kinds of considerations you might need to think about when you're considering mass production of years and years of government data and information. I think there are risks with that are different from just the publication of a single non-privileged document in isolation. But those are matters for the House, and we'll keep working really closely with the Clerk's Office to facilitate this, because there is huge efficiency gains there as well that we see.
Yeah, I mean, I know that we have to go through that process of scanning the documents, and then we have them in electronic form, and now of course there's software that very easily converts all of that scanned stuff into easily searchable and readable formats anyway. It sounds like there's a reluctance to embrace a new technology because we quite like the hurdle of having it in physical form.
I assure you, I do not love the hurdle of printing and carting thousands of pages of documents to the Legislative Council. I think, and we're, obviously, the Government Information Public Access Act puts an obligation on all government officials to promote open access to government information, and we're very mindful and supportive of that.
Yeah,
so
it's
we'll
not
continue.
open access though if people can't get to it.
No, but we are working with the Clerk's Office to move forward on this.
All right, I will. I'll keep an eye on that. Thank you. I think Minister Jackson announced an agency for youth, and I understand some work has been done. Are you able to give us an update of where that is in terms of it being a kind of machinery of government change?
I think I'll have to take that on notice. It might be a better question for the Minister for Youth at this stage, but we can take that on notice. Okay.
And then lobbying. I know that there was an article in, I think, the Sydney Morning Herald the other day about how ICAC had written to the Premier asking about what was being done to implement the recommendations of a prior report that the Labor government had agreed to implement and still hasn't. What is the current status of reforms around lobbying?
So Operation Eclipse, I believe, is the report that you're referring to. I think that was delivered by the ICAC back in 2021. So the then government received it and I think put out a response saying that they would support it and consider implementation, and so that process is ongoing with the new government as well, who has also expressed support in principle for the integrity reform in the lobbying space, I would say. But the detail is very, very fraught. It's a very extensive report with a lot of implementation issues, I would say. So we're working very closely with the Special Minister of State to provide advice on how that can move forward, and so it's ongoing.
I understand it's not your decision to make, but it would seem to me that there are elements of that report and those recommendations that are pretty easy to implement. I understand the previous government didn't want to do this either. Do we have any sort of timeline for when the current government is going to roll out changes?
All I can say is that it's ongoing, and we continue to provide advice on the options for implementation.
When it comes to lobbyist passes, so this is something I've raised before in these estimates, where we have lobbyists are given security passes. They can walk around this parliament, and I've had them come into my office when the door's unlocked to say hi, and I'm like, how did you get in here? When you go to actually find out who's a lobbyist and who's got a pass and who has actually sponsored that pass, that information is not available even for members. A very basic thing would be to at least require those lobbyists to have a different coloured pass to, for example, the special constables, which currently have the same coloured pass. Are those sorts of things being dealt with, or are they purely within the realm of the sort of the President and the Speaker?
I would say so. So I would definitely suggest that sort of submission be made to the Speaker and the President, that we don't have any policies or other control over the security passes to access the parliamentary precinct. I am conscious that the Chief Commissioner of the ICAC's made some comments about this publicly, and it might be something you want to raise with him this afternoon. But I think he erred on the side of saying, well, I'd rather they meet in a formal office in Parliament than, it's probably somewhere less.
Sure, but I'd rather they turn up to the reception like every other guest that I have, and then there's a record of them being here, and they don't just walk the halls with access to any MP that they like. So is there any, I guess from a Premier's perspective and a Premier's Department and Cabinet Office perspective, is there any sort of guidelines that could be issued right now that actually put in place something saying if you're to meet with a lobbyist, they can't just have a pass, they need to actually have registered with the front desk, or presumably that is within the capacity of the Premier to do?
I'm not sure that the Premier could. I mean, I think he could certainly do it for government members, but I'm just not sure that we have the jurisdiction over the parliamentary precinct, given that there's an act that prevails in relation to that precinct to implement those sorts of changes.
But the Premier could set a standard here and actually say, well, at least for ministers, we're going to make sure that any lobbyists that come to see us, it's going to be completely transparent, and they'll come through and actually register at the front desk like everyone else.
Look, I think it would be open to all parties to take voluntary steps if they wish to.
Sure, but the Premier has that capacity over ministers to issue that direction.
Potentially, yes.
Yeah. Okay. So I understand what you're saying about the passes. In terms of then the direction that Mr. Tudhope was referring to before about the definitions and sort of what you need to say in a ministerial diaries perspective, I've spent the last week going through most ministers' diaries, and it's pretty patchy depending on like who's saying what about what. For example, sometimes there are company names that are just abbreviated to two initials that could refer to 200 company names. Where's the accountability for those disclosures? Who's
I would say the ministers are accountable for compliance with that memo. So if you have concerns about the quality or of disclosures, it would be open to you to raise those.
Is there consequence? Or
Well,
is it
I mean,
just
Premier's memos are binding, and I think all ministers are expected to comply with them. So,
Thank you, Ms. Boyd. The opposition.
Thank you. Can I just take you, Mr. Draper, back to the assessment panel? Who is on the assessment panel for Rosehill besides yourself?
I'm not on. No, just to clarify, I'm on the steering committee. So I'll step through it. So the steering committee, I've got a note here, so I don't forget it. But I can basically, it's myself, the Secretary of Treasury, the CEO of Infrastructure New South Wales, the Secretary of the Department of Creative Industries, Tourism, Hospitality and Sport. I think that might be it, but I'll just check in a moment. And then there's an assessment panel.
Yep.
Give me 1 second, Mr Chair.
So you'll excuse me if I just don't understand exactly how this process is going to work.
Yeah.
I probably should have had the
That's okay.
document before me.
Yeah, so the STERCO is the Secretary of Transport, Secretary of Treasury, Secretary of Department of Creative Industries, Tourism, Hospitality and Sport, and the CEO of Infrastructure New South Wales. Then there's an assessment panel which comprises more or less the same organisations but at a less senior level. They might have some additional members as part of the
So what is the role of the steering committee?
It's, as I was discussing with Mr Latham, the whole idea of the unsolicited proposals process is to have separation of advice and decision making. So the assessment panel is getting into the detail of the assessment and the discussions with the proponents. The steering committee is sort of setting the ground rules for that and making sure that the work of the assessment panel is undertaken in a diligent manner in accordance with the guidelines. And then there's decision making at a government level once those assessments have been made.
We've heard a lot of evidence this morning that this is a proposal which will not proceed unless it is agreed to by the members.
I think that's self-evident.
Yeah,
I think unless both parties agree.
The Premier was at pains to actually stress that that is the absolutely preeminent condition relating to this proposal. So when the proposal came to your office or to the steering committee, why isn't it that the first question you would ask is, does this proposal meet with the approval of your members? Before you did any work whatsoever on it.
Yeah, look, I think the ATC had a view that it would meet with the approval of their members. At least there was a high probability of that. I believe. I wasn't that involved in the stages when this all happened, but I understand they have a governing board and that they've discussed it at that level before it ever came to government, and that the proposal that was ultimately lodged with government was lodged in March, many months after it was publicly announced that there was a consideration to such a proposal, and that had been approved by the governing bodies of the ATC. It wouldn't have been a precondition for us to say you have to have taken the whole thing to a vote with your members. I'm not sure what they would put to a vote because the proposition that they could put to a vote hadn't yet been negotiated with government, so they need sufficient detail. It'd be very unfair, I guess, to the ATC members to be asked to vote on something where there was no real detail on what they were voting for.
Well, there's a proposal which has been lodged as an unsolicited proposal. Why wouldn't you say? Why wouldn't it be the case? At least this proposal should have been put to the members before we consider it further.
Well, every organisation has its own governance arrangements. And the element, as I understand the rules of the ATC or the Constitution, the element that needs to be put to the members in order to proceed is the disposal of the land at the Rose Hill. Not the other elements don't require that. Like most organisations, there are powers given to directors and the board to make decisions for the organisation. That's the one element that they need to put to members, as I understand it. And it'd be very hard for those members to really make a considered view on whether they want to proceed with that until they knew the whole proposition that was being put to the.
But we do know now, though, don't we?
No, we don't.
Well, see, the ATC had a proposal before the board members even knew about it. It appears to me so.
We got a proposal in March. That's when we got a proposal.
But in terms of governance, you accepted the proposal
in March,
allegedly on the basis that there was a high probability that it would be approved.
A significant probability, a possibility.
How did you form that view?
The view was, well, because the governing body of the ATC provided that view to us, and they had done their own approvals internally to present it. That was always clear that the ultimate decision of the sale of the land, as we understood it, was that it would have to be put to a vote of the ATC members. So that was very clear.
Is there a document which evidences the view of the ATC board that there is a high probability of approval by the ATC members?
Probably not. The phrase high probability is a phrase that I've used now, but the view of the ATC was it was a proposition that they thought they would like to proceed with. Otherwise, they wouldn't have lodged a proposal.
Well, I'm not so sure. Because if you had formed the view there was a low probability of approval by the members, then wouldn't you take the view, I'm not going to do any more work on this because there is very little probability that this is going to be approved by the members?
Mr. Tudor, every single proposition that comes to government, at some point, you don't know whether the party that you're dealing with is going to be able to follow through for a whole range of reasons. And it's way too early at stage one of an assessment process to say to another party, we don't think you're going to be able to do this. Now, we need to get much further into the process before we can make that judgment.
Well,
and it's really in stage two when we flesh out the details of a proposal. We understand what's being asked for in detail, what's possible, before we can put back to government. By the time we go back to government, if we were to go back to government and say we can proceed, we would have a much stronger idea about what the terms of the deal would be, and secondly, the likelihood of it proceeding.
Could I jump in and say at page 10 of your guidelines for unsolicited proposals, Mr. Draper, the government's got to be sure that the proponent has the capacity to implement and carry out the proposal.
Yeah, and we formed a view.
I can absolutely guarantee you, as long as my backside points to the ground, there's no way in the world the ATC membership are voting for this.
Well,
they see it as a shambles, a debacle at leadership level. The board is split 3-4. You only need one director to flip and they'll call the whole thing off. Why wouldn't the government have an assurance that the ATC has the capacity via a membership vote, that the membership wants to go ahead, as you're legally required to under the Licensed Clubs Act, before wasting the time of your steering committee, whether there's high-level bureaucrats, your assessment panel, all the money that's going to be spent and time wasted on something, and I'm telling you, is a complete dead duck.
Mr. Latham, I hope you'll forgive me for saying that I don't think we can rely on your view about what the ATC members are going to vote when it comes to that vote.
Why don't you ask the ATC to test it?
Well,
order.
As I understand, the ATC will test it. The degree of confidence we need to have about the capacity of another party is proportionate to the stage that the proposal is at. So it's it had been at stage one. It was assessed at stage one that there was sufficient confidence in the capacity of those parties. We knew the types of advisors they were engaging. We knew that they owned the land. We knew that all of those elements that we needed to know for that stage, we had sufficient detail for that. The degree of certainty and confidence is proportionate at the stage. Clearly, we're not going to get to the point of executing contracts unless we know that the organisation can deliver on those contracts, but we're nowhere near that.
So, but you would have been aware of a public meeting of the members of the ATC where there was very, very strong opposition to this proposal.
I had heard of it. I'm not that familiar with it, but as I understand it, there was a public meeting, but I think there's something like many thousands of members.
Yep.
I don't think they were all at that meeting.
No, they wouldn't have been.
Yeah.
But the proposal was canvassed at a meeting of members, and the overwhelming position of the meeting, as reported, I wasn't there, but as reported, was hostile to the proposal.
Yeah, I can see your interest in this, but it doesn't really get us that far.
Well,
if the ATC members don't vote to do it, it's not going to happen. But we're nowhere near the point where we need to know that with any high degree of certainty. And to be fair to those members, they wouldn't even know what they were being asked to agree to until we got much, much further into stage two.
Well, there's a proposal that has been lodged with you. So
the proposal's a stage one. That's an initial proposal. Unsolicited proposals develop over the course of stage one and stage two. They get down to much finer grain. We flesh out some of the unknowns.
Well,
the initial proposal is a request by the party that they would like to be considered. It's again at a level of detail proportionate to the stage that it's at, but we're nowhere near a stage where, and it's not for me to tell the ATC how they should govern themselves, but as we're nowhere near a stage where any party or any organisation could go to its members and say, here's the thing we're trying to vote on, we're just not there yet.
So where are we up to in terms, we must be incurring costs in relation to this, are we?
Yeah.
So give me an idea about what those costs look like in terms of the work being done to, I suppose, assess the proposal as it currently stands and then go back to the proponent with potential views in relation to moving it forward.
Yeah, so the costs, in terms of the scale of the overall transaction, the costs are relatively low. We're talking about hundreds of thousands of dollars that we're expending on consultants at this stage. Over the course, if we went all the way to the end of this, we might spend up to $1 million on advisors. But that's, when you think about the many billions of dollars, as you've mentioned, involved here, I think that's quite a modest cost to the government.
There potentially are costs for, or indirect costs, but there may be delays in relation to the delivery of the metro?
No.
There won't be?
No.
Not even if proceeding to the next stage involves consideration of the retrofitting of a railway station?
No.
That won't give rise to a delay?
No.
Okay. Yeah. Can I ask you some questions about housing? There is a national target of 1.2 million new dwellings over 5 years from the 1st of July 2024 with the Commonwealth. That's correct, is it not?
Yes.
Yes, correct. And that the share for New South Wales in relation to that housing, you answering these questions, I don't know. Sometimes I get confused about it.
That's all right, we do the policy, they do the delivery.
I sometimes think of Mr Draper and his role of infrastructure, but Ms Boyd, so the target for New South Wales is 377,000
yes.
New homes. So under the agreement with the Commonwealth, what is the agreed metric to determine how many new homes will be delivered by each state?
Do you mean in terms of, is it completions or is it, I think it's completions, is that right, Marcus?
Yes,
Yep.
it's completions.
So does that metric then apply to publicly available information such as dwelling units completed which are tracked by the ABS?
Yeah, I think there's
Yes, it's ABS data.
So that's the data which will be used for the purposes of New South Wales's compliance.
All states and territories, yes.
Yep. And that will include, I take it, all private, market affordable and social housing?
Yes, a broad range of housing.
And
yes.
non-student private? Sorry, non-private, including student housing? Does it? Yeah.
I think I might have to take that aspect on notice. I think there might be some particular
there's
rules
some components relating to that. Does it include boarding houses, seniors housing and co-living dwellings? So if you can take all those
yes, I will take
four
take
aspects
all those.
on,
yes.
whether it includes that. So a room in a boarding house, for example, and this, again, you might not, will it be classified as a home for the purposes of 377,000?
I'll have to take that one on notice.
Are there guidelines relating to that in the agreement with the Commonwealth about what they say is going to be?
Yes, look, there would be, but I don't have.
And I suppose on a similar basis, a room for student accommodation.
Yeah, so look, as we've already said, Mr Tudor-Hope, I'd have to take that on notice for those more detailed ones about those less normal forms of housing. Yeah.
Yep. So the target, is it a net target? So, for example, if I demolish a house and construct a duplex, will that be recorded as 2 additional homes or as 1 additional home? Or is that just being too cute?
I don't think you're the first who's asked me that question, but I can't recall off the top of my head how we resolved it.
So it has been
yes.
Discussed about whether that would be 1 or 2 homes for the purposes of meeting our targets. What is the definition of well located within the agreement with the Commonwealth? Is one being applied to the 377,000 home target?
I think it's a broad definition. I don't think it's been subjected to and dissected into a range of different measures per se, but it's a broad definition of what is well located. Yes,
it's a broad definition.
Yeah, and so would take into consideration, infrastructure provision, other things. Amenity issues, various other things.
So if it was 200 kilometres from public transport, that might not be one. Is that what you're...
Well, not necessarily the case, Mr. Tudor Hope. In regional New South Wales, I mean, there might be an additional.
There might be other aspects.
There might be other reasons
why
there'd be an additional dwelling would be brought on in a location like that.
Okay. Can I then just ask you about the $2 billion new homes bonus performance-based fund? Which is part of the agreement. Is that only available to states at the end of the housing accord period? That's 2029?
Yes, that's my understanding.
Yep. And so has the New South Wales government hasn't received any funding as yet under the $500 million new housing accelerator. There seem to be new funds for everything. So have we received any funding under that package?
So there was some funding that was committed from the Commonwealth the year before last was a $600 million in a social housing accelerator funding, but I'm not actually fully aware of what the $500 million aspect of the new home bonus is that you're referring to.
Well, has any application being made under that program for funds?
That's the HAF, isn't it?
Yeah,
I'm pretty sure there have been applications, and we can take that on notice as to what.
Have you received any funding as yet under the $150 million Urban Precincts and Partnerships program as part of the agreement with the Commonwealth?
I'm going to have to take that one on notice too. I'm not aware.
Well, my second question was: have you, if you haven't received the funding, have you made any application for the funding?
I'll get you that information.
And in respect of the regional precincts and partnerships program, same question. There's a $400 million program. Have you received any funding under it? And if no, have you made any application? And again, I assume you want to take that question on notice.
Yes, on relation to those Commonwealth proposals, those Commonwealth funding proposals, I'll have to take that on notice.
As part of the agreement, the state government has issued housing targets to local government areas across the state. Will they be assessed using the same metrics as New South Wales is being assessed by the Commonwealth?
Yes.
Same metrics?
Yes.
Good, thank you. And as part of those targets, the government outlined $200 million incentive program for local governments which meet and beat their targets. Is that correct?
Yes, that was an announcement in the budget.
Yeah, so that's similar to the Commonwealth. Will that only be available in 2029 for local government?
So I think that's going to be available earlier, but the details of that that package and how it's going to be administered, I don't think has been announced yet. So that's a matter for Minister Scully. You might question him about the details.
So there may be an opportunity for councils to make early application for some funding in relation to that program.
Yes, I haven't seen the details of those guidelines under which that funding is going to be administered, so I really can't answer one way or the other.
Well, I take it that councils can be progressively assessed as to their eligibility for that funding.
Yeah, well, again, all I can say is I haven't seen the details of how that program's going to operate. And
is it your department, is it your office that's responsible for those funding arrangements?
So in relation to the local incentive program that you just referred to, that's been administered by the Department of Planning, Housing and Infrastructure.
Can I just go back to you with one other thought that just occurred to me? In respect of the costs which are currently being incurred in respect of the assessment of the ATC proposal, why haven't you asked the ATC to meet those costs? It's often the case, is it not, that the proponents who are seeking to have an approval, that they would then at least meet, and not the taxpayer meet, the costs associated with that proposal?
There may be some circumstances under which we would seek to recoup the costs from them, but we don't. It's not. We always try to get an arrangement where we can get the other party to pay for our costs. It's not that often successful.
Well, wouldn't you at least canvass that with them?
Yeah, no, we have.
Rather
Absolutely
than the taxpayer
no,
picking up the bill for this proposal and the assessment of it, and then wouldn't you expect the ATC to at least let their members know that this is costing money while this proposal is being considered?
That's a matter for them.
Thank you, Mr Draper. Mr Latham, you've got 10 minutes.
Thank you, Chair. Just coming back to the criteria for unsolicited proposal, Mr Draper, there's a provision here, return on investment, and the government has to ask the question, is the proposed return on investment to the proponent proportionate to the proponent's risks and industry standards? Has the ATC provided a credible professional valuation of what the land is worth to them? Because we've heard at the Select Committee, the Deputy Chair of the ATC, Tim Hale, say that there's no valuation of $5 billion, the amount that the Chair, Mr McGoran, has been using. In fact, the current value of the site is $1.6 billion, including a metro, and on that basis the ATC wouldn't proceed because they wouldn't meet any of their investment objectives for the future. So have you got an assurance from the ATC with a credible valuation that they do have a return on investment for the proponent proportionate to the proponent's risks?
So the assessment process that both yourself and Mr Tudor have been asking about, that's the process by which we make that determination. We don't, we've got our own advisors to try and form that view rather than rely on the proponent's own view of that. So we make our own assessment. We're not requiring them to provide us valuations. I guess it's not particularly relevant, but I take it that the valuations, the difference between the valuations that you're referring to relate to land zoned as a racecourse, as is, where is, versus land zoned for residential purposes. Clearly the values are quite different.
The latter, it's $1.6 billion.
As residential?
As residential. I spoke to a leading developer just last week who said he wouldn't pay, he'd pay $500 million for it.
Oh, okay. Well, he's unlikely, it sounds like he's unlikely to be able to get it.
No, well, it raises doubts as to what money the ATC might get. So it says here, where feasible, the proposed rate of return may be subject to independent review or benchmarking by the government. Are you doing that?
As I just said, yeah, that's part of the assessment process and the advisory work.
You'll get your own independent assessment.
Yeah.
Right. And we discussed earlier on the commercial advantages to government. In fact, under the criteria for unsolicited proposals, page 6.5, the types of proposals that are not considered unique and or proposals that are unlikely to be progressed, it reads as follows: proposals that do not contain a commercial proposition for the government. What is the commercial proposition in this for the government?
Well, the potential commercial proposition for this in the government is to secure, to meet some of the housing targets that Mr Tudor was just asking about, and to see if we can defray some of the costs of the metro station if that proceeds to be built.
Right, but overall, won't this cost the government billions of dollars in extra deficit and debt to build the services that are needed for a community of 40,000, 60,000 people at Rosehill, Camellia?
It's not
really a commercial proposition.
As do all developments. So the government provides infrastructure services for all sorts of housing. There are no propositions that are free to government. Every time we build new housing, whether it's on the fringes of Sydney or in a regional city or regional town, or in established areas in the city, there is a cost to government of providing services and infrastructure to support that.
Doesn't the requirement for a commercial proposition indicate that unsolicited proposals are not for land development applications? Because we've got a planning act about this thick that is there, long-standing, for land and housing development applications in the New South Wales planning system.
Chair.
Isn't this USP being used as a way to shortcut that?
Can I raise a point of order,
You
please,
certainly
Chair?
can.
Chair, in terms of the line of questioning that Mr Latham's using, I'm just concerned that it is straying into the unreported findings of a committee, given that the committee terms of reference, the inquiry into the proposal to develop Rosehill Race Course explicitly sets out in the terms of reference that the committee be established to inquire into and report on the proposal to develop Rosehill Racecourse, and in particular, A, the unsolicited proposal process, including associated probity measures, B, the involvement of the government prior to the, and so on and so forth, and includes the role of housing targets. I just am concerned with the line of questioning and how this is, and the established precedent that we've got in terms of not interfering with unreported findings from committees.
Well, on the point of order, Chair, the honourable member hasn't read Part 2 of Standing Order 231, which says the paragraph does not apply to any proceedings of the committee that are open to the public. And all these valuation matters were canvassed extensively in public with Mr McGoran and Mr Hale.
Yes.
Further to the point of order,
Sure.
this committee, yes, while I acknowledge that the reporting is in the public domain, there hasn't been a final report from this committee, and attempting to, solicit information outside of that process is, whether deliberate or not, interfering with that committee's reporting process. It hasn't been reported on.
To the point of order.
Well, Mr. Ruff.
If you take the premise that anything before a committee couldn't be assessed in budget estimates, given the breadth of the committee process that we have in the Legislative Council on a wide range of topics, I think it would set a very dangerous precedent to say none of those matters, none of those inquiries, including the cannabis inquiry that you're chair, or the inquiry into alcohol in public places, none of those matters could be raised at estimates. I think would set a very dangerous precedent and stifle debate and the very point of what budget estimates
Further
is.
to the point of order,
Mr. Chair,
there is a fundamental difference between raising the unreported proceedings of the committee and asking general questions about the subject matter of an inquiry that's before the committee. So my view is that there are very specific references to proceedings before the committee, as opposed to asking questions just about the general subject matter of Rose Hill, which is entirely permissible under the standing order.
Yeah, thank you for your submissions, everyone. And it's a very interesting development that this standing order is being relied upon. But I'm not going to uphold the point of order for the reasons that have been outlined by Mr. Latham, and that is that 2312A, it does say any proceedings of the committee that are open to the public and media. Now, while it's difficult for me to know exactly what was said at a select committee that I wasn't at, I'm going to err on the side of allowing the questions, because I think it's in the interest of this committee and the public interest to allow an exercise of an investigation into what is a matter of public interest. So I understand that the point that's been made, and I'll keep considering it and get some advice from the clerks. But at this point, I'm not going to uphold the point of order, Mr. Latham.
So to answer that, I think, if I can remember the end of your question there,
that's not a
I think it was
commercial
about the
proposition for
planning
government,
system and the unsolicited proposal.
Circumvent the
It
planning
just to make it really clear, unsolicited proposals do not usurp the planning system. So, were the government to enter into an agreement with the ATC about this, or any other proponent for any other site, the planning assessment process would have to happen separately, and more than likely happen after that happens. And for that reason, the Department of Planning does not play any role in the unsolicited proposal assessment process.
Well, what commercial proposition to the government has the steering committee identified, or the ATC submitted?
Yeah, I think you've become very focused on this idea of a commercial proposition. If you look at that, that's a sub-point of a number of other... So is that under the value for money one or the return on investment one? I think of that.
It's the type of proposals that are not considered unique, and/or proposals that are unlikely to be progressed.
And which one have you focused on?
Point 5, proposals that do not contain a commercial proposition for the government.
Yeah, well, this has got a commercial proposition for the government. This is saying that they would enter into a financial arrangement with the government where they would sell land that would be reinvested elsewhere. The government would potentially receive some returns to compensate for some of the infrastructure that will be spent. That's all on the table.
What are the returns to the government?
It's not a It's not designed. It's not a. I mean, government is not a.
The ATC builds a new grandstand at Warwick Farm. What's the return to the state government?
Well, government's not a for-profit organisation. No. The way we evaluate the return to government is partly measured in the benefits to the community.
Are you worried that the Save Rose Hill group have spoken about a legal challenge to this entire process, given that it doesn't fit the government's guidelines for USP?
No.
You're not worried about that?
No.
Okay. Thanks, Chief.
No? Well, thank you, everyone. I don't think there's no one else here from the crossbench. I have no questions. So,
Chair, do you mind if I just do one thing? Mr. Borzak's not here, but there was some evidence given. He was asking a question this morning about the completion of the powerhouse in Ultimo. I think the evidence might have been that it was 2025. That's the powerhouse Parramatta's 2025. Ultimo is 2027.
Okay, thank you,
I
Mr.
thought
Drake.
he had some questions.
No, have you got any more?
Oh yeah, I did have some.
Well, I'll allow another 5 minutes of
Okay.
questions from Mr.
Thank you,
Latham in the
Chair.
absence. Sorry,
In a
everyone.
memo written by Rowan Fisher, an Executive Director indeed,
So
on the
Mr.
3rd of
Five.
November regarding Project Wattle, he raised a question of what interest ICAC might have in this, specifically the problem of, and I quote, "It's already happened before you say that you're going to start negotiating." So isn't this the problem that he's identifying, seemingly inside the bureaucracy, that the word was out, the Premier wants this to happen, we're manufacturing a special USP process, what's the point in doing a negotiation and an assessment of it, given that the head of government has said that it's ticked through?
I just go to the evidence I said earlier that it's most common that unsolicited proposals that do proceed often have the support of government. If they don't have the support of government, why would government agree to them? That's extremely common. And at that point, the unsolicited proposal process hadn't commenced, but the whole point of the unsolicited proposal guidelines is to align with ICAC's direct dealing guidelines. That's what it's designed around.
Right. Why wouldn't the government say to the ATC, you want to sell your property for housing, join the queue, we've got a planning act here, facilitate that. You can lodge an application like anyone else. Why wouldn't that be happening?
There are, and that's quite right. It's in fact, as you go to your list that you were looking at a moment ago, things that aren't unique. If a property owner with land says, "I want to sell my property, I want to develop my property," there's really no role for government other than the planning assessment process. Then there's no need for that to go through an unsolicited proposal process. In this case, there are at least two very critical elements to the proposition that require government to agree. One is the idea that we would provide a metro station that would support the level of development there, and the second is that the use of Horsley Park for training and stabling facilities.
I don't know what the second point means, but just going to the metro, you're saying that any landowner surrounding a new metro can lodge an unsolicited proposal and have the same treatment the ATC has received. Within 3 or 4 days you get a meeting with the Premier. Within 5 days you get Will Murphy developing a position paper on how you can get this done. Within a few days after that you're meeting with the metro team.
Yeah.
That's how Min's government now works.
It's not not only the Min's government. If I'll give you another example, the metro station at Martin Place, that just opened a week or two ago, was an unsolicited proposal where the party concerned who owned properties around that station offered to develop the station for the government because they could see a benefit for it. They brought that proposition to government after early discussions. That's exactly how it was built.
Yeah, I don't see housing in Martin Place, but don't you think this creates a real problem in other areas? I mean, you've got the Joke Sydney Science Park there at Luddenham, 15 years promised thousands of science and advanced manufacturing jobs, and it's a horse and cow paddock, but the government, through a ridiculous process, is building a metro. So won't it be available now for Celestino to lodge an unsolicited proposal to put housing there?
It's open to anybody to lodge an unsolicited proposal. The likelihood of success depends on whether it meets all those criteria that you mentioned earlier. There's no bar on any particular party lodging unsolicited proposals, as Ms Boyd said earlier.
So any new metro station, this is now the precedent for doing it this way rather than going through the Planning Act?
No, well, I've already given evidence about that. The Planning Act is completely separate. The process of getting land rezoned or getting development approvals is completely independent of unsolicited proposal processes.
Okay. Ms Boyd, on the 21st of November, Cecilia New, the Acting Deputy Legal Counsel at DEET, recorded her concerns and those of Rowan Fisher at the probity of the Rosehill USP process, writing of how Mr Fisher, and I quote, caught up with Katie, uncomfortable with the process. KK, I assume that's Katie Knight, was thinking about it. Need to remember that upstairs, the Cabinet Office, your office, is not our concern. We've told them the process, if they lodge a proposal, we keep our nose clean, don't worry about the other stuff they are doing. Are you aware of these concerns that she's outlined and investigated what in fact the Cabinet Office was doing that caused such concern?
No.
Will you do that now in speaking to Cecilia No, the legal counsel at Deep?
No.
You won't?
No, I don't.
No, you're not worried that they needed to keep their nose clean and not worry about the other stuff that was happening in the office you now head?
No, look, if those officials have concerns, I'm sure they'll raise them with me, but I'm not aware of them. And
Well,
no
I
one's
have a
approached
concern
me.
based on their concerns. So isn't that enough to act on talking to her at least as to what
Look,
went on?
I'm happy to take that on
notice.
if you would like us to do that,
Yeah.
but
And just to be clear, Mr. Latham, D, as it was now a new department, was deeply involved in running the stage 1 assessment of the UNSIS proposal.
That's right.
Thank you very
And
much,
they
Mr.
saw all
Latham,
the
and
things
thank
that-
you very much to the officials today for your attendance. There were some matters taken on notice, and the Secretariat will be in touch in due course regarding a response to those. Thank you again for your attendance and the work you do for the people of New South Wales. Committee, we will now break for afternoon tea and return at 3:45. Thank you. Well, good afternoon, everyone, from our very important independent integrity agencies. Welcome to the hearing into the budget estimates for 2024-25 in the area of Premier and Finance. Before we begin with questions, we have to get everyone to state their name and title and swear either an oath or affirmation. So we will start with Miss Anderson here on my left. Miss Anderson.
My name is Christina Anderson. I'm the CEO of the LAC. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much for that. Ms Jobson.
Anina Johnson, I'm the Acting Chief Commissioner of the Law Enforcement Conduct Commission, and I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Mr Miller.
Paul Miller, New South Wales Ombudsman. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Mr Lamb.
Thank you. Chris Lamb, Deputy Commissioner of the Public Service Commission. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Ms Lowe.
Thank you, Chair. Katharina Lowe, New South Wales Public Service Commissioner. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Mr Moy.
Thank you, Mr Chair. Darren Moy, CEO of New South Wales ICAC. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth. So help me God.
Thank you. Mr Hatzitsagos.
John Hatzitsagos, Chief Commissioner, New South Wales ICAC. I swear that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth. So help me God.
Thank you. Mr Oitonji.
Thanks, Chair. Bola Oitonji, the Auditor General for New South Wales. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth. So help me God.
Thank you. Thank you very much, Miss Magotto.
Claudia Magotto, Acting Deputy Auditor General for New South Wales. I solemnly, sincerely, and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth.
Thank you, Mr Colagiorgio.
Peter Colagiorgio, Executive Director, Finance and Performance. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Miss Summerell.
Thank you, Chair. Andrea Summerell, Executive Director, Elections, New South Wales Electoral Commission. I solemnly, sincerely and truly declare and affirm that the evidence now about to be given by me shall be the truth, the whole truth and nothing but the truth.
Thank you. Dr Phillips.
Matthew Phillips, Acting New South Wales Electoral Commissioner. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you very much. And finally, Ms Morris.
Thank you, Chair. Sarah Jane Morris, Executive Director, Funding, Disclosure, Compliance and General Counsel at the New South Wales Electoral Commission. I swear that the evidence now about to be given by me shall be the truth, the whole truth, and nothing but the truth, so help me God.
Thank you very much. We'll now turn to questions from the opposition. 20 minutes of questions from the Honourable Chris Rath.
Thank you, Chair, and thank you to each of you for appearing today and the important work that each of your agencies do. I might start with the Electoral Commission, and I can confirm I've always managed to get my nomination forms in on time. Starting, and my line of questioning is not about that.
Please. Defend home.
I wanted to start with the Electoral Funding Act and the definition of property developer, with wondering if there's ever ambiguity or concerns from the Electoral Commission regarding certain entities about whether they meet that criteria, whether it be whether their principal business is regarding development, one relevant planning application that's currently pending or 3 in the last 7 years. Is it difficult at times when it comes to donors to determine whether they meet that threshold or not of being a property developer?
Chair, if you don't mind, I might refer that question to the Executive Director of Funding, Disclosure and Compliance, Ms Morris.
Certainly, Doctor.
Thank you, committee member, for the question. So I will have to say that I cannot speak for experience. I have been unfortunately in this role for 2 months, so I cannot speak to particular examples of that, and I would have to take that particular question on notice.
Okay. Sure. Do you know if, with regards to the definition of property developer, and again, you might need to take this on notice, if there's a state-based entity but it's linked to a federal entity that might be a property developer, does that mean then that the state-based entity is also a developer as part of the close associate definition?
Thank you, committee member. I would prefer to make sure that I'm giving
Sure.
accurate answer to the committee, so I will also take that question on notice.
And probably the other one as well that probably need to take on notice, unless anyone else can help, is about if the property development is interstate, so they don't have any or haven't had any active DAs in New South Wales per se, but they're an entity or linked to an entity that have DAs or have been engaged in property development interstate, does that then make them a property developer, you know, by that definition in New South Wales as well?
I can see the Commissioner, were you responding to that? No, I will take that one on notice as well, because I really would hate to give the wrong response to that one.
Sure. Is there currently any investigation into the CFMEU by the Electoral Commission?
I'll take that, Chair. All allegations of breaches of the electoral laws are reviewed by the Electoral Commission in accordance with its compliance and enforcement policy. Unless permitted by law, the New South Wales Electoral Commission is not allowed to disclose details or the outcomes of any specific review or investigation it may take. This includes whether or not it is even conducting an investigation.
Sure. Okay. I might come back to the Electoral Commission in a moment, but I might go over now to the ICAC. And I was wondering, and Ms. Boyd started this questioning earlier, but I was wondering if we could turn to Operation Eclipse and what the recommendations were or conclusions that you've made regarding Operation Eclipse and where that's up to. If you could provide an update, that would be helpful.
So, the report was published by my under the hand of my predecessor in 2021, and you can get a copy of it. Do you have a copy of it?
Yes. Yeah.
Okay. So all the recommendations are in there, and they relate to a whole range of activities, including ministerial diaries, definitions of lobbying, in particular expanding the definition so that it goes beyond third-party lobbyists to include in-house lobbyists. Also requirements not only on the lobbyist but also the person being lobbied. There's issues around the scope of lobbying. In some instances, we've suggested that should also extend to political parties who may be lobbying on behalf of third-party interests. You can read all those recommendations in there. Now, what happened is that after the report was released, the previous government responded to the recommendations, and that response is available online. You can see it on our website. However, nothing was done to action the recommendations under the term of the previous government. I wrote to the Premier on the 30th of October of 2023, drawing his attention to two reports, one of which was Eclipse, the other one was Operation Aero, and the recommendations which the Commission had made I subsequently met with the Special Minister of State on the 31st of January of 2024, and that was at his request to discuss a number of matters, including the recommendations in Operation Eclipse. And then, following that, I wrote to the Premier again on the 29th of May of 2024. One matter that did occur that relates to both that matter and Operation Aero is that a decision was made to reactivate the reference which was made to the Joint Standing Committee on Electoral Matters into the administration of the New South Wales election. That was a reference that it was outstanding to the previous committee, but the previous committee had not actually reported. So that matter was followed up, and I gave evidence to that committee recently. And there's a submission that I've made to that committee.
And the government now has accepted all the recommendations, or
No,
at least accepted
they have
in
not.
principle?
They have not responded to the recommendations in Eclipse. The previous government did. They issued a document which is on our website responding to the recommendations, but I don't have a response from the previous government. I did get a letter, I think last week, from the Special Minister of State, which indicated that they're considering, the government's considering the Eclipse recommendation. It was on the 21st of August, advising the government were considering the Operation Eclipse recommendations. They stated that they were also reviewing the Queensland lobbying reforms. Now, the Queensland government did go out and do a review. That followed, in fact, Operation Eclipse, and they have actually legislated since.
And was any explanation given as to what's taking so long in terms of providing a response, given the previous government already has?
I can't answer that question, other than the fact that they're still examining it. I mean, look, the issues in Eclipse are not straightforward and simple. They are fairly extensive, and they need to be addressed. But it has taken a long time over the term of the previous government and this government to meaningfully respond to them. And some of the recommendations are more straightforward than others.
So they haven't indicated any acceptance of recommendations regarding things like banning lobbyists from meetings with ministers or banning lobbyists from making political donations. We're essentially still waiting.
They haven't given me any indication of that. I did raise some of the matters that had occurred in our more recent investigations surrounding donations. I've also raised, as I did before the Joint Committee on Electoral Matters, the fact that political parties in particular get 15 million, well, they get a lot of money in to cover their administrative expenses. Last year it was 15 million. And one of the recommendations which arose, I think, out of Aero was that that there be requirements for them to have governance arrangements to deal with some of the ethical issues that arise. And that can include, incidentally, matters relating to third-party lobbying.
And to the ICAC...
But I haven't got a response.
Fair enough. To the ICAC and to the Electoral Commission, probably more to the Electoral Commission, but do either of your agencies keep track of political donations from lobbyists? I assume the Electoral Commission, I mean, you publish any item above $1,000, is it? Or whatever the disclosure threshold is.
That's right, it's $1,000.
Yeah, but I assume it's not a matter, not necessarily it's tracked by the ICAC.
We wouldn't look into a matter either unless it was referred to us by the Electoral Commission.
Yeah, fair enough. To the ICAC, Mr. Sistogos, is the ICAC currently considering the investigation into the New South Wales division of the CFMEU?
Look, I'm not going to comment on what we're investigating and what we're not. There has been some publicity about a referral. I'm not going to comment on any aspect of that for reasons which I think you'd be aware of. I can say to you, however, relevant to that issue, one thing, and that is that you should carefully look at the recommendations which were made in Operation Hector.
Right.
That's a report in which, in relation to a public inquiry where I presided, and I identified some limitations on the Commission in terms of being able to examine circumstances where a head contractor had been engaged and there was corrupt activity involving subcontracting. Now, you can read the report. I subsequently wrote to the Parliamentary Committee, and I've also written to the Cabinet Office identifying that fact, and hopefully they will both take it up at some point in time. Now, I raise that because that may be relevant to the matters you're raising.
Different issue, and I'm jumping around a little bit, but I wanted to turn to local procurement, local content rules. To what extent is procurement, which gives preference to local content and supplies a gameable or corruptible system? I read the submission that the ICAC made to the parliamentary inquiry into local content rules, but I wanted to ask you about it today as well.
Our Director of Corruption Prevention gave evidence to the committee of this Parliament which looked at the issue of procurement, and I can refer you to his evidence. Our concern in relation to local procurement is different to state for obvious reasons. When you're looking at state procurement, you're looking at a much wider field, but the issue of local councils deciding that they're going to preference local contractors is problematic. In many cases that can be one person only, and in a very small community one might be a person who they well know and identify, and so that is a problem, and we're trying to deal with it at the moment through a corruption prevention approach and through education rather than a heavy-handed approach, but it has arisen in the course of our work, and it's something that we've identified.
And have these...
And it's more common in rural councils, I have to say, than in metropolitan councils.
And have these warnings or issues been raised with the New South Wales government outside of the submission?
I'm not quite sure what you meant. I mean, we've had a couple of conversations with the Minister for Local Government. I can't recall off the top of my head whether that specific issue was raised, but we've certainly identified it through the inquiry that local government is a concern for us where that circumstance arises.
Yeah, no, I was talking more about, I suppose, as the government pursues a domestic manufacturing and local procurement policy, whether they've sought your advice or whether you've had input into their decision making on that.
Look, it depends on what the issue is. We've had some involvement with the government in relation to procurement policy. We've dealt with it, but at what depth I can't tell you off the top of my head. I can take it on notice and let you know.
Thank you. Thanks. I might go to the Auditor General and to the Audit Office. So I wanted to ask about does the Audit Office, and your website's very helpful in terms of some of the projects that have gone through the audit process. Does your office maintain a risk register for grants programs, in particular in terms of pork barrelling?
No, we don't. What we do is, as part of a specific scoping of an audit, then we look at the risk environment, the risk ratings, and to pick the specific agencies that will target in terms of our audit process.
So it's more a referral's made to your office and that audit would be undertaken. Is it that the process, is it you would look into it at the end of the program, or can it be for a program that's, a grant funding program, for instance, that's currently in place, or maybe even just having been proposed and quite early on in its initial stages, but hasn't yet been rolled out particularly widely?
Yeah, we do, because we have audits at the design planning stage, and whether it's in flight or when it's matured. So we have at different stages. One of the things that we often get pushback on is when at the start of the program, there's always the resistance about what the findings will be when they just design in the policies. But one of the things that we convince them about is that when you're part of the planning, we can actually add to what the policy design will be and what the governance arrangement should be. So that's, I think, what we currently do. But I think, to answer your question, yes, at different stages, we're able to go into do.
So it could be retrospective for a program already finished, concluded, or it could be having input into maybe the guidelines early on.
At the planning.
Yeah.
Yes.
Yeah. Okay. No, very good. And have any concerns been raised with your office or any referrals about the local small commitments allocations?
I'll just check with my deputy.
I'm not aware of a specific referral about that grants program, but I'd be happy to take that on notice, because we do get a volume of requests and referrals through a number of channels. So I'd be happy to check that. But it's not currently a focus for any of our current work.
Thanks. Thank you. In terms of the budgeting process, so in terms of the budget papers themselves, do you have any role in terms of the production or audit or compliance of those, or is that entirely left up to Treasury?
Yeah, that's entirely left up to Treasury. So we're not involved in the review of the budget. We used to, I understand, 2016, 17, but not currently, no.
Yeah. Okay. And probably one last question before my time expires, probably just to the Public Service Commission, or Commissioner. How has the role of the New South Wales Public Service Commissioner changed over the last 18 months in terms of responsibilities?
I think it's thank you for the question. I think it's probably a narrower period than the last 18 months. As you would be aware, a bill was passed by the Parliament amending the Government Sector Employment Act, which changed some of the functions of the Public Service Commissioner and reassigned some of those functions to the Secretary of the Premier's Department. There were also administrative orders which abolished the Public Service Commission. In its place, a office of the Public Service Commissioner is being established in the Premier's Department. I will be the head of that office, but the staff of that office will be employees of the Premier's Department and assigned to work with me to deliver on my statutory functions. That is a model that I suggested after being advised of the budget allocation that would be provided to help fulfil my statutory functions, and given the overheads that are associated with maintaining a separate agency, I suggested this alternative model because I didn't think it was a good use of taxpayer money to maintain a separate agency and have those associated overheads.
Thank you.
Thank you, Ms. Lowe, and thank you, Mr. Ruff. Mr. Latham.
Yeah, thank you, Chair. Could I ask Ms. Lowe, do you believe it would be useful in New South Wales to have legislated whistleblower protections?
I think you might be referring to legislation administered by the Ombudsman's Office. There is whistleblower legislation?
Just for complaints to the Ombudsman, but I was meaning across the board. Recently the Parliament's had an experience where there was a certain matter under committee inquiry and it elicited a whole series of other submissions about problems in a public agency where people clearly for a decade or more had been living in fear of speaking the truth. And it's been quite an eye-opener in that regard. We don't have across the board whistleblower protections in New South Wales, do we?
So people are able, if they're employees of government departments, to make disclosures about things that they're concerned with. Members of the public also have various channels through which they can make complaints or raise issues as well.
But what protection do you get? In other states, whistleblower protections give protection and immunities to whistleblowers. They have penalties for anyone who names a whistleblower, and they have restitution provisions to assist whistleblowers who've been harassed or sacked for speaking out. We lack those, don't we?
Look, my responsibilities are the functions that I've been given under the Government Sector Employment Act. Whistleblowing legislation is beyond the remit that I've been assigned.
It is. It wouldn't help public servants to have a bit more protection when they live in fear.
I'm happy to refer that to the New South Wales Ombudsman.
Mr Miller, would you like to respond?
Yeah, I'm happy to respond. In New South Wales, we have Public Interest Disclosures Act that we've had a Protected Disclosures Act since 1994, which became the Public Interest Disclosures Act. That was completely rewritten in 2022. That legislation commenced in late 2023. That provides protection for public officials who make disclosures of serious wrongdoing, which include the kinds of disclosures that you might make to a body such as appears here. Those disclosures can be made to one of these bodies. They can also be made to any other public sector agency, the head of the agency or a disclosure officer of that agency. Public officials who do make a public interest disclosure obtain the protections under the Act, which include protection from criminal, civil prosecution, protection from detrimental action, which is defined much more broadly than that, includes bullying and those sorts of conduct. And there's also an obligation on those who receive a public interest disclosure to undertake a risk assessment to identify the risk of detrimental action and take steps to mitigate it. The legislation is administered by the Cabinet Office, so the Cabinet Office is the policy agency responsible for it. I chair a PID steering committee, which is comprised of many of these agencies, as well as Cabinet Office and Police, which provides advice to government and, where necessary, to Parliament on that legislation. And we did so in relation to the 2022 legislation.
Thank you. To Mr Waitonji, the Auditor General, in the inquiry about the sale of Rosehill Racecourse, Tony Harris, one of your predecessors, made a submission very critical of the accounts of Racing New South Wales. Yesterday I spoke to someone with even more serious allegations about the misuse of the horse welfare trust funds being spent on real estate properties. Why can't you audit the books of Racing New South Wales?
Because it's not under the mandate of the Auditor General.
It's not, sorry?
It's not under the mandate.
It's under the mandate.
Yes.
You've got a list of
so
agencies.
So we have a list of agencies that we can...
Yeah, would you like to broaden that list to include other public authorities with lots of money that where serious allegations are raised?
Well, I think it all depends on the funding for it. So one of the things we do have is if there's any funding from government to Racing New South Wales, we now have the power to follow the money, but it's only if there's funding to Racing New South Wales from government.
That's the grants reform, follow the money provision.
Yes, so we can do that.
Okay. To Mr Hasistagos, why in some cases do simple ICAC inquiries take 3 years? I'm citing the case of John Sidoti, where the process became the punishment. The findings about him, some would see them as trivial, but effectively it ended not only his ministerial career but his parliamentary career. You've got plenty of funding and staff. Surely a matter like that should be wrapped up within 12 months so that the accused person can get on with their parliamentary duties rather than effectively being run out of the parliament and unfairly having his career ended.
Well, I don't subscribe to the opinion part of your question.
That it took 3 years?
Well, the aspect of timing I'm happy to address, but in terms of the opinion that it was trivial, I completely reject that. Members of Parliament are in a position of trust. All their resources and all their powers are to be used in the public interest. In that case, there was a very clear demonstration of a Member of Parliament who used his authority, his powers, the instruments of his office in order to advance what was something that was in a private interest. That was identified. There was a challenge brought in the Supreme Court, which was ultimately abandoned. So the Commission's findings stand, and there's nothing in that report that I need to apologise for. Now, in terms of the question of timing, you are right. It's taken us too long to do some of these matters. But I do draw to your attention to the fact that under the previous government, we had a significant funding cut, which at one stage led to a retrenchment of our staff, significant section of our staff.
How many?
We lost about 25% at one point. Now, this was under the Berejiklian government. Now, to his credit, the previous Premier, Perrottet, restored some of that funding, and I also give credit to this Parliament, the parliamentary committees, which embraced our concerns about our funding and supported us to get to the point where we now have a significant increase in our staff from 110 to 150. But let me be quite clear. Our organisation runs with a legal staff of 20. We cannot devote all of that to one investigation. Robodebt, for one inquiry, had 30 staff for one inquiry. Now, there's no way I can ever have 30 staff working on a single investigation. We're dealing with multiple matters. When we came to the Commission in 2012, myself, Commissioner Morell and Commissioner Lakatos, we had 5 uncompleted reports. Some of them had not even been commenced to be written. And we had to undertake that and get them all completed in the space of 18 months. And we did Keppel, we did Tolosa, we did Galley, we did Skyline, and one other, I can't remember.
Are you aiming to cap the duration of these inquiries? So
Look, at the moment, no, it's not a question of that. We have now benchmarks. I still think the benchmarks are quite ambitious. We have met those benchmarks with our last 3 investigations that we've done. 2 of them were under my predecessor, 1 that I did myself. We've engaged in a number of processes to try and streamline and to try and get them out. I fully accept your criticism that persons who are in positions of power should not be left hanging for a long period of time. That's one of the reasons why a lot of effort was made to not only finalise the Barilaro Ayres matter, but to publicly state what our position was in relation to that matter, which we did prior to the last election. It's another reason why we did everything we could to expedite the Krakenthorpe matter, which was in a somewhat similar position. Ms Joyner, you might recall, who was a person who was identified in this Parliament. There's some allegations concerning her. Likewise, we did the same. It's not always easy, because very often with these investigations, 90% of the work that the material that we trail through is electronic and documentary. So there's a heavy burden on us, and our benchmarks at the moment are not based on the amount of data we have. They're based on the number of hearing days, which is a very antiquated way of having a benchmark. That's the benchmark that was set by our predecessors. At the moment, I'm trying to meet those and do everything possible we can do to get those investigations finalised as soon as possible.
Thank you. You mentioned the Krakenthorpe inquiry. I thought it was a fascinating report, and I said so in the House with regards to the duties of an MP. Why didn't ICAC have any capacity at all to see things through the eyes of the representative Member of Parliament, who in the case of Krakenthorpe, it would have been a betrayal of everything he stood for and promised his electorate not to have some involvement in advancing the much needed regional sports facility there at the sports ground on the main road in Newcastle, with, I mean, the most nebulous point of view that a sports facility could have any positive impact on the father-in-law's property holdings when the member himself was estranged from the father-in-law. So there was no mention of the betrayal an MP would have to his electorate if he did nothing about the one big sporting project he had in his electorate.
I'm not here to review that report. That report stands for itself. You can read it. We're publicly accountable for the contents of it. We've made our findings and you can disagree with them. Anyone else can disagree with them. If you wish to come out and make a statement about it, that's your entitlement. We apply the law. And there's laws on conflicts of interest, there's laws in relation to acting partially, there's laws in relation to breaches of trust. We've identified all of that. And there's also laws on what constitutes corrupt conduct, and in particular serious corrupt conduct, and we apply that. Our explanation is clearly documented in that report. It's available for you to make whatever assessment you feel appropriate. If you don't like it, you can move a motion to put a bill to change it. But that's what we apply.
Change your findings.
I'm sorry?
I don't think that's
Thank you, Chief Commissioner.
Okay.
You might just do that.
And by the way, he accepted.
They might do that for Gladys.
And by the way, Mr. Latham, he accepted the findings.
Well,
Thank you, Chief Commissioner. Questions now from Ms. Dickinson.
Thank you, Chair. I've just got a couple of questions, and I know it's very awkward because it's for the terrific people down this end of the table. So, for Ms. Johnson and Ms. Anderson in relation to the Law Enforcement Conduct Commission's functions. I'm just, as I understand it, the court proceedings have now been settled in relation to the Law Enforcement Conduct Commission being able to require materials from police in relation to critical incidences and other matters. Are you satisfied at this point in time as an agency that you can now conduct your investigations or your oversight functions of these particular incidents and investigations with a high degree of confidence and satisfaction?
So you're correct. Thank you, Ms. Higginson. The proceedings have settled. There was an application for special leave to appeal filed at the High Court of Australia. That's now been withdrawn. The Commissioner of Police and the Acting Chief Commissioner, it was me sitting in the role on the day in which a joint protocol was signed. That joint protocol which sets out the arrangements by which the Law Enforcement Conduct Commission will be able to access highly sensitive material held by the New South Wales Police relating to critical incident investigation monitoring functions, and the way in which that material will be provided to us. There were two matters that were the subject of Court of Appeal proceedings. I understand that the documents in relation to both of those matters have now been provided to the Commission. There were another 6 matters where public interest immunity was claimed. Documents have been provided in relation to one of those matters, and we're confident that the balance of the documents in relation to the remaining 5 will be provided shortly. It's really a matter of working out some of the practical access arrangements rather than anything otherwise. So the process of accessing those documents so far has certainly been very cooperative, and we're confident at this stage that that joint protocol is working as we'd anticipated and as it should.
And so what would be the procedure where now, if you had concerns going forward that, you know, that things weren't as forthcoming as they ought to be? Like, what would be that? Clearly this was litigation, it was court proceedings, that was the police exercising some, I don't know, impunity that they don't have to cooperate, or some question. But what would be the process shy of that? What would you have to do if you feel that the police are not cooperating fully in the provision of materials that you need?
So in the area of the critical incident monitoring, which was a narrow part of the Commission's jurisdiction, the joint protocol sets out the appropriate arrangements, but it also sets out a process for escalating any concerns initially via the various levels within the Commission, but ultimately it would be a matter for the Chief Commissioner to speak with the Commissioner of Police and to come to some arrangement in relation to accessing those materials. And the joint protocol, which, as I said, is on our website, makes it clear that public interest immunity does not apply in relation to those documents. But we do acknowledge that the police have understandable concerns about the sensitivity of some of the documents that form part of a critical incident investigation, and we're willing to work with police to make sure that those highly sensitive documents are handled carefully within the Commission and not disclosed outside of the Commission, at least without first giving proper notice to the police.
Do you think, what is the current LECC's capacity to undertake proactive work in oversight of police? And do you feel that you have the resources and capacity to do proactive work?
We certainly do. If you mean by proactive work, we have investigations that we start and commence either on the basis of complaints or on the basis of our own inquiries.
I would consider that more reactive kind of work, really.
We also have a strategic intelligence function that's underway now, which is aimed at identifying matters that are not linked to complaints, but where we're doing a proactive, a sweep, if I can put it that way, of upcoming issues. And we also have our prevention and engagement function, which is very much about looking at broader systemic issues within the police, and that is working well.
Is there is there a way of understanding what that is, or is that more confidential work?
No, the prevention and education function is the function that leads to the publication of a range of reports. So the domestic and family violence complaints report, the report Operation Torpedo in relation to the suspect targeting management plan, our review of the Aboriginal strategic direction. All of those things are under our prevention and education function, and I think it's fairly carefully set out in our annual reports year to year, the kinds of big systemic reports and work that we do as part of that function.
Thank you.
Thank you, Ms. Higgins. Ms. Boyd.
Thank you, Chair. If I could just go back to Operation Eclipse with you, Chief Commissioner. I asked questions at the last estimates about lobbyists and passers in particular. And I just wanted to be clear about what I mean, because being, I guess, an MP in this building, we see a lot of things. And during a sitting week, we have ministers who are here in the building on floors that anyone can access through stairs. And then we have a bunch of people who just have a permanent pass that they can use to come in whenever they like, because they've got sponsored from somebody and we don't know. And there's no transparency over that.
I've got one too.
Right. So whether it's, unions or peak bodies or lobbyists or whatever, they walk around with these black passes and go into people's offices and say hi. Would you expect that be a bit more transparent? And secondly, should ministers really be putting down those interactions they have in the hallways and those casual interactions with lobbyists into their ministerial diaries?
The issue of passes has been raised with me previously. It's not an issue which has been the focus of any of our attention. So I can't really comment to you on terms of the corruption risk. I mean, generally I would think most people would not welcome someone just barging into their door unannounced and coming into their office. And if that arose, I would expect that there'd be some protest somewhere in the building. And generally speaking, all I can say to you is, looking at some of the events that have occurred in local government where you see councillors meeting in cafes and less salubrious environments, pubs and so on, I'd prefer them to be meeting in offices where at least people can see what's happened, and they're actually there's staff and other people around who can assist them. So I think that's an issue.
So when we look at the recommendations in Project Eclipse then, when we talk about there being sort of insufficient transparency around when these meetings are being held.
Well, Eclipse does deal with a broadening of the kind of interactions which should be disclosed, and the persons who are described as lobbyists who should be identified. We haven't got a response to that. You can read the report for yourself, I'm sure you have.
Yes.
If you've got any doubts about any of that. The problem at the moment is that we have these diary disclosures, but I have to be perfectly frank, and I say this both in respect of the current government and the previous government, they're suboptimal.
Yes.
When you have a description of the purpose of the meeting as portfolio matters, it really doesn't tell me anything.
No, exactly.
When the description is purpose of the meeting.
Yeah.
Agreed.
So I think this needs to be dealt with. The object of the disclosure regime should be, together with a documentation regime of the interaction, to enable a party to be able, if necessary, to go and make an application under the government, the GIPA legislation, and get access to the particular record.
Because I was looking at the Premier's diary for this estimates, and everything was either lunch or meet and greet, or something of that nature, which tells me absolutely nothing.
Well, it tells you very little, if anything. Some of them, if it's, I suppose, if you're meeting a consul general who has nothing to do with your portfolio, describing it as meet and greet might be sufficient.
Sure.
But in other circumstances, clearly not so. So this is an issue that we've dealt with in our report. We've also given reference to some examples in other jurisdictions where there's much more comprehensive statements of what occurs and greater transparency. This is, I'm not trying to, I'm very conscious of the fact that there are interactions that may not need disclosure. They're also dealt with in the report, particularly some community organisations that we shouldn't be burdening with the obligation of making detailed bureaucratic disclosures. They're all dealt with in the report. It's a considered report. I don't know that I really need to add to what's in there. It's really a matter for government to respond to it.
Thank you.
Thank you, Chief Commissioner. Mr. Ruff.
Thank you. I might ask a couple of questions to the LEC. Sorry for the awkward angle of the questioning. I wanted to turn to the issue that's been in the media quite a lot the last few weeks about the police commissioner and the large number of bottles of gin that has been gifted to dignitaries or has been asserted in this parliament to members of staff. Has the police minister or any other minister sought your advice on this matter or matters regarding the conduct of the commissioner?
So the commission, as has been announced, did investigate aspects of that issue in terms of an alleged conflict of interest, and a report has been provided to the Minister for Police along with the Commissioner of Police. That report's subject to confidentiality orders made by the Commission, and we haven't had any further correspondence with the Minister of Police.
So you recommended that it be a confidential report?
That was our recommendation and the basis on which it was provided under Section 135 of our Act, yes.
Did the Minister request that it be confidential as well?
We had no, there was a decision made by the Commission.
Right. Before, in terms of the timing in which that Operation Askern was released, was that a decision that you made in terms of when that was released?
So that report had been, so it hasn't been released. It was provided to the Minister for Police and to the Commissioner on the 6th of August. That date had been set by the Commission several weeks prior, taking into account a number of other commitments that the Commissioners and the Commission had, and there was no communication from either the Commissioner of Police or the Minister in relation to the provision of that, or the timing of the provision of that report. That was a decision entirely resting with the Law Enforcement Conduct Commission.
And when you were looking into this matter, were you looking at, to put it crudely, the first 50 bottles of gin, or which was later updated to 100 bottles?
The nature of the Commission's investigation, subject to the confidentiality provisions, the confidentiality orders that were made in relation to that matter. So we've indicated that there was no findings of serious misconduct on the part of the Commissioner of Police, but we've made some recommendations in relation to a refresher of conflict of interest obligations for senior staff of and senior officers of the New South Wales Police Force, but the New South Wales Police Force generally.
Okay, fair enough. I think that the issue for us is, and it's been debated in our chamber in particular, more so than the other place, is that it seemed to be that the Commissioner, when the media story did break, was running with the line of 50 bottles, and then it was later updated and re-clarified, I think 2 or 3 times to be 100. And I was just wondering, I suppose, what if there's any if you've looked at the nature of misstatements that are made by the Commissioner in that regard, or was it just the substantive issue itself?
So our investigation preceded those comments in Parliament and the comments made by the Commissioner. We have not, to my knowledge, received a complaint that there's been misstatements or that the Commissioner of Police has been making misleading statements. We receive hundreds of complaints a week, so I could easily be wrong about that, but not so far as I'm aware. So those comments were made after our report was provided and after our investigation had therefore concluded.
Fair enough. I think the LEC, you would take seriously the issue of misstatements by someone as senior as the police commissioner, for instance.
We always carefully scrutinise any complaints made about the conduct of senior police officers. We carefully scrutinise complaints made about the conduct of any police officers, but clearly, as the Commissioner herself has acknowledged, there are an extra degree of scrutiny and upon her as the leader of that organisation, and the importance of her having integrity.
Held to a higher standard than a rank and file police officer on the beat, so to speak.
The standards are the same, but I think she takes that responsibility as seriously as we do.
Okay, I'll turn to a different matter. It's some time ago now, but the tasering of the elderly woman in the nursing home, Claire Noland, by a police officer. What reform has the LEC undertaken or recommended with relation to weapon regulation and training as a result of that incident?
So that incident's a coronial inquiry and it comes under Part 8 of our Act. We have no powers to investigate that matter until the coronial process has concluded. We are monitoring the critical incident investigation as we do any critical incident investigation. So I don't think I can take that in.
Okay, but you could very well do a review down the track on the use of tasers, for instance. That could be something that you could do post the coronial inquest.
Yes, and post the conclusion of a report being provided by the critical incident investigation, the New South Wales Police Force critical investigation officer. So sometimes that report is actually provided sometimes 12 months after the conclusion of the coronial inquest. It's something we're working on with the police to shorten that time frame, but it would be, I'm not sure where the coronial process is up to, and it may have paused while there are the Supreme Court proceedings on foot, so I expect that would be some period, some years potentially away before the LEC regains a jurisdiction to look at that particular incident.
And is that also the case for the incident of Beau Lamar Condon and the police issued handgun being used for in that incident? I'm sure you're aware of that. Is that a similar? Is the LEC looking at that, or has it looked at that, or is it a similar issue where it's pending a coronial inquest?
So we can't investigate that particular incident or how that officer came to have access to that handgun and how that unfolded. However, the New South Wales Police Commissioner has indicated that the police force, she's requested that there be a review of the way in which firearms are tracked by the police force. We've been briefed by the police force about that review, which is a more general review, albeit triggered by, as I understand it, by that particular event. So the Commission has received a verbal briefing about that review. We've requested some documents to be able to review those ourselves in writing and to reflect on the suggestions, and we received a letter yesterday from the Commissioner of Police indicating that they'd be willing to provide us with those documents provided that we don't disclose them outside of the Commission. That's something we're considering further.
A question that I have, and sort of it's a bit awkward that I'll have to go around and ask each agency individually, so maybe we just go around one by one, is the issue of, and we've just legislated, and Mr. Sistogos, you mentioned it before, the Integrity Agencies Bill in terms of a new process for the funding of the agencies. I just wanted to confirm with each of the agencies that the appropriation for in this budget, that was the appropriation that you requested and was given, allocated to you by the Treasurer. And I don't think this is a Public Service Commission is captured, but Ombudsman, ICAC, Auditor General, etc. So
I might ask Ms. Anderson,
Yeah.
our Chief Executive Officer, to
Thank
answer
you.
for the Commission.
Yeah, so our budget was certainly what we were expecting. We did receive additional funding.
Ms. Anderson, can I just ask you to speak into the microphone too, just so Hansard and people playing at home can hear?
That our budget was what we were expecting, and we received additional funding for some additional positions that we had requested. There was no questions about what we had asked for, so it was all approved.
Okay, thank you. Ombudsman?
Similar position. We made 3 budget bids. Only one of those required an additional appropriation from government that related to our leases up next year, and we will need a new lease. But beyond that, the budget was what we expected it to be.
Okay.
Yes, our funding is what we requested, and that included additional funding to accommodate eventual move to new premises over the next 2 years. So we were very satisfied with funding.
Yeah, Auditor General.
Yes, we're satisfied with the process. We didn't request for any additional funding, but we are satisfied with the framework as recommended by my predecessor. So that's been captured in the process.
And Electoral Commission?
Yeah, thanks for the question. Happy with the process and the Specialist Integrity Agency or unit, which has been established in Treasury. We had really good engagement with that unit over the budget process, which is many months. Disappointed with the outcome. The New South Wales Electoral Commission made 4 submissions for new funding, new policy proposals in the 24-25 budget, one of which was funded. And so first with digital modernisation, we're trying to upgrade our systems. Our core election and corporate systems are rather dated, end of life. They pose significant risks to the delivery of elections in the future. We had scoped up in the previous budget. We had received some funds to scope up a project, to develop a strategy and the like to take the organisation forward. And this leverages a lot on what's happening at the Commonwealth as well through their Project Indigo, where they're updating all their systems. So a lot of lessons were learnt through that process. Put in a detailed business case, and in the 24-25 budget, it was rejected. We also put in a budget submission, new policy proposal to re-baseline our budget. This was consistent with the previous government, Premier Perrottet, to re-baseline the integrity agencies. We've been working for a number of years with Treasury on this, what this looks like. We had undertaken that work in accordance with government requirements and so forth, or what re-baseline should look like. We made quite a substantial bid funding submission to government, and that's to address issues such as WHS, fatigue for our staff, the high-cost employment model. We rely upon external third-party contractors to deliver core services of the New South Wales Electoral Commission at great cost. We were seeking to move away from that. We've got high staff turnover, and between elections, we lose a lot of critical IP. Also, this committee and the JSCAM have asked us around stakeholder engagement. We did have resources built in into that budget rebaseline submission, but ultimately we were not successful in that business case. Thirdly, we put in a submission for technology-assisted voting. This is internet voting to enable us to deliver a solution at the state general election in 27. We always said it was a policy matter for government to decide whether or not to pursue internet voting. We did a request for information to market to see if there were suitable suppliers. There was very limited, 2, and 1 has subsequently gone. We put in a bid to say to government, yep, you can proceed. We can offer the solution in 27, offer the state general election in 27. That funding submission was not funded. We did make a submission for cyber security, and that was through the Digital Restart Fund. We were successful. It was just over $15 million, which is money that's already been hypothecated to the Commission anyway under that fund. So we just put in an application to get it. Again, that's to improve our cyber security defences. We were successful, but I should note that staffing, licensing and maintenance were stripped out of that bid based on advice and put into budget rebaselining. That was rejected. So while we've received money for cyber security to a certain extent, we don't have ongoing staffing, we don't have maintenance, and we don't have licensing into the future. So our ability to deliver what we put up in that business case is now curtailed. We're going to have to rescope and go back to government. We did, I think, just generally, I think I'd make the point that the New South Wales Electoral Commission is now operating outside its risk appetite, and we're not currently funded to address critical risks in staffing, systems and cyber to ensure successful election delivery in the future. I should note, just for completeness, we did put in a PTA, a parameter and technical adjustment. That's where you've got existing funding but you need a little bit more. And that was around the roll and roll products provided to us by the AEC, the Australian Electoral Commission. We were successful there. We were successful also in some of our carry forward bids as well.
So the
implications?
Thank you for all that information. The new bill that has passed this Parliament now, in terms of a more independent approach, if I can put it that way, of funding the agencies, that's now coming into law, but the system was already in place in terms of the way that the process was in place before the law came in, I think, from the 22-23 budgets. You wrote to the Treasurer requesting funds that haven't been allocated, and then the Treasurer, I assume, has written back to you indicating that you haven't been successful in terms of those additional appropriations that you've asked for, and a copy of that would have gone to the JSCAM as well, which was the practice that has been in place for the last couple of budgets. Is that right?
Yeah, so the process has been in place for the integrity agencies to make funding submissions, which is slightly outside the normal budget process for agencies in terms of if there's any limitations and so forth applied to number of submissions and so forth. We're outside, we can always make a submission. So that process has been in place for a period of time. I should note that it's not as simple as providing some correspondence to the Treasury or to the Treasurer or the Premier to ask for funds. The Digital Modernisation Program, which is, we're talking serious dollars, over 10 years it's 323 million. Rebaselining was close on 500 million. So these are substantial bids, and they're supported by comprehensive business cases in all those instances. So I'd just like to, and I should note that we got very good support from Treasury throughout that budget process. So I'd just like to correct that in terms of it's not just the letter.
Yeah.
It is supported, and you go through a process with Treasury where they rigorously go through every little line item in those submissions. So we are still subject, as we should be. It's taxpayers' dollars. Those business cases are heavily scrutinised by Treasury. Every dollar needs to be justified, and we went through that process, and we had good support via Treasury during that process.
And Commissioner, I think I cut you off before. You were going to start talking about the implications of what it means for the Electoral Commission now that those, 4 budget bids were rejected?
Well, the three.
Three of the 4.
Yeah, 3 of the 4 of their new policy proposals. My priority in the organisation is now around the delivery of the local government elections in just over 2 weeks, while we work through the process of the impacts of the funding decisions. However, I will, and we're undertaking a restructure of the agency, I will be forced to exit staff, temporary staff and contract staff who we had hoped and who are performing critical services, not only at election time but outside that as well. We're hoping to convert to ongoing roles. We'll have to leave the organisation, and we will have to shrink to accommodate our reduced budget, our budget envelope. So we're going to see, we've got currently 377 people as of the 30th of June. We've got LEC funding in this budget, which is labour expense cap, which is your staffing item, for about 160 odd staff. We will be able to retain some temporary staff, absolutely, because there is some project funding around, but this will result in a significant reduction in our staffing, which means we will have to look at our service offerings and what we provide into the future. We're also going to have to do that on our systems as well. We're undertaking a comprehensive systems review, and we'll have to pare back our systems. Those systems are delivering elections, because we just, the risks of election delivery failure are heightened as a result of this funding decision.
Shrinking democracy.
Yeah. And we may even have to revert to some manual processes, and that includes the count. I've already advised the government that we won't be able, because of the funding decision, to do certain activities, and that includes logos on ballot papers, for example.
Oh, right. Yeah, that was a recommendation we've had for some time.
Recommendation.
JSCAM, I think.
Yep. Our digital modernisation program was required to enable us to deliver logos on ballot papers. Without that funding, we cannot deliver. So we're comprehensively going through all our service offerings, what we provide to political participants, what we provide to members of the public, and we will have to pare back that offering because we are not funded to deliver.
Thank you. Thank you so much, Commissioner, for that.
Thank you, Commissioner. Just before I turn to Mr. Latham, I've got a couple of questions for the Acting Chief Commissioner of LEC, Ms Johnson. In September 23, you prepared a report review of a sample of New South Wales strip search records 2021-2022. There were some findings in there that I think alarmed a lot of people, in that 65% of records were unclear when it came to strip searches, that only 30% of strip search records reflected adequate consideration of the seriousness and urgency threshold for which officers must meet in order to justify a strip search under the law, and only 27% of strip searches records contained information indicating police followed the rules for protecting privacy and dignity in strip searches. You've made a number of findings and conclusions in that. What has been the response to, if any, to your report from the police and from the government?
So that report related not to strip searches generally, but it was a paper audit of strip searches conducted at a number of identified music festivals.
Yeah, that's
so
right,
it was, I think it's important to clarify, it wasn't a broad audit of police strip search powers generally, but in quite a narrow compass, and reflected concerns that the Commission had identified in earlier reports in relation to the way in which strip searches are conducted at music festivals. Ordinarily, where there is and what we'd identified was that the training that had been developed and the forms that had been developed by the police were both good. The problem was the forms weren't used and the training wasn't completed in general terms. And so my recollection, but I would need to check and take it on notice, is that the police have acknowledged those deficiencies and have agreed to do better. We ordinarily now will put the police response onto our website so that the community can see what the police response to our recommendations is. I presume it's there, Mr Buckingham, and I apologise, I just can't remember, and I'm happy to take that aspect on notice.
As part of that audit of the sample of New South Wales strip searches, you decided not to review body-worn footage from police officers. Why did you do that?
So that was, I mean, effectively a resourcing issue in that, one, it allowed us to turn that review and that report around much more quickly. If you want to get body-worn footage for each matter to see how the strip search is being conducted, then that's it's a much bigger project. It takes a lot more time and a lot longer to report. So we made a strategic choice in collaboration with the New South Wales Police that in this instance we'd do a paper audit, and already that paper audit, as you've indicated, uncovered some significant problems. We were able to identify them relatively quickly. We do have as one of our regular focus areas the way in which strip searches are conducted. So if there are complaints made to either the New South Wales Police or to the Law Enforcement Conduct Commission about strip searches, we would regularly and ordinarily ask for and obtain the body-worn video footage for those strip searches, and we'll review that body-worn video footage either as part of our complaints assessment process or as part of our oversight of any investigation.
So do you have any plans to conduct another audit in the future that's better resourced so that you can ascertain whether or not there's been an improvement in the processes that you've been investigating?
Never say never, but every time we look at strip searches, we're not looking at something else. So I think for the time being, we don't have a project plan to go back and look again at the way in which strip searches are conducted at music festivals. As I said, strip searches and the way in which they're conducted by the New South Wales Police remain always very much on our radar and on the things that we scrutinise. We're aware too of the training and have attended police I've certainly gone to observe the way in which the strip search training has been rolled out. So it's something that we keep an eye on, but we don't currently have a project in place to review that, to repeat that audit at a later stage.
Okay, thank you. Mr Latham.
Yeah, thanks, Chair. To Mr Hasistigos, does ICAC have any concerns or is monitoring the emergence of this unusual, unorthodox process of unsolicited proposals as a new way of doing housing development in Sydney, given that it's quite ripe for favouritism? It takes you out of what the Premier this morning described as jumping through 1,000 hoops in the Planning Act to something that can be quite fast-tracked. In the case of Rosehill Racecourse and the ATC and Steve McMahon, 3 days to get a meeting with the Premier, 6 days to get the Cabinet Office to tell you how to do it, 8 days to meet with the Metro people, and then a very high level of just about all the departmental secretaries on the steering and assessment committee. What's the ICAC view of what could be seen by the government as the solution to housing supply issues in Sydney, but also raise some probity questions?
I'm not going to tell you what matters we are looking at, what matters we're not looking at, but you're perfectly entitled, as is any other citizen, to make a referral to us about any issue that you have of concern. I will hand you down, complimentary, a publication that we issued in 2018 on direct negotiation guidelines for managing risks. That might be of interest to you. Pass it down to Mr Latham. Anyone else wants a copy, it's available on the website.
Thank you.
Hopefully that'll be of interest to you. There's also a publication which the South Australian Independent Commission Against Corruption has published more recently, this year actually, I think, on the same topic. So I refer you to that as well.
Do you think it'd be desirable for these unsolicited proposal guidelines to be legislated, to have a formal statutory standing in New South Wales? I mean, the whole thing, I suppose, going back is very unusual that it came out of some meeting in the Toaster with James Packer and Barry O'Farrell and Alan Jones, and it sort of evolved since then. The Premier's now brought Investment New South Wales into Premier's department, so it looks like unsolicited proposals are very much part of central government. Would it be helpful for these guidelines, which just sit there randomly in the Cabinet Office, to actually be legislated as a process, as we have with the planning laws in New South Wales?
There have been occasions where the Commission has had to examine unsolicited proposals, and we've published some reports on it. And I can draw your attention to those reports if you wish, but it's not a subject that, as far as I'm aware, we've specifically recommended in terms of legislating comprehensive guidelines for unsolicited proposals.
But if it became common now, I asked the Cabinet Secretary Kate Boyd earlier, is there anything stopping a Lend-Lease or a MERVAC from lodging an unsolicited proposal for a major housing development? If this is the new pathway for housing supply in Sydney, and it becomes quite popular in that regard, and if you like, a rival to the traditional methods, the 1,000 hoops of the Planning Act, wouldn't it be, do you think it's desirable at that level to have it legislated? So that there's a clear statutory basis on which these things happen rather than vague guidelines interpreted by some bureaucrats?
I can't comment on the proposal. You've asked me the same question now twice, effectively differently.
Well, I'm just projecting.
It's the same proposition, but can I just say this to you? If you're asking me whether it should be in exceptional circumstances, I would concur.
Right. So you don't think it should become commonplace because it's open to
I don't know.
favouritism like you. Back in the day, I don't want to bring back nightmares for you, but imagine Eddie Obeid in charge of unsolicited proposals.
Well, I don't know. You published an article in 2019 praising Mr Obeid in the Financial Review. I'm not sure if you remember it.
2019, no, I think you're wrong there. But
I've got
Have you got a copy there, Miss?
I do. I do. I thought you might be interested to read it.
Are you tabling that?
No. I'll give it to Mr Latham in praise of Joe and Eddie.
But anyway, unsolicited proposals. I'm sure unsolicited proposals aren't mentioned in the article, and I'm just asking: are they left open to favouritism if they become a source of multiple applications for major housing developments?
Well, I'll give you a look at the article. You can read it for yourself. I don't really wish to. This is not an occasion for me to sledge, and I don't intend to do it. But I've indicated to you what my thoughts are in relation to that subject matter. The Commission's thoughts are in the publication which I've given you.
Yeah, I think
there's
we'll
further material.
Table document. I'd like to.
Well, it's not 2019.
Oh, sorry. When is it?
Well, it's 16 years ago.
Well, you can read it out if you want.
Well, no, I'll have a look at it. I think I said he donated it to a lot of community groups, probably you.
Mr Latham, just provide that
Well,
secretary
I donated
there.
to you too.
No, he hasn't. And he hasn't provided an accurate dating of it. The ICAC Commissioner hasn't provided an accurate dating of it.
Well, I stand corrected, Mr Latham, but I was just interested that you had positive thoughts about Mr Obeid. I didn't, actually, at the time. In fact, I was the one who was responsible for recommending the appointment of Mr Ip.
Mr Hatson, just to clarity, did you table that document?
No, I'll just give it to Mr Latham. I
fair
don't.
enough. All right.
It's not really appropriate that I should table it.
We can Google it.
Mate.
Where are we up to now? I got distracted.
It's me.
Oh, we've got 10 minutes. We've got, sorry.
It's over to us.
Yes, thank you. We'll start with Ms Boyd.
Thank you. Okay, let me come to you, Dr. Phillips, because I was going to come to you anyway to ask you how wonderfully the project for technology-assisted voting was going, assuming that you had been funded. So it comes as a huge surprise after sitting here for the last however many years, 4 years of the previous coalition government failing to fund it, and now finding out that the Labor government has also failed to fund it. You'll probably recall I've been asking about this because it's yet another one of those issues that really disproportionately impact on people with disability. Is there any... I'm a bit sort of astounded, I guess, but if we were to get the money now, say there was to be a turnaround, would it be in time in order to provide online voting in 2027?
No, we don't think so at this time, for a number of reasons. One of which is the market has changed.
Right.
While we went out for an expression of interest, request for information process, I think we got 7 responses. 2 of those we thought had potential.
Yep.
As I mentioned before, one of those companies now is in receivership or is now no longer probably able to provide the services. So it's down to 1. And so, well, there is still 1, I suppose, and there may be new entrants since that time. So there's market conditions, and 2, it takes time. It takes time to roll that, and also we made a commitment to the blind, low vision community in particular that we would work with them on this technology. We would co-design this thing with them to ensure they got out of it what they were seeking. They are the key group that arose from my predecessor's review into technology assisted voting. It was going to be a very narrowly defined offering for SGE 27, blind, low vision electors. It takes time to test. It takes time to implement, to design. Given the market conditions, given the time, and most importantly, given the fact that we've got 0 budget, it is impossible to deliver an internet solution for the state general election in 27. Even, I'm happy to stand corrected by my officers, but even if we were to be given money today, I do not believe that we could deliver a solution for the state general election in 27.
Wow. So when you first asked for this money, when was that, of the Labor government, not previously?
In the 2024-25 budget. So in the recent budget round, so submission would have gone in roughly February.
So if you'd have had the money in the budget when it came out
1
in
July.
June,
Yeah, it was 1 July.
then you could have done this by 2027?
Yeah, I think it still would have been difficult given changes in the market. I still think it would have been difficult, but we could have done it based on advice at the time. But that's the position we're in. We always maintained that it was a policy decision for government.
Yeah.
We gave them an option throughout the budget process. Decisions have been made due to the tight fiscal environment not to fund that particular initiative.
I'm keeping a tally of all the ways that the Labor government has failed people with disability, so I'll add this one to it. Can I ask you about the shrinking of staff and that sort of needing to re-baseline the budget? Did you say that that's going to potentially result in a manual count?
No, so what we're so thanks for the question. My apologies to jump in. Do you
please.
Yeah. So what we need to do is we need to look across our systems. The count system now is a computer system, and it has been in place for a number of years. We need to work out, particularly for the upper house, we need to work out if we've got funding available and resources that we could dedicate to it to roll it out, and that appropriate measures such as cybersecurity protections and others are in place for us to use that system. We have not come to a decision at this particular point in time. We're going through that work across all our systems, both core election systems as well as corporate systems. So I'm not saying that we can't at this time. I'm just saying we need to look at all. We need to retire some systems that we can no longer afford to provide, and there will be, whether it be in corporate systems or election systems, we may have to revert to manual processes, but it's too early to determine that at this time.
And all the discussions we had about outreach that Victoria do and everyone else manages to do, that's just not on the horizon at all now about...
We have one officer on an ongoing basis that provides outreach to stakeholders.
Versus
who is doing, I should give him praise. He's doing an amazing job during the local government elections in terms of his engagement with those communities who face additional barriers to democracy.
There just needs to be 11 more of him.
Yeah, much to the Victorians, there should be 11 more, or we've got a package that we presented, which wasn't funded. And we can do more, and we should be doing more in that space, but we are not funded to do so at this time.
Thank you,
Yeah,
Commissioner.
but can I just add, my apologies, if you, Chair?
Sure.
Yeah. Just note, there is a JSCAM process, the Joint Standing Committee on Electoral Matters, looking at voter engagement, participation and integrity. I think that's a wonderful process. We will be a wonderful review, and we will be looking at that review to re-engage on these matters around stakeholder and so forth, but also to re-prosecute our claims for additional funding, because without investment in the fundamentals of this institution and democracy, staffing, systems, cyber, for example, then, I'll leave it with you. Can I just make just one statement of fact? 38% of our workforce is ongoing. That's it.
Thank you.
Thank you, Commissioner. Ms Higginson.
Thank you. I'm just heading back to Ms Johnson and Ms Anderson, the LEC there. I'm just trying to get a grasp on the amount of complaints you receive and the percentage of those per annum that you would take on as matters that you investigate. If you can give us a kind of rough of what that looks like.
So I think when we've done these figures before, it comes through at about 1% of complaints we take on as our own investigations. Last financial year we assessed 5,755 complaints, and we have about 50-ish investigations on hand at any one point in time, and that number sort of fluctuates depending on where things are.
Thank you. And so what is the kind of, what is the primary reason that you wouldn't be taking a matter further into investigation or within your capacity? What's the primary, or even if there's a couple of grouping reasons?
So the legislation provides that police should have the primary responsibility for managing misconduct. Police and the Crime Commission, obviously, should have the primary responsibility for managing misconduct within their organisations. And so primarily we look to see if it's the complaint raises issues that can be handled appropriately by the New South Wales Police.
So on that, are you suggesting that the bulk of the matters, the 5,000 odd that you don't investigate or take further, you would refer back to police?
Yes. Yes. So no complaint reaches a dead end, or very few, unless the complainant specifically says that they don't want it referred back to police, or we receive a small portion of complaints that where we refer them for information only, where the complaint is very difficult to understand what the complaint's about. But yes, otherwise the complaints come to the Law Enforcement Conduct Commission, either directly from the public, or we oversee complaints that have been made to police. We will refer those complaints to police. We check to see the way in which police have triaged the complaints. We make sure that triage has been completed properly. We assess the police response, if they're going to investigate it or not. If we disagree with their approach, and if we think something should be investigated that police have said they're not going to investigate, at that point we have the power to direct police to investigate a matter, and we will then oversee the outcome of that investigation. So it's not a matter of sending a complaint to police and just saying, well, job done. Far from it. We maintain an active role in overseeing the way in which those complaints are handled. Coming back to your other question, so what we might investigate. We also have an eye perhaps to particular systemic issues, but we can also pick up complaints that have not been investigated by police to our satisfaction. And the matter involving Police Officer Daniel Keneally was one of those, where the matter had been referred to the police. The police had investigated. The LEC was overseeing that investigation, and then wasn't comfortable with the way the investigation was being handled. Picked it up and did the investigation ourselves, and then prosecution proceedings flowed from that.
Does it concern you at all that the police spent more dollars, literally losing in court proceedings and settling misconduct cases than your entire budget? Like, is there and I'm not trying to be smart about it at all. I'm sort of coming from that public confidence perspective. And yes, there's a lot of police, but in terms of the amount of complaints that the LEC doesn't kind of take to another matter.
At the moment, I am comfortable with the number of investigations that we have on foot. There aren't matters where we say we don't have the resources to investigate those. It's a question of under the statutory scheme, the police need to have responsibility for taking on, for owning their own conduct, and that was a recommendation from the Wood Royal Commission. Who said if you palm it off to a third party, they won't own it. They need to look at themselves in a mirror, and I think, generally speaking, that system works effectively.
So you think that recommendation from the Wood Inquiry is still the most contemporary kind of best practice for policing accountability systems?
I think it is. There's always room to sort of tweak at the edges, but I think there are real risks with saying a third party, an independent third party, ought to always investigate everything. I think there are real benefits with police investigating their own, looking frankly at the way at the conduct that's alleged to be misconduct, and making an assessment of whether this was right. Police will, I think, hear criticism and receive criticism better if it comes from someone wearing a blue uniform than if it comes from someone external. And I think that's an important part of the process. I think where the LEC can and does add value is in making sure that that investigation is well conducted, thoroughly conducted, and addresses all the right issues.
Thank you very much, Chief Commissioner. Unfortunately, that concludes our allocation of time for questions today. Thank you all for your
Could I
attendance.
just clarify a few minutes?
Yes, certainly.
Very quickly, I mentioned 5 reports when the Commissioners commenced. We commenced in 2012, by the way. I think I may have misspoken about the date. 2012, August and sorry, 2022. 2022, not 2012. There were 5 reports. They were Skyline, Tolosa, Galley, Paragon and Keppel, and we got all of those done within that timeline that I mentioned earlier. I also mentioned 20 legal staff. The number of staff in the legal division is actually 14. There are other lawyers, but they're not in the legal division, so associates, brief handlers and some people in assessments. So I just mentioned those numbers.
Thank you, Chief Commissioner. Thank you all for your time today. The Secretariat will be in contact with you regarding any questions or matters taken on notice. Again, good afternoon, good evening. Thank you for your time and thank you for the work you do serving the people of New South Wales.